So, camera. Where's my menu at? Check 1, 2. Why don't I see the I don't get it. Okay. You're up. So, Bitfire Firebridge. That is your link. If for some reason something would close, you would get shut down, something, whatever. If you have to reconnect, what you're going to do is all of these cables are going to be connected. You're going to click on that link and click start, just like we're doing a live shot for Carolina Week or Sports Extra or something. If you don't have any questions.
If in any event that link that you sent us or sent me on the phone,
that's the same thing.
Okay.
That's the same. Yeah. Okay, so I need to call these people.
Camera shots, you select when in doubt, go live. Please, like, you can see camera shots, speaking yourself, and then basically who's talking for a while. Just go watch.
I'm going to check on the transmission, make sure you're seeing and hearing us on your end. This link we have up for the FALR guest tour. Yes. Well, no, I'm calling to check on the YouTube stream right now, but you do have that up on YouTube, in fact, right? Okay. That's what I thought. I'm going to call them right now. They haven't verified with me, but I wanted to just make sure you're seeing us there, so they should be seeing us. Okay, thank you very much. Let's go ahead.
Is he what this moves to right now? Here, do you want the wheel?
I'll take that with me. Yeah. I'll take that with me since y'all don't need it. I would take those bags, see if they'll fit up underneath there, because that backpack is yours too, so you can load the laptop and stuff in it. Try to keep the floors. I'd lift that, what you call it up. I'm obsessive over trip hazards because my old TV station, there was a couple different times where we got sued over trips. Yes. Yeah. And it was always photogs on a live shot, leaving stuff out and people trip over it. Had a lady break a tooth one time.
Was it just out? Or like, were they just not looking?
So they had stuff sitting on the sidewalk, and the lady wasn't paying attention, you know. And then when you see a camera crew out, you tend to focus on that and nothing else. And then she tripped over something that they had said. So the only thing I have not confirmed is that they in fact see it on YouTube. I don't have the login. I can't confirm information for that, but I just spoke to Bitfire. Bitfire confirmed that they see us and hear us, and that they are sending it to YouTube. So in fact, it should all be working. I just don't. I hate to leave y'all without knowing that it's right.
And should we see when they start speaking, should we see audio levels?
Let me look at this some more because I want to figure out why it's not displaying the level it needs. That's being weird because you should be seeing all kinds of information there, but somehow that has gotten turned off, and I don't know where that's at. So I would have thought that it would have been in the LCD viewfinder, and then. Grid marker. Check me if I'm crazy, but that says audio meter turned on. We're on the display settings. All of these features are turned on. Here. Okay, so if that gets turned off, there's a display button right here that turns all of that to different modes. Yeah. So yeah, that leave it like that, and you should be good. That's so weird. Okay, another thing to be aware of. Since you're using internal, yes, anything you say.
I was going to try to get something to eat or something.
So that's even more of a reason for y'all to occupy this space.
Can't wait for this to be on the
Please don't say anything.
Can you just write my sources? No, he loves pulling
We're doing, doing live feed.
Yeah, we're doing the live stream. You're doing photography. Yeah. I thought I saw you sitting out there in the lobby at first. Yeah.
So it's too early, like 7:30.
Oh yeah. I parked at 7:30 and walked over, and it's like I'm about to speak here.
No one's here.
Yeah. That's the way it goes. So yeah, these are two of our students from the J school. They'll be here for the remainder of it. I'm the engineer. So get it started.
I'm really sorry about that.
It's just like there's nothing. There's no it is She was alive.
He said these.
Our two people are going to occupy these two chairs right here.
And if you need other chairs or anything else, let me know. I can bring chairs. If you need a dedicated table for your stuff, let me know.
It would keep us from being in these chairs. If you could have something in it. What we were going to do is we were going to try to have this chairs.
Why don't you, let's start you off there. If they feel like they need those chairs, let me know. We'll get you a dedicated table and you can have it. Okay, does that work? Perfect. Okay.
Hey, Jack. I was actually just emailing you. Just found out that they there used to be like when they rebuilt so what we are going to do is use the built-in microphone on this here. Our people are going to occupy this. Wanted you to know as well. So that's one of the things. The other thing is, if I have the credentials, I love to respond to you. I mean, someone's been responding. So the way this is set up, we use the service to get out of this laptop, and that's what you see on the laptop is what we're sending the service right now, and they are connected to your YouTube stream feed. So if you log in, it's like, if it's not there, I would be very shocked. Yes. Crazy. Yes, let's do it now.
One to control the slideshow where she can work with clicker, but also having a laptop in front of her so she can roll.
I have my own.
Okay. Yeah.
So
Yeah. Jack, if you got something. Right here.
Not having to do it on
Yep. So
so how do I, when you give it, like, send it to someone, or like, because if I think of clicker.
Oh, okay. Yeah, what is that? Oh, I don't have an HDMI. Maybe I would say. An adapter, yeah, that's sure. Pass it around.
Right. Worst case scenario.
Yeah, I was planning to have like a laptop on my computer. Oh, they're on.
Unwinding. Yeah, that's what I'm like.
Morning, I just want to see, is everything going well? You have a professional job. It's not village sheep. I can check Okay, cool. I'm going to check it out. All right.
Okay, so we'll check it out.
How we looking?
Looking good.
Bring all ready to go.
Just all good stuff.
That would be a jack.
Okay.
Yeah. We've got the feed up, but I don't know if they put it live on YouTube.
Okay.
That would be. And so I just leveled and raised. I'm super
So like 6:30, but
raised it up really high. So people, but you can hopefully still reach those controls right now.
back to sleep. 7:15.
So is there anything we can do to help you with this sound issue?
Oh, we don't have a sound issue. The issue we have is they used to have the
Like, we
ability
have a
to.
sound board you can plug into.
Yeah, exactly. No, it's better to have us back here so that you're getting the shot of the speaker. If we get closer, then we're actually getting underneath the speakers.
Do you feel confident that
It's a shotgun mic. I mean, it's what you would use if you didn't have direct audio.
so it's okay?
Yeah. It'll pick it up as soon as it can.
Is there anything that
Outside of giving me house audio, which is really easy. I wish I could move here
All right, good morning, everybody. If you're able to hear me, we're about to get started. All right, good morning, everyone. On behalf of the First Amendment Law Review and the University of North Carolina School of Law, we welcome you to the 2024 First Amendment Law Review Volume 23 Symposium. My name is Benjamin Craig. I'm the editor-in-chief of FALR. It's a pleasure to have you all here. I'm so grateful to have so many faces here in the audience today, as well as several of you that participated in a live broadcast that's going to be coinciding with this event. We're going to get started right away. Chancellor Roberts, who is here, has graciously offered to open up our ceremony today. He's got a meeting to run off to, so we're going to turn him over to him in a second. But just wanted to additionally recognize Peter Hans will be with us later, the UNC System President, as well as Chancellor Roberts, and then Dean Mack and Dean Brinkley. We will begin our symposium this morning by hearing brief opening remarks from Chancellor Roberts. We extend our gratitude towards him for being willing to give up some of his time despite that it is scheduled to speak to us. As a way of introduction, Chancellor Lee H. Roberts was named the 13th Chancellor of the University of North Carolina at Chapel Hill on August 9, 2024, after serving as the interim Chancellor. Before that, he was the co-founder and managing partner of Sharpview Capital. In a public service capacity, Chancellor Roberts has served as the State Budget Director under Governor Pat McCrory from 2014 to 2016, and as a member of the UNC System Board of Governors and chair of its Budget Committee. For the last 5 years, he has taught budgeting at Duke University Stanford School of Public Policy. He has also served North Carolina through his position on the State Board of Community Colleges, North Carolina's Banking Commission, the Board of Visitors at the Stanford School, and the Golden Leaf Foundation. So, ladies and gentlemen, please welcome to the stage, Chancellor Roberts.
Good morning. Thank you for having me here. Even though I started as interim in January and became permanent in August. I've done multiple events in this room. And I always consider it a success if nobody took down these steps. So be careful. Welcome to the First Amendment Law Review Symposium. Thank you for lending your time and your expertise to a topic that couldn't be more important for our university and for our country more broadly. First Amendment's always been a contentious topic. I said to somebody recently, the Supreme Court has been trying to define the precise contours of the First Amendment for over 230 years, and it's still a work in progress. Our era has proven especially lively in its debate over free speech, free inquiry, and the role of higher education in a free society, and there are obviously plenty of reasons for that. We have a closely divided political landscape. New technologies have rapidly changed information access, and growth of higher education to welcome far more students and far more voices than ever before. But what hasn't changed is the crucial importance of what you're all here to discuss: how to maintain our universities as the quintessential marketplace of ideas and fulfill our mission of pursuing knowledge and seeking truth. The great strength of a public university like ours is that we have the deep expertise to tackle the challenging topics and current issues faced by our society. Protecting free expression is essential to solving problems. Every day on this campus, across this campus, we're having classroom discussions, conducting research, and offering expertise to hopefully elevate public discourse. Education has always been essential to an open society, and we can only deliver an excellent education if our students and our scholars can exercise their curiosity, follow their conscience without fear. In Carolina, we defend that freedom as a profound foundational responsibility. I'm grateful to all of you for gathering in exactly that spirit. I'm grateful that you'll be able to hear from my boss, Assistant President Peter Holmes, who has thought a lot about these issues and with whom I work closely on this topic, among many others. Best wishes for a successful conference. Thank you very much again for having me here. Have a good day.
Thank you, Chancellor Roberts. My name is Jack Denton, and I serve as the Symposium Editor for the First Amendment Law Review. I will also be your MC today. To begin, I would like to note that each panel will have an audience Q&A. There are pens and paper on the tables for you to write questions on, and we have several baskets right across the room where you can submit them. Please note which panel the question that you are writing the question about is for, and make sure it's submitted about a half an hour before that panel ends. Additionally, if you are here seeking CLE credits, please make sure we have your name recorded at the registration table. If you need to leave early, we also have partial CLE credit forms available at that table as well. It is now my privilege to introduce our Volume 23 keynote speaker, Mary Rose Papandrea. Professor Papandrea is the Samuel Ash Distinguished Professor of Constitutional Law at the University of North Carolina School of Law. After graduating from Yale College and the University of Chicago Law School, Papandrea worked for U.S. Supreme Court Justice David H. Souter and practiced law for several years at Williams & Connolly in Washington, D.C., where she specialized in First Amendment and media law litigation. At UNC, Professor Papandrea teaches civil procedure, constitutional law, and an upper-level course about free speech issues in education. She served as the law school's Associate Dean for Academic Affairs for 5 years, from 2021 to 22, and she also led the university's strategic initiative to promote democracy between districts. She also serves as the First Amendment Law Review Faculty Symposium Advisor, and she has published widely on a range of First Amendment issues, including free speech in schools and government employment. Her most recent article, Law Students, Professionalism, and the First Amendment, was just published in the Stanford Law Review. Please join me in welcoming to the stage Professor Mary Rose Papandrea.
Well, thank you so much, Jack, for that introduction. Before I begin, I do want to thank Jack and Benjamin and all of the First Amendment Law Review staff members who have made this event so amazing. I mean, just looking out and seeing all of the attendees, having dinner last night with our extraordinary guests, we couldn't have done it without dedication for several months, over a year really, since the last symposium, and to put this together. So thank you very much for your hard work. I also wanted to thank our symposium speakers for coming today. I really enjoyed the conversations we've had so far, and I'm very excited about the panels that we will have today. Before I begin, I do want to add at the outset that I'm very sorry Jeffrey Stone, who is the planned keynote speaker, is not here. He is a giant in this area. He is irreplaceable. But as they say, when life gives you lemons, make lemonade. And so I'm going to take advantage of this opportunity this unexpected opportunity to share my own thoughts on some of the issues we face today in the area of universities and free speech. The free speech issues facing universities are many and complex. Since October 7th last year, much of our attention has been focused on college protests and the increased interest in institutional neutrality. There are many, many more issues facing us in this space. Just to take a few examples, we have ongoing litigation challenging Florida's anti-woke legislation. We have Amy Waxman's controversial statements in and out of the classroom. It's just subjected her to punishment. We have ongoing litigation about whether professors can refuse to use students' preferred pronouns as a matter of academic freedom. I also want to make clear, as is obvious to all of you, that UNC is a particularly appropriate place to be having these conversations. Historically, I refer to the 1960s North Carolina speaker ban law, which prohibited alleged communists from speaking at public colleges and universities here in the state. More recently, there's a long list of academic freedom and First Amendment issues that have come up. It would take all of my allotted time to go through them, so I won't, but I'll just mention the botched hiring of Nicole Hannah-Jones, and more recently, the recording of a business school professor's classes without his knowledge. So the rest of my remarks, I'm going to highlight a few challenges that are facing us, those of us who care about these issues. The constitutional protections for academic freedom and the freedom of speech more generally at public universities is much less clear than one might expect, given how important these protections are to the freedom of thought and, more importantly, to an informed democracy. And some of the relevant law that we do have offers inadequate protections. I just want to start briefly with some basics about the First Amendment. This is primarily for those of you in the audience who may not have a background in the First Amendment. The First Amendment does not provide absolute protection for all speech, but these protections are robust. We have some carefully defined categories of unprotected expression, like incitement, true threats, and defamation, and the university does not have to protect this speech. We allow time, place, and manner restrictions to serve important government issues. Interests, as long as those interests are not designed to suppress speech and there are adequate alternatives for discourse. And universities can also take advantage of these time, place, and manner restrictions. And we will have, I expect, quite a spirited discussion of time, place, and manners on our first panel today. But one thing the First Amendment, the jurisprudence from this court in the First Amendment makes very clear is that the government cannot regulate speech because it is offensive. We do not have a carve-out for hate speech. Profanity and lewd expression are protected. False speech is protected, with some exceptions, of course, for defamation and perjury. The foundational principle for our First Amendment jurisprudence comes from my favorite case, New York Times v. Sullivan. As where the court has said, and this language has been repeated many times, the First Amendment reflects a profound national commitment to the principle that the debate on public issues should be uninhibited, robust, and wide open. The primary theory animating the court's jurisprudence is the marketplace of ideas. It is not, as Justice Thomas asserted in his majority opinion in Bruin, text history and tradition. We see the marketplace of theory underscoring so many of the Supreme Court's First Amendment decisions, from its public forum doctrines to campaign finance. Now, the marketplace of ideas theory has its flaws. We clearly do not have an efficient, self-correcting marketplace of ideas, but the concept of the marketplace of ideas has many strengths, particularly if you think of the marketplace of ideas as encompassing the checking value of the First Amendment and a general sense that we do not trust government intervention. As Justice Souter said in Denver area, adherence to the principles of the marketplace of ideas keeps the starch in the standards for moments when the daily politics cries loudest for limiting what may be said. This brings us to our first challenge. We just heard Chancellor Roberts refer to universities as the quintessential marketplace of ideas. But it would be a mistake to assume that the theory applies perfectly in university context. Universities in many ways are not the town square. And nowadays we see many people arguing that we should affirmatively reject the marketplace of ideas theory in the university context and instead embrace and formulate a very institution-specific theory of approach to First Amendment questions that would allow universities to regulate speech in ways that are appropriate for its educational mission. As a starting point, most agree that a true marketplace of ideas would undermine the very function of universities. I'll start with the classroom. The classroom is not town square. It is not even a non-public forum. Viewpoint-based restrictions are permitted. Compelled speech is tolerated and indeed essential, a point all too obvious to the students preparing for their fall exams, where they will be compelled to provide answers and make arguments they perhaps would prefer not to make. Generally, in the classroom space, the professor's pedagogical choices will trump a student's First Amendment rights, subject to a few meaningful limits. While it might seem that the professor has all the power, the full marketplace of ideas rules of the town square don't apply to a professor either. Professors must teach the subjects they are asked to teach, and their teaching must be competent and germane to the subject area. The full conception of marketplace of ideas does not apply to research either, at least not if a professor wants to be hired and be promoted and tenured. Professors are hired and evaluated on the content of their scholarship all the time. Professors do not, in fact, have the full freedom to make any arguments that they want. Another way the universities are not the town square is that universities are required to prohibit discrimination that's encompassed in Title VI and Title IX. These concepts are foreign to the general marketplace of ideas. This brings us to a second challenge, that the relevant First Amendment frameworks that we have governing student speech and professors is deeply uncertain and highly problematic. I'm going to start with professors at public universities. The current framework for government employees, just generally, is a hot mess, and particularly as applied to the academic environment. The rights of professors vary depending on which box you put the professor's expression in, and policing these boundaries is a super difficult task. In 2006, in Garcetti versus Travalis, the court said that expression made is part of a government employee's job duties. This is not a professor or university case, but more generally, government employees' job duties expression is entitled to no First Amendment protection. This decision was animated by the court's developing government speech doctrine. In this case, the court specifically reserved judgment on whether this rule, the Garcetti rule, applies to professors' teaching and research. After all, allowing the government to have absolute control over professors' research and what they teach would have a dramatic chilling effect on the production of knowledge and critical thinking. But Garcetti itself was problematic. It involved an attorney. Many of you attorneys, probably most of you, maybe all of you, and they were bound by the rules of professional responsibility. This decision doesn't make a whole lot of sense in that context. And it has been devastating in the K-12 context. Teachers once governed by the Hazelwood standard, which required regulations of their speech to serve a legitimate pedagogical purpose, often little protection, but it was something. Garcetti takes away even this. I think this is highly problematic, and scholars in this room should condemn that. We should not throw the K through 12 teachers under the bus as we move forward. Lower courts disagree about whether to honor this academic freedom carve-out from Garcetti. The court simply said we won't decide it. And of course, what the scope of that carve-out is. Some of these questions specifically come up in determining the protections for professors' extramural or intramural speech, and whether that can fall within the carve-out of Garcetti. For example, professors at the law school frequently write op-eds, field press calls, go before Congress, see Professor Bearhart in the audience, and make other public statements outside the university community. Are these statements part of a professor's job? We certainly, I should say, as a law professor, it seems like we're encouraged to do that. So it's not entirely clear whether those are or aren't part of our job responsibilities and academic freedom. Intramural speech is another problematic area. The possible carve-out from Garcetti, the language of itself specifically mentions faculty teaching and research. It does not refer to statements made in the context of faculty governance. And if so, these intramural speech, a little bit like orphananity, it's so important to faculty governance, but at the same time, it's not entirely based on academic expertise that forms the basis for academic freedom in the context of teaching and research. We have two other important decisions in the government speech arena. In Keynote, the court established a threshold test that speech must be a matter of public concern if a government employee is entitled to protection. This is not the same public concern inquiry we see elsewhere in the First Amendment doctrine. It's a much more limited version intended to avoid the constitutionalization of employee grievances. This has led some lower courts who want to protect a teacher or professor's speech, outside of government employee speech more generally, to twist this concept so that the speech can fit within that requirement. And so in some of the K through 12 contexts, we see government employees facing employment consequences for engaging in artistic endeavors or other more private speech that is not a matter of public concern. Because if it's not a matter of public concern, it just falls out and you get no First Amendment protection at all. In the context of academia, lower courts disagree whether academic research or teaching is a matter of public concern. The audience for their teaching and research is not a public one often, and it may not be a topic that generates widespread public interest. Sure, we might be able to twist the concept of public concern to argue that all intellectual inquiries are a matter of public concern. I mean, it has a soaring ring to it. I like it, but it's really not true to the language of that opinion. We saw the Sixth Circuit hold in Merriweather that a professor refusing to use a student's preferred pronouns as a matter of public concern. This was also a twist on that doctrine. Intramural speech likely falls this speech. This is speech about faculty governance. And this, indeed, as I mentioned, what the court was motivated by in embracing public concern was to avoid constitutionalizing workplace grievances. The last test that's very relevant in this space is the Pickering test. The court held in this case that government could not condition employment on the relinquishment of free speech rights. So in that way, it's a wonderful decision because before this time, government employee speech had no protection. And in this decision, we do see the marketplace of ideas theory peeking out, which is that government employees often have particularly valuable contributions to make to the public debate. However, at the same time, the court recognized that government employees, that government employers often have very important and weighty interests for wanting to regulate the speech of their employees. So we have a balancing test that the court must apply to weigh the employee's interest in the speech against the employer's interest in regulating that expression. Balancing tests are inherently not protective of free speech. The government does not have to show a compelling interest, or that there are no less restrictive means of achieving that interest. There is no presumption in favor of protecting the employee's speech. It remains entirely unclear whether a hostile reaction to the employee's speech can outweigh the public's reaction. The AAPP's guidance suggests that extramural speech should be protected, but that's too limited unless it shows unfitness for the job. I mean, this is a useful limitation that can protect the worst abuses, but unfitness itself is a very malleable context. What if the professor embraces an unpopular view on any number of hot-button social or political topics? Many would say that professors exercising their right to speak as citizens should have the right to engage in public debate, but as soon as those statements call into question the matter of equality or civil rights, you will typically see concerns from all sorts of community members, faculty, students, donors, parents, alumni, the legislature, the board of trustees, I could go on, and that this person cannot be trusted in the classroom and should be removed. The next challenge we see comes in student speech context. We see the application of K through 12 cases in the higher education context, from Tinker to McEnroe, or maybe I'll call it BL because I'm still trying to figure out how to pronounce my favorite case word. I'm saying that ironically, McEnroe. So BL. In Healy v. James, which was a university speech case, the court vacillated between invoking traditional First Amendment doctrinal rules, such as the heavy presumption against prior restraints, and allowing the school some leeway to regulate student speech in keeping with, this is a quote from Tinker, the special characteristics of the school environment. Since that time, since Healy, which was in the early 70s, we have frequently seen lower courts embracing Tinker and other K through 12 speech cases to evaluate higher education speech. I don't blame the lower courts too much. They're trying to do their best, and there aren't a lot of cases involving student speech in the university context coming from the Supreme Court. But there are very good reasons to question the application of K through 12 cases in the higher education context. Students are not compelled to attend the university. College students are not minors, and they can vote. They are not subject to parental control, and the doctrine of in loco parentis has been roundly rejected. But again, there seems to be very little else to guide the lower courts, and so they frequently look to these decisions. This is highly problematic, and I just want to focus on Tinker for a moment. The Tinker test Tinker's the black armband case. You might know about it, where some children wore a black armband to school to protest the Vietnam War, and the court held that students do have free speech rights, and but then basically imposed a balancing test of sorts, saying that the schools are permitted to restrict speech that they reasonably predict will cause a substantial disruption or invade the rights of others. So if lower courts fully embrace the way Tinker has been interpreted in the lower courts, that would allow universities to restrict a whole lot of student speech. So for example, in the K through 12 context, schools have been permitted to restrict speech whenever they anticipate there might be some disruption. And then the courts give deference to that prediction. And so you can see, I hope, how that might be particularly dangerous in the university context to give that kind of disruption. The other highly problematic thing that we see in these K through 12 cases is that lower courts frequently credit hostile audience reaction as a substantial disruption that can meet this Tinker standard. This is very problematic. The hostile reaction often comes when you have someone engaging in minority speech, or I should say unpopular expression. And I do want to raise a flag of concern. Recently, First Circuit decision this summer and others trying to give more teeth to that second part of the Tinker test that allows the school to regulate speech that invades the rights of others. This is a very amorphous test, and it's not entirely clear what that means. If it's limited to legal rights of a student, perhaps the right of the student to be free of defamation or physical attack. In some of the early cases on which Tinker perhaps relied on involved pinning civil rights pins on students, and that might be what the court meant by invading the rights of others, like physically attacking the students. Another case that is, the courts have resisted, but it does pop up from time to time, is Bethel v. Frazier, which allows K-12 schools to prohibit lewd, profane, and offensive speech. Even the Supreme Court recognizes it doesn't quite know the theory animating this case, but we do see it used to regulate bad words and other offensive speech. This idea pops up in a Second Circuit case where a UConn student who's a soccer player in celebration, and perhaps she just kind of lost her mind at the moment. She in victory, she gave the finger to the ESPN camera. This did not go over well, as you might imagine, and the lower court said that Frazier could be used to restrict her speech. Oh my Lord. So the Second Circuit did not embrace that specifically, just left it open. I hope all of you are frightened by this idea that schools could just to regulate profanity, swear words that students use, even if they are student athletes. I don't think anyone in the symposium today is addressing the rights of student athletes, but I'm deeply concerned that we throw them under the bus as well and say, you have the right to be an athlete, so if you're going to represent the school, we will hold you to higher standards. I think that's very problematic. I'll skip Morse and Hazelwood just for the sake of time and to get to BL versus McElroy. This was the case where a high school student who did not make the cheerleading squad went to the Cocoa Hut with a friend and posted on Snapchat something that many of us may feel on a daily basis. She said, "Fuck everything, fuck cheer." And sorry, it's a First Amendment conference. I don't use the actual words. And in a remarkable decision authored by Justice Breyer and joined by everyone on the court except Justice Thomas, the court embraced a leeway test that essentially says that schools can regulate the off-campus speech, and they're no longer using that as a strictly geographic term, but the idea that speech that's not part of a school activity or otherwise supervised by the school can be regulated under the Tinker standard. I hope you remember just a few minutes ago I told you how problematic that Tinker standard is, particularly if it's used to its full invasion of the rights of others and allowing reasonable prediction of substantial disruption. And so this standard, we see Justice Alito in a concurring opinion specifically saying, I'm not sure that this standard should apply to college students, but I don't know what's happening. Okay, that's nice. But the court itself does not, the majority opinion does not specifically reserve judgment on college students. And so we see this case now being used in the college context. So I guess this brings me to my third challenge we're facing, which is, to be honest, there's a lot of leeway for university officials to regulate speech on campus. The frameworks are very uncertain right now. And so the real question for universities is whether to use this leeway. Many questions, in addition, that we're facing in this space are not First Amendment questions at all. They are actually more institutional leadership questions. Many of the most difficult questions are ones that I can't answer. I've got phone calls all last year. Can a school do this? Can a school do that? Like, I'm a First Amendment expert, and that is the limit of my authority. Do I think it's a good idea? I don't know. I'm not sure I even want to say one way or the other because it's just not my area of expertise. First Amendment experts largely agree there are limits to student free speech rights on campus, but we disagree on what those limits might be. There are some concerns that we'll hear in our first panel today that universities are increasingly using time, place, and manner regulations to make it harder for free speech to flourish. Some universities have allowed students to maintain in campus that violate school rules and to occupy administrative buildings for some time. They don't have to do that. Violations of these school rules are not protected under the First Amendment. And in some of these, the protests have led to property damage or violence. How much does a school have to tolerate? How much should a school tolerate? These are not First Amendment questions. The universities are not required to tolerate the expression. The question is for the university leaders on what expression they should tolerate. I might also add, I've been speaking mostly of public universities, but private universities generally have committed themselves voluntarily to the principles of the First Amendment. And now we see some debate among private universities and scholars of whether they should continue to embrace First Amendment principles. And indeed, in the private university context, we see people arguing that educational diversity might be a positive thing. This is very concerning, but something to watch. I would argue that schools also should consider protecting more speech than they have to under the First Amendment. For example, under that Mahanoy Doctrine, and I should have mentioned a growing area in the lower courts that allow schools to regulate student speech that violates professionalism expectations, also very disconcerting. I would say we need to be very worried about that. That brings me to my final challenge. The final challenge is that we have a lot of work to do to explain why universities are valuable to our democracy. We see attacks on our institutions coming from all directions, the universities, libraries, the press, which is my other area of expertise. We need to do a lot of work to explain, not just to the courts, because as I said, the law is only going to get us so far. We need to be doing a lot more work to explain why these institutions are valuable and why they are worthy of First Amendment protection. So with that, I'm going to close my remarks. I'm so grateful that I have this captive audience to listen to some of my thoughts on the First Amendment. I care so deeply about the topics that we will be discussing today. Thank you so much for your time and attention.
Thank you, Professor Papandreou. We're going to move right into our first panel for the day. Our first panel is dedicated to student speech and protests. Our moderator is Professor Michael J. Gerhardt, the Burton Cray Distinguished Professor of Jurisprudence here at the UNC School of Law, who will introduce each of our panelists. Please welcome me, or please join me in welcoming them to the stage.
not going to get any better once I get to know. So, how we can talk about this? I just want to make sure everybody can hear me. It would have been dangerous to leave the microphone anyway because I would have used it. But I do want to thank everybody for the opportunity to be here today and for our distinguished panelists. I have a fairly easy choice at the outset, and that is I could either spend all of our time introducing them, or we can actually have a discussion. So, your indulgence and their as well, I wanted to sort of launch into this as quickly as I can. I also want to take the liberty of just perhaps flagging some questions that we need not to address, but if you wish to, that's fine. Folks can have keynote speeches there. I'm sure you all have questions. And here perhaps are some of them. To begin with, I think Tinker, is it possible, or could we understand Tinker as being on sort of, it's long been on the collision course with other precedents of the Supreme Court. And particularly, precedents which recognize, as Mary Rose pointed out, increased authority among administrators to deal with issues that relate to not just pedagogy, but to the mission, preserving the mission of the school in question. For example, could students wear stars of David? Could they wear bloody fists in light of the current contest? And if the school said, no, you can't do either of those, is that consistent with the First Amendment? Because if you did that, it would be disruptive. That's a question that at some point I want to talk about. Secondly, I think when we talk about marketplace ideas, are we talking about unfettered marketplace ideas, or is the challenge really the relationship between marketplace ideas and the reasonable time disadvantage? Those things have to be coordinated within any environment, including this one. Another question that occurs to me is we, those of us who work at universities, and particularly public universities, are of course government employees. But what are our students? They're not employees. To what extent do they have an independent interest in the rights that are independent from or apart from whatever we allow them to have in the context of the university? Now, with all that being said, I have reversed the order of panel in the sense that I'm not going alphabetically, I'm going to go reverse alphabetically. And that is my one disruption. It's a very daring move, but I think we can handle it. And that means that Tim is our first speaker. Let me just add quickly, if you allow me. Tim, of course, is a professor at the University Law School, a place that I taught and have a great affection for. Still, great place to be. And so I haven't had a chance to meet Tim before, and I'm glad he was at home there. And we'll start as well.
Well, thanks. It was nice to go first. Last thanks for the invitation. I'm so happy to be here to talk about an important topic or set of topics. The public protest committee has been very much top of mind. Published a book last year called Managed Dissent, The Law of Public Protest. I'm happy to show the book, don't worry. But in the book, I have a chapter devoted to campus protests. In that chapter, I defend, within limits, of course, student activism on campus, and I identify the norms, the practices, the laws, the regulations that affect activism and protest on campus. So this is a subject that I've been thinking a lot about. My paper for the symposium is entitled New Threats to Campus Protests, and I'm going to focus the paper on what happened during the protests over the Hamas attack on October 7, 2023, and also subsequent to that, because universities have been enacting policies and revising them in response to this protest. So my paper focuses on how universities, respondents, and university leaders and administrators to those protests in the moment and subsequently. So I'm looking at both the public and private universities. As Mary Rose suggested, only public universities are formally bound by the First Amendment, but most private universities embrace robust exchange of ideas, and so I'm using the First Amendment as sort of my guiding North Star in the paper. I also discussed briefly Title VI, which obligates both public and private universities that accept federal education funding to address discrimination, harassment, and hostile educational environment concerns on campus. So I have something to say about that, but we can address that further when we do the Q&A. So I said my focus is on university responses and not those of Congress or state legislatures, not because those institutions have been silent on the matter, they certainly have not, but I'm interested in what presidents and university leaders faced and what they did in response to the protests. And I acknowledge in the paper, and I think we have to acknowledge that university leaders were and remain in a very unenviable position. They face tremendous pressure from different constituencies, donors, boards of trustees, boards of visitors, the public at large, politicians of all stripes, and of course students. In this particular context, the students on both sides of a very divisive issue. So I appreciate the position that they're in. Nevertheless, those tensions, those pressures do not excuse sort of ignoring or violating, of course, First Amendment obligations, nor should they prevent students from engaging in activism of different sorts on campus. So for the initial responses, what happened when the protests broke out, my main takeaway was sort of a general approach of campuses, and of course they vary across the nation. Resort to sort of a law enforcement model for addressing campus unrest. So for institutions otherwise devoted to free exchange and discourse across difference, I didn't see very many universities trying in the first matter to engage in dialogue with students. Instead, what I noticed or witnessed was a sort of model that applies outside campus gates, which is to say, calling on law enforcement to use force, to use arrests, to disband encampments, to use things like flash grenades, and in some cases armored personnel carriers. At my alma mater, the University of Bloomington, well-positioned snipers to position themselves near an encampment that was otherwise peaceful on the Bloomington campus. So none of that surprises me because that has become the model of responding to protest-related unrest everywhere. And so to see it on campus wasn't exactly a surprise. But in total, more than 3,000 activists were arrested for trespass and other crimes. Many of those charges were later dismissed, but not before students and their activists were arrested and processed and subject to those particular burdens. Things could have been or done much worse. There were almost immediate calls, again, before any violence took place or any vandalism, to call out the National Guard to come into campuses, and we should never forget that decision Kent State in 1970 resulted in very tragic consequences. So I'm grateful the National Guard was not called out to address campus unrest. And there were, I have to acknowledge, instances of violence, right? Physical assaults, there was vandalism on some campuses, there was blockages of access to buildings, occupations of buildings, and those may indeed merit some sort of law enforcement response, and physical assault, of course, does, and some of these other criminal activities. But what I noted was, regardless of whether the protests were merely disruptive and otherwise peaceful, or that there were instances of violence, law enforcement was generally the preferred course of action for university leaders, again, as a first resort, not as a last response. So universities, of course, have the duty and obligation, of course, the authority to maintain order on campus. But I think how they did so in this particular instance has serious implications, not just for the protests that were occurring, but for future protests and students' willingness to put themselves in positions like those who were arrested, the 3,000. So most of the paper is devoted rather to subsequent responses. So what happened after the initial protests had more or less subsided. Universities spent their summer break, as it were, revising their policies on protests and on expressive activities on campus. And many of the revised policies are indeed what Mary Rose described as time, place, and manner type restrictions. A lot of them are sort of gap fillers, right? So at the time, maybe there wasn't a rule against encampments. Now there is. At the time, maybe there wasn't a rule against overnight protests. Now there is. So there are a lot of sort of gap-filling responses by universities, expressly prohibiting some of the very things that students and other activists were engaged in on campus. Many of the policies that have been adopted subsequent to the protests relate to locations where protests can take place. Some of those policies adopt free speech zones, so there are particular places or areas on campus where you can protest or demonstrate, but not others. Some of them adopt what I would call buffer zones, so areas outside of campus facilities, classrooms, administrative offices, where you are no longer allowed to engage in any kind of protest or expressive activity, presumably because of concerns about noise and tranquility around those places. Universities have adopted policies limiting where students can chalk physically messages on campus properties. They've imposed limits on placards and signs across campus. There's limited where you can actually display things on signs on campus. Because of concerns about so-called outside agitators, many campuses have now adopted restrictions on the access by so-called non-community members, so people who aren't faculty, staff, or students or their guests, accessing places on campus, and in some cases large parts of campus. Now, assuming that all of what I just described, that all of those policies were adopted without regard to the viewpoint, the message, the idea of the protest, in other words, they'll apply to everyone going forward, they're likely to be treated, very likely to be treated actually as content neutral, time, place, and manner regulations. I have some concerns about that, given the timing of the policy provisions, the fact that they directly target tactics used by recent protesters, and the fact that some universities are intent to focus on expressive activities instead of all university activities. Notwithstanding all that, is a strong likelihood that the courts would treat most, if not all, of the things I just described as content control, time, place, and manner regulations. That doesn't mean they'd be valid. To be valid, they have to be narrowly tailored to address whatever concern the university has. And it depends on how they're written, right? How broadly they apply across campus, for example, would be relevant to that determination. Other policies and actions, though, the same paper raised some much more serious First Amendment concerns. So, for example, one university in Maryland canceled an already permitted demonstration set for the anniversary of the Hamas attack, reportedly on the grounds, or at least the report determined on the grounds that the anniversary demonstration would be too offensive to the university community. Of course, that's textbook viewpoint discrimination, and the court held as much in an early case challenging one of these decisions. Some universities have adopted what appear to be content-based speech standards. There's one policy that suggests or requires that campus speech be, quote, welcoming, whatever that might mean. In some instances, universities have identified certain words or phrases that they say will now constitute discrimination and harassment. That includes calling a person antagonist. So those sort of look like the beginnings of a sort of speech code type approach to at least some offensive words. The draft discusses the concerns about this sort of content-based discrimination, particularly in the context of Title VI. So if they're required to protect students against discrimination, harassment, and hostile environments, it could be that simply the words you use on a sign or placard during protest could be prohibited, to be sanctioned for using the word Zionist or other types of words on your placards or displays. A more serious concern from my perspective is that a protest on campus would itself be treated as a hostile environment, a hostile education environment, in which case universities would be required to step in and disband the protest and sanction the students for participating in it. We haven't reached that point yet. I don't think universities are still working through their own interpretation of Title VI, and the federal government is working through its own. But I flag that as a potential concern. There are other potentially problematic subsequent policy decisions that universities have made. Many have banned masking or attempts to conceal one's identity. That may or may not implicate and violate the rights of anonymous speech. Some universities adopt permanent requirements that require advance notice before any demonstration. Some of those requirements require so much advance notice it may be nearly impossible, if not impossible, to hold a spontaneous demonstration for the things that are happening in the world at the moment. Some of them require the submission of protest materials to university committees or authorities, and of course that raises serious content discrimination concerns itself. As I mentioned, there are restrictions now on signage and displays across campuses, and even if those are content neutral, it may be the case that they're invalid because they're too broad to serve the university's interests in aesthetics or tranquility or whatever the university interest might be. Some new policies finally address the disruptive conduct, and those may be subject to vagueness, overbreadth, and other types of constitutional challenges. So I addressed all of those policy revisions and amendments individually. But I think, as I say in the paper, it's important to consider them cumulatively. It's not as if universities were drafting a blank slate. So there are already pre-existing limitations on protest. These simply add to what was already there. And it creates a situation where it becomes increasingly possible, if not probable, that a student engaged in a demonstration could run afoul of one or more campus rules or restrictions. I'll just give one quick example of a small group of students at the University of Virginia who were trying to table on one of the green spaces on campus, and they were told immediately that they could not even do that because there was now a new policy in place that restricted the erection of quote structures on the campus. So their table had to come down. So in conclusion, I offer, as I do in the book, a chapter in the paper, some reasons to be more protective of campus activism. So it's become somewhat commonplace to deride students in their activism on campus. And I list that in the book. You think historically about the student protests and their effect on the course of the Vietnam conflict, civil rights, and other things. There's great value in preserving, which is this definition was called the spirit of rebellion on campuses. We shouldn't let universities become what he called useless appendages in terms of their democratic functions. And my overall thought, as I sort of looked at the response of universities, is that one thing we should be sure not to do is to adopt the sort of response to unrest that has been adopted outside of campus gates and create this sort of more repressive protest environment. I'll stop there.
Okay, thank you, Professor Zick. I want to ask Professor Collis, next to the University of Texas at Austin School of Law, to speak to us about campus protests.
Okay, well, I appreciate all the comments that have been made so far to Professor Andrea and her comments. To Ben, Craig, Jack Hinton, and their tireless efforts to try to round up a whole bunch of professors who I have to assume with that experience were as horrible at responding to emails as I was. I appreciate very much the First Amendment Law Review and all of the scholars here who are working so hard to help us understand the First Amendment better. There's a story I like to tell. I find with the First Amendment that most people have incredibly strong opinions about its freedoms, but almost little to no understanding of what those freedoms are. And my experience in life is we get in trouble when we have strong opinions about things but don't know what they are. I'll just give one example. Just to break the ice a little bit, lighten things up, when I was 9 years old, I lived in a little town in New Mexico. My family didn't have a lot of money, we lived in a small home, everybody shared one bathroom. And little boys like me, back then, it was really cool to spike your hair up. So I was 9 years old, I went into our shared bathroom, put the mousse in my hair, spiked my hair up, I was feeling pretty good about myself. I came strutting out of the bathroom and my mom walked by and started sniffing. She stopped me and she said, "What does that smell?" And I very proudly said, "It's the mousse." And her eyes got really big and she grabbed me, spun me around, shoved me back into the bathroom, ran my head into the sink and started washing my hair out. Without explanation. Turns out that what I thought was mousse was actually her hair removal product, Nair. And all of my hair started falling out for the rest of the summer. People thought I had some horrible illness. I learned a valuable lesson. We get in trouble in life when we think we know what something is and we don't, and then we act accordingly. And I find that to be repeated behavior when it comes to First Amendment freedoms. So I'm thankful for the opportunity to explore them with you. I would also say that one of the problems we have, of course, when we have freedoms that are difficult to understand is that we run the risk of having them developing inconsistent doctrines, and then whatever doctrines we do develop, applying them inconsistently. I just recently launched a new book, a trade book for lay audiences about how to have productive discourse about hard topics. And what I did is identify various habits that people who are good at that skill engage in to be able to have such conversations. And one of the habits I identify among people who are very good at productive discourse is they tend to hunt for and understand the best argument against whatever position they might have. They can often articulate it better than the very people with whom they sometimes disagree. And I find that sadly with the October 7, 2023 attacks in Israel and the protests and fallout from that too often we're seeing, once again, people wanting to silence positions and arguments with which they disagree rather than trying to understand those arguments and be able to grapple with their true substance. So I'd like to just talk about this just a little bit. So the Israel-Hamas conflict, the related student protests, government and university reactions to speech around them, really served to me, at least as a stark reminder, that far too many people are not committed to that normal understanding positions and arguments with which they disagree. In fact, most people, for certain topics that they hold most dear, prefer to silence opposing views instead of grappling with them. And that instinct is why we truly need, especially on university campuses, neutral principles of free speech. Now, we can disagree, of course, on what those neutral principles should be, and we should have robust disagreement. But I think universities would be best served by identifying them, making sure everyone understands them, and then enforcing them in a neutral manner consistently over time. We've seen far too much inconsistency on campuses. Let me just give a few examples here. Now, I'm going to offend everybody in the room, like I'm an equal opportunity offender, so when I start off offending one political persuasion, please don't shut your brain off, I'll offend the other side a little bit, just stay with me. Prior to October 7, 2023, the common narrative from the political right was that left-wing academics and administrators were silencing speech on university campuses. And I believe there was some truth to these accusations. We repeatedly saw some left-wing actors expressing skepticism of the First Amendment and its related freedoms, and it seemed to be getting in the way of their desired goals and policy choices. So we saw a number of academics and others on the left label defenses based upon the First Amendment as mere weaponization of traditional First Amendment freedoms that would allow oppressors to continue oppressing the oppressed. That came up in scholarship, but it also came up in decisions by administrators. And in their effort to combat this, they tried to compel speech, to silence those with whom they disagree, or to force campuses to restrict what they deemed as, quote, hate or discriminatory speech. Their methodologies were relatively straightforward, so we can just consider two very controversial areas related to LGBT plus rights and race, although I think we could explore a number of other examples. Again, some actors on the left, I'm not accusing the entire side of the political spectrum, but some actors on the left who disagree, tried to silence anyone who disagreed with their proposals by attempting to label speech rather than deal with its substance. They labeled as, quote, racist any argument against their race-related proposals. Any proposals related to the LGBT plus community with which they did not agree, they labeled as homophobic or transphobic or anti-LGBT. They tried to label all of this speech as either hate or harassment. And once they applied the labels, it was easy for them to try to silence the speech or cancel speakers. After all, most reasonable people of goodwill do not want hate or harassment on campuses. But critics, especially many on the political right, correctly pointed out that the definitions of the labels were doing all the work. If the labels were defined too broadly or left undefined, they could be used to stifle all sorts of speech on any number of important topics. If a university administrator wanted to punish someone for certain content or viewpoints, they needed only say they were not regulating speech. They were merely preventing, quote, racism or homophobia or harassment or hate. Until recently, these were the dynamics, and they defined many of the disputes around free speech in institutions of higher education. In the past year, however, since the October 7 attacks and all the many protests we saw, I feel like we've kind of journeyed into a mirror dimension. The groups and their positions have swapped. We have seen some right-wing lawmakers, journalists, and some university administrators engaging in the very same tactics they have been deriding for years. And we have seen actors on the left become newborn champions of free speech fundamentals. Republican actors have pushed for the silencing of speech they deem, quote, hateful, bigoted, genocidal, or, quote, anti-Semitic. Some have expressed worry that students don't, quote, feel safe on campus. And it's interesting that Professor McGill is here today because immediately after the testimony of Congress of the University President, I was asked to testify before the Senate Higher Ed Committee in the state legislature in Texas, and I had right-wing lawmakers who had been mocking the notion of safe spaces for years, pounding the table arguing that there needed to be safe spaces on college campuses, which I found just miraculous. But the word, and of course, the words in all of these cases are doing all the work. The words like anti-Semitic and genocidal are doing all the work here. Using those labels, universities have canceled pro-Palestinian events, with speakers wanting to highlight the plight of Palestinian civilians who criticize the nation-state of Israel. Universities have silenced graduation speakers who would have criticized Israel's government. Pro-Palestinian student groups have seen their designations as official student groups stripped. Incidentally, many of the, in my state at least, in the state of Texas, many of the actors who are engaging in this silencing of speech just a few years earlier passed a law in the name of expanding speech rights that all open spaces on public campuses in the state of Texas must be deemed as traditional public forum, because they were bothered by the fact that speech that they thought they liked was being silenced in some of these open spaces. One of the more public acts along these lines in the state of Texas came from Texas Governor Greg Abbott. In an executive order dated March 27th of this year, he ordered that all Texas higher education institutions must, and here's the language, notice what's happening, review and update free speech policies to address the sharp rise in anti-Semitic speech and acts on university campuses and establish appropriate punishments, including expulsion from the institution. Ensure that these policies are being enforced on campuses and that groups such as the Palestine Solidarity Committee and Students for Justice in Palestine are disciplined for violating these policies. Now notice the move here. Include the definition of anti-Semitism adopted by the state of Texas in section 448.001 of the Texas Government Code in university free speech policies. Now, if we go to section 448.001 of the Texas Government Code, we then come to see a definition of anti-Semitism. It means a certain perception of Jews that may be expressed as hatred toward Jews. The term includes rhetorical and physical acts of anti-Semitism directed toward Jewish or non-Jewish students or their property. It also includes examples of anti-Semitism included with the International Holocaust Remembrance Alliance's working definition of anti-Semitism. Now you have to go 3 steps removed from the order to figure out what some of these examples are. At least 2 of these examples are, quote, now this would be considered anti-Semitism that would be barred from campus speech. Denying the Jewish people their right to self-determination by claiming that the existence of a state of Israel is a racist endeavor, or drawing comparisons of contemporary Israeli policy to that of the Nazis. As with all the examples I gave from the political left, all the work in this executive order is being done by the definition of anti-Semitism. If too broad, it will silence all sorts of speech related to some of the most salient political questions in the world today, and it will guarantee that the strongest arguments will go unheard on college campuses. This paternalistic use of government power likely violates First Amendment precedent, but more importantly, it will stifle speech in the exact same way the banishment of harassing, racist, or hate speech would. Now, I want to just point out that just in the last little bit, at least one court has ruled this particular policy as unconstitutional. But the ideological flipping is not one-sided. Many faculty and political actors who can see the problem of banning anti-Semitism and genocidal speech, if those terms are defined too broadly, are the same people who previously pushed for speech codes that ban harassment and hate speech. They have suddenly become champions of free speech when they were previously hostile to it. In short, both sides of the political spectrum flip their position based on which speech they want to protect and which they want to suppress. This, of course, is nothing new, especially to people in the room. That instinct has persisted perhaps as long as there has been speech and a government to regulate it. But the Israel-Hamas conflict and the flip-flopping it has spurred has proven once again why we need neutral principles of law to govern speech regardless of which speech it is, and why government administrators and faculty need to identify consciously what the principles should be and apply them in a neutral way with consistency over time. None of this is to suggest that we want hate or anti-Semitism or racism on college campuses. Of course we don't. But we do want to hear and explore the most sophisticated arguments surrounding the critical issues of the day from all viewpoints. Neutral principles of free speech doctrine apply to all regardless of the issue will allow that to happen. If universities and lawmakers can put such principles into place, then we will be able to engage in at least one of the habits that I found in my research that peacemakers engage in, people who engage in productive discourse, and that is spending time grappling with the substance of the strongest arguments against our own positions. Thank you.
Thank you, Professor Collins. I'm going to turn to Professor Lamar, Distinguished Professor of the University of California, Davis School of Law, for yet another perspective.
Thank you, everyone. Thank you to the First Amendment Law Review for inviting me and to Mary Rose. I've already benefited from hearing the insights of my colleagues. Mary Rose's Festivus-like airing of the grievances touched on many important themes, and Tim and Stephen's remarks I will try to respond a little bit to in some of my comments. I served as the Dean of the University of Illinois School, College of Law, for 8 years until 2023. And I've written about First Amendment free speech as a constitutional scholar, both before and after that. So I welcome this opportunity today to wear both hats, or maybe neither hat, but informed by my experience in both of those realms, to talk a little bit about the challenges, the problems that universities have confronted in recent years, and some of the responses. I've spent the last few years speaking to a lot of different groups about what's been going on throughout the country, and I'm not going to speak with the kind of granularity that Tim's paper goes into. I'm going to kind of be a little bit more abstract. But I presented at the University of California Center for Free Speech and Public Engagement. I spoke before the University of Illinois Board of Trustees, and just last month I had very interesting discussions. I spoke at the a meeting in Washington, D.C. of the Association of American Universities. So from all that, I want to kind of mention a few of the things that I think have been difficult for universities to deal with in these times. So first relates to a question Tim talked about and Mary Rose as well, and that is how and when to enforce regulations when student speech is causing some issues on campus. And here, my big takeaway is not inconsistent with what Tim said about maybe the kind of overzealous use of traditional law enforcement. But my sense actually is that a lot of universities got in trouble in the last year because they didn't enforce their rules for some period of time. They granted some kind of grace period. They overlooked what they thought were smallish violations until things got more publicity and got more out of hand. And then they brought in the heavy guns. Maybe they went from 0 to full throttle at that point. But let's remember that they tolerated a lot of stuff that violated the rules. And they did it because they wanted to be nice. They did it because they wanted to promote speech. But it got them into trouble for 2 reasons. First, when people do something that is rule-breaking and then they're allowed to do it, they react negatively to the enforcement of the rule. They get an expectation that they can continue to violate rules. We do that when we drive, when we speak, and no one pulls us over. It's, how can you pull me over for 5 miles over the speed limit? That's insane. And then second, of course, there's always the question of why you enforce when you enforce. Is it because the message was getting too loud and you don't like it, and it's getting through? You open the door to the dreaded accusations of viewpoint discrimination. So I think one of the responses that Tim talks about nationally taking place is an effort to tighten up not just the rules, but also to tighten up the discretion about when and how they're enforced. And I think that's all too good. Tim has some misgivings about the timing and the context of some of these responses. And I got that a lot. When I talked at Illinois in front of this faculty senate, to a faculty member, everyone talked about the Palestinian exception. Free speech is fine unless you're pro-Palestinian, and then it turns out that speech needs to be regulated more. I think, in fact, that Tim is not just right that most of these rules will be understood as content neutral, time, place, and manner, rather than viewpoint inspired. And I think that, in fact, most of them really are probably innocent in the sense that every problem comes to regulators in the form of particular individuals with particular characteristics and particular points of view. But that doesn't mean that the response to the problem would not have been fashioned in the same terms, no matter what the identity of the original people who put it on the radar are. And I would actually go a step farther. I think actually proving invidious motive in free speech cases is harder still than it is in equal protection, from which the framework is largely drawn. And I want to mention a few reasons for that. First, I think it's much harder to predict durable viewpoint-based disparate impact in speech than it is durable disparate impact along racial or gender lines. If you use standardized tests, you can be confident they're going to have a disparate racial impact for a long time. It may be true that the Palestinian supporters who spoke last year are going to be most adversely affected in the short term with regard to some of the rules that have been adopted or revised. But who knows what's going to happen 6 months from now? Who knows what the new cause celeb is going to be? So the correlation between impact and intent is harder to draw in the First Amendment setting than it is in the equal protection setting. Second, government is allowed to speak under the First Amendment, and that's true even of universities. I tend to agree with Keith that institutional statements are problematic. I didn't do them as a dean. I did not issue departmental statements. But that's a matter of policy, not as a matter of First. I object to them not as a matter of First Amendment, but as a matter of what universities should be about. But the fact that government can speak, and that's business as usual, creates more problems with discerning and finding invidious intent than in equal protection. If you have a legislator who is drippingly racist or sexist and then votes for a law that has a disparate impact along racial or gender lines, it's pretty easy to connect the dots and say that's invidious motive. If you have lawmakers who speak and then they enact a law that may have a disparate impact against the viewpoint that they disagree with, well, they're allowed to speak, and that's business as usual. So connecting the dots and finding invidious intent is much harder in that respect. Third, as Tim pointed out, the test for content neutral laws is already quite rigorous. So the inclination to find a law, in fact, viewpoint based when it's neutral on its face, is both unnecessary and more aggressive. And then finally, the history of laws that have disparate impact along particular viewpoints is not actually one that punishes non-mainstream, kind of ultra-progressive causes. You think about the cases where the Supreme Court has most clearly articulated the idea that a disparate impact along different viewpoints is not a problem with the First Amendment. There are actually cases involving pro-life speech. It's Frisbee versus Schultz, where we ban residential picketing in neighborhoods. It's Madison, where we have an injunction against abortion protesters. It's McCullen, where we have a statute against protests outside abortion clinics. Those are all kind of laws and government decisions that have an adverse impact against conservative mainstream speech. So I think that those are reasons why proving the invidious intent is really going to be hard, and it should be. Let me just mention, before I stop, some larger reforms that have been on my mind about what universities can and should do. That relates not so much to campus protests, but to the problems posed by outside speakers, invited often by registered student organizations or the like. So some of you may remember, I think it was in 2017, my undergraduate alma mater, Berkeley, spent about $800,000 to prepare for, quote, Free Speech Week, where various student groups had invited Milo Yiannopoulos and others to come. It never actually happened. But they had to spend up close to $1 million, between $700,000 and $800,000 in security costs to prepare for this thing. Now, I share a concern that Mary Rose mentioned and Tim mentioned, that when you have unpopular speakers who might portend outside agitation and violence, and I share the concern that kind of quelling that speech, silencing that speech, or requiring the organizers of the inviters of that speech to pay the cost, that poses the risk of viewpoint discrimination and quelling provocative, transgressive speech, which of course is what the First Amendment is largely about. I get that. And certainly that was reflected in the one Supreme Court case that deals with this. That's the Forsyth County case from 30 years ago, where the court said it was problematic for a public entity to impose a $1,000 security fee on a provocative speaker organization. But here's the problem. I can tell you, as a dean of a law school, if I have to pay that kind of money to have RSOs invite a bunch of people who really don't belong to speaking at a university in the first place, I'm just going to shut down RSOs. That's what I'm going to do. These are fora I create. We don't have to have them. I can pull back the podium. And so courts need to be more sensitive to the fact that universities are not just like municipalities, and we create things we don't have to, and we can pull them back. So, it's one thing to say that a city should spend $1,000 rather than foisting that bill onto an unpopular speaker, because $1,000 means nothing to the city, but it might mean something to that unpopular speaker. That's a sensible decision in foresight. But when Cal has to spend $800,000 to allow outside groups to invite individuals, or student groups to allow outside individuals, that's going to cause Cal to reconsider its delegation of authority to student groups, to faculty members. It's going to pull back, it's going to centralize. And that's not a good thing, because that means fewer people get to invite outside speakers. And that's going to limit the range of perspectives that are reflected. And I gotta say, faculties are less diverse than student bodies. And so it's going to decrease the ideological diversity of those who get invited. So I hope courts are more sensitive to the options that universities might have that municipalities might not, because they're bound by traditional public fora doctrine in a way that universities are not when they designate or create limited public fora. Last thing I'll say is, much of what's lurking behind some of these questions and debates is really a question that I think Tim's paper talks about, especially near the end, and that is, how much should we really embrace student activism versus tolerate student activism? Is it a model that's a tinker while we allow it as long as it doesn't disrupt what we're really about? Or is it something that we are really about and we should trade that up? Now, I gotta say, I'm torn about this because I think more speech is generally better than less speech. But it's actually, at the end of the day, not that hard a call for me if we have student protesters who are so loud that no one can hear the lecture that's taking place in the building next door. That's easy for me. Because universities are first and foremost about research and teaching. And I'm happy to allow student speech and allow interpersonal development and maturation and citizen building and all that, but it's not on par with the other aspects of the university's mission from my point of view. And again, this is something that really is outside the bounds of the First Amendment. Whatever the above and beyond the First Amendment a university does should be clear and quickly enforced. But how much more generous universities should be than the First Amendment requires to floor is something about which people will disagree. Let me just mention two other reasons why I'm a little dubious of the idea that students should have more speech just because they go to university rights, just because they go to university. I think there's a classist element to that. I don't know why a 20-year-old at UNC should have more rights to express herself on campus than a 20-year-old in Chapel Hill in the city park would. I just don't, I'm not sure why that's part of the privilege of being a university student. And then second, and somewhat related, I don't think that's what the people of North Carolina or California are subsidizing us to do. I take seriously that we have this trust, we spend a lot of money, and we come under a lot of fire because we're not always sensitive to those who are funding us. And I'd like to know more about what the legislature, what the regents, what the people of the states that fund public universities think about how important this element of the student experience really is. Now, private universities, of course, is a different matter. That's one area where they might diverge. But these are some of the issues that I think are worth thinking about, even though I myself haven't come to rest on resolving any of them. So,
thank you very much, Professor Lamar. I think we're off to a really good start. And obviously, beginning to talk about issues that are going to cut across a number of different panels. So I want to sort of pick up where Professor Lamar left off in asking all of the questions. And I'll start with Steve and then we'll go on down the line, if that's okay. One of the things I think Vic's remarks raised, and I think it's probably raised by each of you in different ways, is an issue that we haven't sort of identified or focused on clearly, but it's integral to everything we're talking about. And that is, what's the purpose of the university? Why are we here? I think that is a question that needs an answer. It's something we need to really think about, because depending on the answer, that may help illuminate the extent to which there may be certain kinds of regulations or not. Take, for example, some of these recent protests we've been talking about. Is the university's mission or purpose simply to kind of stand back and let as much happen as possible until there's a problem? You probably tell by the way I phrase that question, I'm a big fan of that. But is that the university's mission? Now, at the other end of the spectrum, we can say, is the university's mission to sort of tell us what to think? I'm not a big fan of that either, though I happen to do that in class all the time. But what I am wondering about is, to what extent is the university's role or mission or purpose to provide a degree of instruction on how to engage in discourse about very difficult issues? I think the university has a mission and purpose. That does not mean the university should be taking positions on all sorts of policy questions. My point is different than that. My point is, to what extent can the university actually set an example for what responsible dialogue about difficult issues looks like? There's no perfect example, no perfect place on the planet, but near the beginning of these protests, I thought Dartmouth College provided a very good example of trying to have somewhat of a responsible discourse about these things by setting up panels. The students were voluntarily allowed to attend, but these panels were great instruments, I think, for not just informing people, but for the manner in which you could address these kinds of questions responsibly. Now, as they often say, you can lead a horse to water, but you can't make it drink. You can lead people to these things, but you can't necessarily make them think. But I think part of what universities are about, and this is kind of what I wanted to just open this up to discussion from each of you, is not just being reactive, and each of you kind of talked about the importance of being proactive, but proactive in an educational, pedagogical way. What's the mission or purpose of the university, which is going to help provide a framework for whatever the university does?
Well, first, just right out of the gate, I want to thank Vic because I have a game that I play with my children. I do so many talks around the country that we have this new thing where they challenge me every time I go somewhere. They give me a line from the TV show Seinfeld, and I can work it into my addresses. And by invoking Festivus in the area of grievances, he did that for me. So thank you. I appreciate that very much. I mean, this is I think it's a very complicated question when we talk about what is the mission of universities. The initial first blush, I think, is to come up with some singular mission and say that's it. But the reality is, universities, especially large universities, and it's even more complicated with large public universities, have a multitude of missions, right? You could argue that part of the university's mission is to seek, find truth, and then to disseminate that truth to students. But part of it is to help prepare students for the job market, to learn skills that they can take with them and actually use in the real world. Some would argue that part of the mission of the university is to seek justice or even social justice, and that might be in tension with seeking truth. Some would say that's a false dichotomy. Part of the university's existence is to be a community participant and to be a good citizen within the community. These are often large institutions that have a lot of weight within a given community. And for public institutions, these are often armed to the state. And are funded by the state and have missions related to the goals of the legislature's funding them. I think part of the mission of universities is to teach students how to learn and to model discourse. My initial comment on this is to say, most of the time, I don't think any of these missions are actually in tension with one another. Where I think universities make a huge mistake is occasionally you will see universities adopt, for example, a particular social justice mission, even at the expense of truth and research, where they create a tension that doesn't need to be there. I'll just give one example. We hear stories of scholars who make some kind of discovery, only to have their department or their university tell them, you don't want to publish that. Right? That'll ruin your career, that'll ruin your opportunity to get tenure, it's against our mission, it's against our preferred view of something like affirmative action. That creates a real problem for universities where their lack of clarity about who they are and what they're doing can pose a real problem. It creates a tension that I think is unnecessary and doesn't need to be there. So to the extent universities have all of these, I mean, the reality is I think discovering and disseminating truth over time, and I talked about this once when I worked in a different setting. All these people came jumping in saying this is why we should get rid of colleges of liberal arts because they're all worried about truth. Everything should be about STEM. And I thought that was such a nonsensical response because scientific research is about finding truth as well, right? Discovering the nature of atoms and molecules and the physical universe is still a discovery of truth. We're not talking about philosophical truths. Allowing that pursuit often will lead to just outcomes over the long term. These things are not necessarily in tension with one another. When universities make a mistake is where they create an environment in which they are in tension with one another. And that's where I think universities need to be very careful. I think we spend all day talking about this, but that's just an initial thought.
So, let me start by saying I think there has to be room and space for student protests on campuses, especially public university campuses. Earlier I distinguished universities from municipalities, but we also do perform a municipal-like function with regard to the area that we control. So, so we have to tolerate some of it, whether we want to or not. Now my question is, well, how much do we want to encourage it? How do we want to encourage it and the like? I would say here that there are really different kinds of student expression that we have to maybe look at differently. These protests typically do not involve a lot of attempted persuasion, let's be honest. They're not people talking with or among others, they're talking, or even to others, they're talking at each other. And I'm not sure that that's really, again, they have a First Amendment right to do that. And there's something important about learning how to exercise one's voice and being on record and kind of identifying yourself as associated with a cause. And sometimes they want to put pressure on the university audience, the regents, the president, et cetera. So being very loud and being there in a particular location is very relevant. But I don't think that fits into the core of the university's mission as much as trying to channel whatever the underlying disagreements are into some kind of rational discussion that is informed by different but expert viewpoints. So again, I don't want to steal Keith's thunder, but one of the reasons that I was able to resist the relentless pressure to issue statements after every headline that came down was that I would usually not be silent. I would usually not ignore some recent episode. But instead of opining on it or characterizing it or giving my supposed faculty's take on it, I would just use that as an occasion to convene some kind of academic event where people across the philosophical and ideological spectrum, all of whom have some background in the topic, can then present their take on it as individuals and engage students in an analysis of the event rather than a reaction to the event. So I think that's our comparative expertise. I think that's what we're good at. Again, I mentioned I went to Cal undergrad. The day jobs came down, I got an email from the then chancellor, who I'm very fond of and very impressed by, Carol Chris, who's an English professor, old English professor. And the letter I got to all Cal alums was why Dobbs was such bad constitutional law, and which it was a kind of a big error for the Supreme Court to make. Now, an email from her saying, at Cal, we still are offering reproductive services, no one should be confused about that, this is our value, blah, blah, blah. Great. But she knows less about the Constitution than my high school age kids, literally. And I was offended. I wasn't offended as a kind of a person who thought jobs were. I was just offended as an expert that someone is kind of using this. But that, to me, that's not what universities should be doing. They should be playing to their strengths. And so, you know, how do you manage the student unrest? You channel it. And you channel it into things that universities are distinctively good at, even as you must and should allow some of it just as individual citizen expression.
Yeah, one of the challenges during class, I agree with a lot of what's been said. In terms of the democratic functions of universities, there's all sorts of language in the Supreme Court's own opinions about education and democracy. With respect to higher ed, faculty and priests of democracy. Sounds great. K through 12 schools are the nurseries of democracy. In the BL case, which Mary Rose was talking about, the disgruntled cheerleader case, what's the proper metaphor then for universities? There's some kind of finishing school. You know, they certainly have a democratic function or functions. I don't think it's their principal function by any means. But to the extent it is one of those functions, I don't think you model discourse by violent suppression of protests, right? It's true that some of these protests were allowed to go on, but there was very little dialogue on the front end. The dialogue came after. Now we're encouraging students to engage in reasoned discourse. Well, that's after you brought in the police. And part of the problem with that approach, by the way, is it escalates violence. it actually leads to more force. And I'll just give you an example. I live in the city of Richmond, and about a mile from me is the campus of Virginia Commonwealth University. And about 30 students had gathered outside during one of these protests near the library, and I got an urgent message from law enforcement and campus security: stay inside. It's very dangerous. So as a measure of civil disobedience, I quickly hopped on my bike and went down to campus to see what was going on. And not to my surprise, nothing really, right? The students were there, they gathered in front of the library, and they were being advanced upon by a security force. That's the public danger. The problem, as I see it, with the protests, this is not just on campus gates, is that we're starting to see an impression that every assembly is an incipient riot. It's dangerous to have people assemble in public places, including on campuses. We need the National Guard to crack down immediately. And I think that's a dangerous model to adopt for campus. I frankly think it's a terrible model to adopt outside of campus gates as well. But if you are going to encourage students to engage in reasoned discourse, I don't think you can also have a speech code that says you can't say certain words. So you've got to be consistent with respect to what messaging you're giving to students. And in many cases, students are misinformed, right? There were students at Berkeley that said, we have a right to protest in the backyard of the dean of the urban university. They don't have that right, but they think they do. So part of this is a little complicated because it was just a little bit, yeah. So, you know, I think there's an educated function there with respect to even the protest. And to the point about, you know, a student protest on campus and off campus, frankly, the point isn't always just to relay a message. Public protest has values internal to the protest itself. People gather for solidarity reasons, right? It makes them feel good to be with others and agree. So I don't think it should be a requirement of any kind that they have a specific message or that you can reason it out, or it's, you know, it's sort of providing these dulcet tones or any of that, right? Of course protests are messy, of course they're disruptive. That's part of the point of protesting, is to disrupt daily function. So yeah, I'll stop there.
I'm going to just preface one of the questions that comes from the audience. I think I'm going to combine these questions in a second. But I want to map on to what everyone said, which I think has been very thoughtful. The reality, I think Vic might have mentioned this, I'm sorry if I misremember who first brought it up, that some impulse for protesters is to silence the discussion, in other words, to preempt it, to shut it down. Now, Steve mentions that his kids have a deal with him so he can work in the Seinfeld line. My deal with my kids is to work in something from the Batman movies. And so the line I'm going to use in the Batman movies is, you'll have to guess which one, is when Alfred says to Bruce Wayne, you know, some people just want to see the world burn. And I think to some extent, when you see some of these protests, that seems to be one of their objectives, to disrupt. There was a piece in David Target in which a student said, I have a right to disrupt. Now, I think that's kind of interesting. I don't know how many of us would actually agree that there's such a fundamental right. But let me just frame this from several people in the audience who've asked about why are things different now than they were back with anti-apartheid protests, which seem to have been arguably more peaceful, or even protests back in the 60s. Are they different now? And if so, why are they different?
I don't know if they're different. I'm not convinced they are from what I've seen, but I confess I'm not like a scholar of anti-apartheid protests. But from what I've seen, I don't see things as dramatically different. I have wondered, at least at some of the universities I looked at, if some of these protesters have not been trained as someone to push the envelope to the very edge of First Amendment law into a gray area to make it very difficult for administrators, because I don't think, as Vic points out, as you said, the goal is not, I don't think, to have productive discourse about a very difficult topic. I don't think that is their goal. I think their goal is to draw attention to the plight that they have. So at the University of Texas, we've had something like 29 pro-Palestinian events across the campus. The week of the major protests in April, there were 4 separate events that all happened back to back to back to back in the same space. The first day were protests where people were arrested. The second day was a massive response from faculty and students in protest of the arrests. Thousands of people went out and protested. Almost no news coverage and no arrests were made. The next day was a Muslim religious prayer that occurred in the same space. Again, no media attention, nobody even thought anything of it. And then the fourth day, the protesters from the first day came back. And again, did things to kind of push the envelope. And I think their goal here, I don't know that their goal is to disrupt, and I don't know that their goal is to silence opposing views. I think the goal, at least for some of these protesters, is to draw attention to what they see as a massive humanitarian crisis and trying to put it in the best light to live. They don't achieve that by having a quiet, peaceful protest that doesn't push the envelope. They've got to push things to the edge to get an administrative response that then draws in news media. And so I don't think the administrators are trying to deal with these things, because it does seem to me that the protesters are behaving in a way precisely to get that response. And that makes it very, very difficult, because the way you do that is you get right to the edge of the First Amendment protections and kind of push into a gray area, and it becomes incredibly difficult to know where to go from there.
So I do actually think things are different. I'm old enough to kind of remember the apartheid protests. And I think there are probably many reasons for the differences, but 2 I would point to are, first, there's much more involvement by outside organizations that themselves have agendas that are very sharp and very aggressive. There's more kind of interaction between students and outside individuals, like whether it's Turning Point USA or whatever, pick your organization to the left or the right, that have a bigger agenda, and they're, I think students are used often. I look at the individuals that RSOs sometimes invite to some of these events, like the Berkeley Free Speech Week, and the students are being kind of used as pawns by a lot of larger outside organizations and forces. And that wasn't as true in an era where we just weren't as driven and traveled more generally. And then the second big change, I think, is social media and the internet. And that has 2 dimensions to it. First, it ramps up the stakes, because you can Tim rightly talked about the value of spontaneous speech. But spontaneous speech can become spontaneous chaos too, and melee with the ability to summon large numbers of people very quickly, so that puts the news regulators on edge, because they do have to worry about the specter of violence when something is posted in a way that can draw a lot of outside attention. So that's one aspect of what the internet and social media has done. And the flip side goes back to Steve's point. There's so much stuff out there. To get anyone's attention, you've got to go big. You're not going to be on the news. I mean, the Westboro Baptists wouldn't be on the news anymore, because their events are just so small potatoes compared to stuff that is going to go viral or be on the evening news or the like. So the fragmentation of media and the difficulty of capturing anyone's attention, I think, increases the scale that we need to operate on if you want to be heard and make your point.
Yeah, with respect to disruption, right? I think there's a difference, obviously, between disrupting a scheduled speaker, for example, if that's what we're talking about, and disrupting the daily activities and routines of people on campus. And I don't mean interrupting classrooms or classroom functions, but when we're talking about disruption, we get different meanings, I think, to different people. And in terms of just disrupting people's daily routines, the Supreme Court itself has said one of the benefits of speaking in a public space is that it's very difficult to avoid what's being said. It's so easy online to just channel all that and avoid it and delete it and so forth, but not in an open space, including on campus green. So in that sense, I would defend a right to disrupt, at least to that point. With regard to the differences between protests, I don't know that anti-apartheid is the right model here. Think about the 1960s civil rights protests and the Vietnam protests. Those were sometimes quite violent, more violent than anything I've seen in the context of the recent protests. I mean, there have been no bombings as there were back then, right? There were similarity, occupations of buildings and police escalations and so forth. So I think we should be careful about which protests we're talking about in terms of differences and similarities. And the last thing I would say with respect to why these protests might be somewhat different, and other people have pointed this out, in past protests, the students were sort of joining common cause against power, right? Authority. The students on one side and the authority on the other. These protests are quite different because students are on different sides of this very serious divide. They are also opposed to authority in their own ways, right? And so campus administrators, university presidents have to, in addition to everything else, somehow manage that tension, being pushed and pulled in different directions. So I think in that sense, these protests are unique.
Thank you, Tim. It reminds me of something happened at one of my college reunions. Class of 1968, members of the college set fire to a shanty on the middle of campus in protest of the fact that the shanty was there. And a graduate class 10 years later, 78, tackled the people that set fire. That was the generational difference between those classes. One would set fire, the other says, no, we're going to put an end to that. More importantly, it's time to open it up for questions. We've been patient, and I'm sure there are likely to be a number of questions.
Part of the problem in all of this, I feel like, going back to my remarks, and actually all three of us touched on it in one place or another, is just the inconsistency with which universities are approaching these things. So, Vic mentioned folks like Turning Point USA, and some of the other Young America Foundation. I think there's some of these outside groups that are sending people on the college campuses from a conservative standpoint. Well, in Texas, they changed all of the outdoor spaces to be traditional public fora because they thought it would ensure that groups like that could bring in their speakers. And that was the goal. It's going to work in our favor. We're going to make everything a traditional public forum. And then, of course, when speakers came to use the traditional public forum that they didn't like, suddenly it was kind of a problem that everything was a traditional public forum, right? And so then they wanted to crack down on it as if it wasn't a traditional public forum. I think universities, and in this case, government officials, they really need to come up with consistent standards and apply them consistently over time, regardless of the disruptions. I actually don't think it is that hard to anticipate these types of things and to put in protocols well in advance to be able to respond to them. It shocks me continuously that administrators act as if every time a protest comes, the first time they've ever seen one of them. That's just mind-boggling to me after all the decades of protests we've had in the
The only thing I would say about that is
defend the administration.
well, no, I guess I would say people don't start a job as a entry-level assistant professor thinking about being a college president. And people who then, after a while in the academy, are open to administration, when they want to become a college president, they're doing so because they want to shape the direction of the university and the research and the great team. No one has kind of been trained all the way up to be focused on crowd control. This is a bigger problem with higher ed administration generally. Higher ed administrators today are being asked to do so much more that they're just not well trained to do. Maybe with time and experience they can learn. And maybe there needs to be more boot camps for incoming provosts and incoming presidents that deal with some of these things. But it's just, you say you're surprised. I'm not surprised because that's, I don't think, Chris Bracey became provost because he wanted to work on labor relations, for example. That's, not why he decided to put his hat in the ring there. So the learning curve is steep for a lot of these things.
We're doing our best to elicit questions from the audience. So, Yes.
I have a question for all of the panelists. So I've been on a college campus now this year 2024 and 2016, and I've seen a lot of unrest within student populations on the campus. It was touched on, but a lot of these protests are students against like an authority, and now we're seeing a lot of disruption within student groups, within the student body itself. How do you administrations manage that disruption when it's within students?
I assume everybody heard that, but the thrust of the question was, how should administrators be able to handle the fact that the students are in tension with each other? There are conflicts among student groups and the student body.
So, you know, one important way is through education. So, for example, when I was dean in Illinois, the Jewish student group would put out an email that was accessible to all the student body, and the Muslim student group would do the same thing, and people would get upset. How can you allow someone to send me this offensive email? And so part of what we did, we put out kind of repeated reminders of how none of this is coming from the administration. This is the way RSOs operate. And I mean, I got emails from parents saying, "How could you let my kid be subject to this?" And I waffle between, okay, well, the kid doesn't have to read the email. The kid's 24 and is going to be taking the bar and going to be a lawyer soon. And why is the kid not coming to me and you're coming to me? I mean, there were so many, but I took a deep breath and I responded, in an adult fashion. But a lot of it has to do with, I think, just educating students about what the rules are. When the rules are violated, I think kind of progressive enforcement, but some enforcement is important. To nip it in the bud, maybe not kind of with the nuclear weapon, but you give someone a warning the first time or a reprimand, and you kind of within the bounds of privacy law, you make clear that this is going to be the university's response when the disagreement kind of escalates into something that is more threatening. But beyond that, again, law schools are distinctive because we are, we're training people to operate in settings where they're going to have to respond to ideas that make their blood boil. And so if we can't model that, I don't know that the rest of campus can. But a lot of it is just education and counseling.
I'll second that. I'll also defend my comment about consistently shocked about administrators not planning for these things in advance. These aren't new problems. We live in a society that for centuries now we've allowed speech for people to talk to each other who have very deep disagreements about some of the most important topics of the day, and we have law that's developed accordingly, and I think universities can plan for these types of things in advance. But the idea of students against students is an interesting one because, like, arguably what I see, that's their biggest concern. Students are afraid of each other more than they are faculty administrators. We hosted an event, the First Amendment Center that I directly hosted an event to help educate student groups about what their rights are, what the resources are available to them, how the First Amendment works, that kind of stuff. And it was interesting. We had a pro-Palestinian student group representative show up and a pro-Israel student group representative show up. They were both expressing the exact same worries and concerns about each other and about what was the university going to do. So it was critical at that point, in my view, I'm not an administrator, but it was critical for administration to make sure that they are expressing clearly exactly how they're going to protect each of these student groups and their rights, what the limits are, what the rules are, and how they'll be enforced, and ensure that they'll be very clear about that. But again and again, I see universities not getting ahead of this and struggling to do it in advance. Last thing I'll say, talk about getting ahead of it. One thing that the University of Texas has started to adopt, especially the University of Texas Law School, but I think this is not to integrate with campus. Part of the application process is to inform students that they are coming into an environment in which they're going to be exposed and they're going to have to grapple with lots of ideas with which they disagree, and then write an essay about how they feel about that.
The point of that prompt in the application process is to start getting them thinking in those terms right out of the gate, so they're not shocked by it when it comes. And hopefully, perhaps it might weed out some students who just say, I don't want to be in an environment where I have to deal with people who think differently than I do.
So let me, Stephen's comments kind of trigger something Don Plummer. So I think he's right. We do, administrators do need to be more proactive. And it's not just about educating students of the inevitable reality that the First Amendment is going to require them to hear things that they don't want to hear, just like in Common, you're going to see the draft message on a jacket that you might not like. It's often reaching out to student leaders and kind of encouraging them. You can't force them to do anything, but encouraging them to kind of work with each other. So, for example, in Illinois, you know, whenever Federal Society or ACS kind of was telling me about an event they had, I said, maybe you should co-sponsor this with the counterparts. So ACS and Federal Society would jointly sponsor something and bring in people kind of across the spectrum on this issue. Same is true with the Jewish student groups or the Muslim student groups. I actually met with their leaders and tried to identify things that they could do together so as to kind of facilitate some kind of mutual respect or at least understanding.
A couple of thoughts. It's probably disappointing to university and graduate school administrators that they're having to address this problem. This problem being how to model proper discourse. It seems like that's something the nurseries of democracy maybe should be better at, or maybe should do more of. So by the time you're in law school, for example, you should already have some of these skills in place. I'm not a Luddite, but I don't like social media. But I think a lot of the discourse is modeled on the takedown social media model, right? Because where people aren't engaged in recent discourse and they fear cancellation or whatever repercussions that come from that. And I agree that students are more afraid of each other in terms of sort of what they say in class, for example. I've had things go viral from a class. But the student actually said that thing or not seems not important. It just sort of becomes its own rumor. I actually made a point of saying to a seminar class, please keep this sort of in the room, right? It's going to be a controversial subject class. The very first night, I got an email from a student outside the class that I heard in your class today. So-and-so said such and such, right? So there are lots of difficulties here. If you want to make sort of one sort of pitch for sort of the kids are all right, this is sort of a pitch to sort of a calamity across the country. In actual fact, in terms of the protests themselves, it's a pretty small fraction of universities and colleges across the United States. A few of them got a lot of media attention, so it seemed like an enormous crisis, and that happens far too often. I have friends and relatives say to me, what's going on in your campus? When you married, are the students going crazy? And I said, no, they're studying for their exams. That's what they were doing. In fact, there was very little activity on my campus. And I'm quite grateful to work at a school where I think the students are generally, with respect to these protest matters, reasonable adults. They will come to me often and say, I plan to do X. What could happen to me? And X might be, I'm going to protest the governor getting an honorary degree. I'll say to them, well, you can do that, but it's sanctionable and civil disobedience, right? Or speakers coming to campus, we object, my group objects, so here's what we plan to do. What do you think, right? So there is more of that out there, I think, than gets any coverage in the New York Times or the Wall Street Journal or any other sort of media outlet.
So I think Tim is right that, yeah, it is a relatively small subset of universities that experience these issues, but I don't think it's coincidental or irrelevant that it's not a random subset. These are the elite institutions of higher education. So, whether it's Columbia or University of California or University of Texas or William & Mary or whatever, oftentimes a lot of the activity takes place in the best-known universities, and that informs the public perception of all of higher ed. It's part of the problem more generally. So even though it may not be as widespread, it is perceived to be so in part because of the identity of the institutions involved.
I would just provide an anecdote that I think supports what Tim was saying. Tim was talking about, I think, the small sensitive universities. So even on university campuses when these protests were occurring, I can't speak to all of them, of course, but University of Texas, I think between like faculty, staff, and students, what do we have here? It's like 58,000 people. It's a massive place. I was in my office at the law school, and I've been getting media requests now for multiple days related to protests. Finally, I got an email saying, stay in your office. That's the same thing you got, Sam, but be careful, disperse. So, of course, the first thing I did was walk over to the protest, right? I walked from the law school across campus. I passed, and I'm not making this up, I passed obviously Jewish and Muslim students eating lunch together. In one case, who were sunbathing. People were studying. It was peaceful. It was beautiful. I didn't even know where the protest for sure was happening until I walked up these stairs. I went all the way across campus, and finally I heard it, and then I got on top of it. In a place of 58,000 people, there was probably 1,000 there. The media, of course, zooms in on the most intense moment of it, and you would think, I was getting texts from my parents, are you okay? Can you get out? You know, I mean, it was really not as overblown as it appeared to be in the media. It's not to minimize the stuff, but it's just to say that you have a campus of 57,000 people who were going about their business, who were functioning, who probably were engaged in productive discourse, who were doing fine, and then you had this small group government and made a thing, and that matters. Universities have to not respond to that, but I do think it's important not to suggest that everything about higher ed and all these students and the way universities are operating is dysfunctional. 98% of it was operating quite well, I think, and then there was one place where these protests were happening. Just as a side note, I have a buddy who's one of the leading Islamic law scholars in the world. He and I were watching the protests together. He has been harassing me for like 2 years to go with him to Egypt to speak about religious freedom and freedom of speech. He said, we're watching these protests. I said, hey, what would happen to these protesters in Egypt? And he said, oh, they would have been arrested within the first 5 minutes and would have been in jail for a minimum of 5 years. Some of them might have been executed. I thought, that's where you want me to go speak? I'll take the problems we have in the United States.
So just in defense of administrators a little bit, part of the problem and why these warnings go out is because the one time someone gets hurt and there was no warning, all of you budding lawyers are going to sue. And university, there's no species in the universe as risk averse as the university council. Avoid the possibility of litigation at all costs. And so this is part of the larger culture, so I understand.
I want to thank Nick for identifying our common enemy, the University Council. So one thought that occurred to me before I call on somebody for another question is I can't help but I want to come in a little bit of defense for the administrators as well. And I hate to use this analogy, but it's unfortunately the only one that popped into my head. It's from boxing. I think it comes from Mike Tyson, who said, I didn't know that. Anyway, and so Tyson said, you can have the best plans in the world until the first punch is landed. It's the unpredictable, it's the disruption, it's the things that you are not necessarily expecting. You know, things coming from directions you hadn't necessarily anticipated. That's what makes it more challenging. It might give help create an appearance that somehow administration is not necessarily in control or on top of things. It's because I think they've moved into an area that they just had not anticipated, and it's hard to anticipate everything. And I think right now there's a lot that's happened recently that has been unpredictable. It's challenged the status quo, conventional wisdom. Kind of, you've got plans, then suddenly you've got a protest that includes bullhorns. Or you've got plans and people decide to take over Hamilton Hall in London. You've got plans and things that you expect to be able to do, and there's this new kind of disruption that your plans have not quite figured out. Yes, sir.
The question is, could universities do a better job
directing student protests more to exercise their First Amendment rights more properly through contacting their local, state, or federal officials, depending upon what the issue is. That's where the change occurs. When you can protest all you want on the university campuses, and people have that right. But to properly change policy and conditions, then, for example, the Gaza, white member of Congress, go to the Senate Foreign Relations Committee, chairman and ranking member, House Committee, House Foreign Affairs Committee, chairman and ranking member, and then the concurrent appropriations. That's where the change can occur. And if students knew that and can properly present a well-researched position, then that's a more effective way of doing things. I worked on Capitol Hill in the U.S. Senate for 22 years. Staff and Senator Madigan, Senator we'll meet with anybody. Members of Congress meet with anybody, and that would be a more effective way of expressing their First Amendment rights.
Well, again, I want to emphasize, I think exactly what you're describing is happening. I think lots of students are being trained in how to do that, and lots of students are going out and doing that productively as citizens, and they're going up to be citizens who are doing it. We're talking about a subset of the campus community, including some people off campus coming in and engaging in these protests. And quite frankly, go back to what I said earlier, I don't think their goal is to effect change through the legal process. The protesters, I think, have a different goal. I think their goal is to draw attention to what they see as a crisis, and to do that, they've got to behave in ways that will get media attention. But I think it's really important not to assume that because you've got 1,000 people on a campus of 58,000, you've got 1,000 people protesting, that all the students are behaving that way. I think there's a lot of students who are learning the very skills you're describing and are going to effectively go learn how to employ them. Real quick about University Council. When I went to go observe the protests at UT, we're standing there watching them. You've got protesters on behalf of Palestinians, you've got pro-Israel counter-protesters, you've got hundreds of other students circling this whole thing, just kind of curious. The media is there, the police are there. And I see the University Council. So I go up, the idiot law professor, and I'm talking with her. I knew who she was, I'm talking with her, and I say, isn't this amazing? I just heard my comment from my friend from Egypt. I'm like, isn't this amazing? Think of America's First Amendment at work. We've got protesters and counter-protesters, and police trying to do things right, and universities trying to make sure it all gets handled properly. And she's sitting there, she's worried about, is somebody going to get shot? I've got students climbing up on these balconies over here that were stable. We got to get them off to make sure those balconies, the students had walked up on these balconies to see what was happening. She's worried about making sure those balconies don't collapse, so she's directing people to go do that. She's worried about how the police are handling it. She's monitoring everything. And here I am, this idiot professor, marveling from an academic sense about how all this is working. And then I'm like, all right, I'm going to go back to my office. And she has to sit there and deal with this. So I do feel for the administrators who have to deal with this in real time, including the University Council, who's looking at all this risk and trying to figure this out. It was enough for me to just take it all in, marvel at it, and then go back and talk to someone in the press about it.
So on your question, as both Stephen has pointed out and Tim did as well, a lot of the protesters are interested in things other than or in addition to affecting legislative change. They're looking for solidarity, they want to be heard, they want to be with like-minded people, they want to be on the news, whatever. And the final thing is, to be fair to the protesting students, nominally their audience often was the university administration and or the University Board of Regents with regard to investment policies. Now, I think that was reflected a relatively unsophisticated instinct about the way financial decisions are made and how much investment decisions could be influenced by any kind of student opinion. But they may be faulted for not being sophisticated about how that part of it worked. But their audience wasn't just DC, their audience was more local in a lot of these instances.
Okay, Tim, last time. Quickly say something about the efficacy point, right, which people have raised about public protests for a long time, right? What's the point? It doesn't work. It really should be inside the halls of Congress, or state legislatures. And I think that's an important point, but the argument that you should do it this way instead of that way, it's sort of an argument against public protests writ large. I mean, why have a Black Lives Matter protest? You really should be inside the halls of the state legislature or Congress if your concern is police violence. But the only way to change the conversation, right, is to make people stand up and take notice. And the largest public protest in the history of the United States certainly changed the conversation, whether it changed immunity doctrine or other things that the protesters were concerned about. I think that's a fair question. But I don't think I would sort of, discount a public protest as unefficacious. I mean, there's academic literature that raises the rate of voting, right? It engages more people in public issues. So there are just different values in public protest, I think, that should be considered.
Of course, you can get public notice and all the attention you like, or you can try and notice and as much attention as you want to try and get, but it may not turn out to be the attention you wanted. In other words, you get back on. And that may well be another phenomenon that we haven't talked about, but is certainly exists out there. I have a note that tells me, and I'm surprised with this, that our panel is not all day long. I thought for sure it was going to be all day long. But, so I hate to do this, but I think I have to wrap things up and thank our terrific panelists.
We're now going to take about a 15-minute break. If you guys could try to be back in your seats at about 11:15 for panel 2, that would be great. There's water, tea, coffee in the back of the room for y'all. See y'all in about 15 minutes. Thanks.
I think I'm good. I guess. Great purse. This was my IMW sat purse. Are you done with today? Good luck. It's going to be good. It's going to be great to have you. I did not. I said. I just like to sit there and just like.
You bet.
All right, we're about to get started with the second panel. Make your way to your seats. I wanted to note that fortunately we have one of our panelists on the first panel, Lindsay Brand, was unable to make it on today. So she was supposed to be on panel one, but she was sick and couldn't make it down here. But we appreciate the fact that she's willing. Also, real quick, just note again, there are baskets right over here, and this table over here in the corner, as well as out by the registration table. If you would write down your questions on pieces of paper on your tables and deposit them into the baskets, that would be great. And all right, we'll get started with our second panel. Moderating this panel, Faculty Speech and Academic Freedom, is Professor Bill Marshall. He is the William Grant Keenan Jr. Distinguished Professor of Law here at UNC School of Law. And he will go ahead and introduce our panelists. Thanks so much.
Thanks so much, Jack. On behalf of the panel, first of all, let me once again congratulate Jack and Benjamin for organizing and putting on this program, and thank all members of the First Amendment Law Review. Really terrific job. On behalf of the panel, I also want to point out that our keynote speaker today, Professor Papandreou, had only 2 weeks to put together that wonderful talk. I mean, she stepped in at the last moment and really is to be congratulated. And I'd like us all to give another applause for her. Consistent with what you talked about earlier, the question of faculty speech and academic freedom is one that involves a number of very difficult questions. The first is, what is academic freedom? The second is, does it have any First Amendment aspects to it at all, or is it just some sort of norm that we talk about rather than having any true legal effect? And third, what are the parameters of it? Next term, I'm supposed to teach a class on church and state. If I start teaching corporate tax, can I be sanctioned for doing that? Both because it's not the subject I'm supposed to teach, and second, and even more importantly, I don't know the damn thing about corporate tax. How broadly do we define the parameters? When I was asked to moderate this, they gave me a list of who was going to be on the panel, and I was just overwhelmed with how wonderful the folks we have out here. I remember, I forget who it was, but I saw an awards program recently where I think it was Steve Carell said, there was somebody that he was introducing, I think it might have been Paul Simon, and he said, this is the greatest songwriter of our generation. And then he looked over, and I think it was Randy Newman, and said, "This is the greatest songwriter of our generation," etc. We have 4 people here who are the greatest experts on faculty speech and academic freedom of our generation. David Ravan at the University of Texas really is the foundational scholar on the subject. Amy Gaia is bringing all kinds of new insights, and not to just what academic freedom is, but the pressures that are being raised against its recognition that are currently taking place. Tyson Langhofer is one of the leading litigants on issues of faculty speech and academic freedom. And Caroline, my longtime friend Caroline Corbin, is one of the great experts on the combination of free speech rights and equality issues that have particular resonance when we're talking about questions of academic freedom. I've just introduced them in the order that they're going to speak. I'm not going to spend any more time reading their credentials because that will take the rest of the day, and I'm just going to turn it over to David.
Great, thank you, Bill. Can everybody hear me in the back? Everything's good. So I want to focus in my brief comments on the status of academic freedom as a First Amendment right. You know, academic freedom was defined as a professional norm and outside the legal system in the founding document of the American Association of University Professors, the AUP, in 1915. And the concept of academic freedom is well developed there. But the United States Supreme Court did not even discuss academic freedom until the 1950s. And the court first recognized academic freedom as a First Amendment right in a case called Sweezy versus New Hampshire in 1957. And in that case, very interestingly, I think, the court identified both quote-unquote academic freedom and quote-unquote political expression as First Amendment rights, indicating that they were different, though both covered by the First Amendment. And 10 years later, in a case called Intermission versus Board of Regents, the Supreme Court, very famously, in retrospect, referred to academic freedom, quote unquote, as a special concern of the First Amendment. How is academic freedom special? Right? How does it relate to free speech generally? Those questions have not been answered in the subsequent half century since these famous cases. I want to reiterate a point that's been made already this morning, which is that, of course, the First Amendment applies only to state action. And just to specify that a little bit more, this means that professors, including at private universities, can raise academic freedom claims against legislation, against state regulation, against state executive activity that affects them because there's the state action. Also, professors at public university can raise First Amendment claims against administrators and regents at those public universities. They're public, there's the state action. Here at the University of North Carolina, for example. But at a private university, say Duke down the road, a professor cannot raise a First Amendment claim against the administration or board of trustees there. So that's a very important point to remember. Also important to remember that state action can affect professorship at private universities, but state action does not apply to the interaction between professors and administrators at private universities. As people have already mentioned, many private universities voluntarily accept for themselves what the First Amendment requires of public universities. And I want to give an example from my own experience long ago as a student at Stanford Law School. My first year in law school, Stanford was in the process of bringing dismissal charges against a tenured professor for allegedly inciting students to violent activity at an anti-war rally. And the administration of Stanford informed the faculty committee that was processing this charge that it should use the First Amendment standard for what constitutes incitement from the recent Brandenburg case, even though Stanford was a private university and didn't have to do that. Stanford did not want to be perceived as affording less free speech than Berkeley across the bay had to because it was a public university. I want to give you a sense of the many, many decisions in the last 60 years that have discussed academic freedom as a First Amendment right. There have been hundreds of cases that have asserted academic freedom is a First Amendment right, but the decisions are inconsistent with each other, and their reasoning, to the extent it exists at all, is unclear. So at the very core, academic freedom as a First Amendment right has covered the content of the scholarship and teaching of professors relevant to their scholarly expertise. Some decisions have limited the First Amendment right of academic freedom of professors to content. So in one case, a former law professor, then a judge on the Seventh Circuit, Frank Easterbrook, rejected the claim of professors that a state law prohibiting the use of aborted fetal tissue in research violated their academic freedom as researchers. One professor, for example, was using aborted fetal tissue to study Alzheimer's disease. And Judge Easterbrook said, as he would in his distinctive way of writing, this academic freedom claim is a quote-unquote non-starter. No professor was prohibited by that law from writing or saying anything, Easterbrook reasoned. Other courts have applied the First Amendment right of academic freedom more broadly to include access to research material, to include confidentiality in one's research material while writing one's scholarship, protecting confidential interviews through a First Amendment right of academic freedom. Some courts have extended the First Amendment right of academic freedom of professors to what has been called intramural speech by professors about educational policy issues at universities. That's considered to be still within a professor's expertise, though not as core as speaking within one's academic discipline. So, to summarize the law, and I have a book too on academic freedoms called From Professional Learn to First Amendment Right. Writing this book, I've read really thousands of cases. I feel confident in saying that the American judiciary has clearly recognized academic freedom as a First Amendment right, but has never really justified it, and its meaning is unclear. Okay. Making things even more complicated, courts have often not referred to academic freedom in cases where issues of academic freedom have been clearly presented. And to give you just one example, as many of you may know, cases challenge state laws that prohibited teaching evolution or that required teaching quote-unquote creation science. And professors claimed that those laws violated their academic freedom Some lower courts agreed, but when the case got to the Supreme Court did not even refer to academic freedom, but rather struck down these laws as unconstitutional as a state establishment of religion. The court finding that the motivation of the legislators was to promote their religious views. So academic freedom clearly was posed in those cases, not addressed, indicating that academic freedom is not as established as a First Amendment right as some people may think. Okay, Mary Rose mentioned this morning, I want to elaborate briefly, that many courts have applied government speech jurisprudence to the academic speech of professors who are public employees, government employees, and they've applied this law of government speech jurisprudence, one, without recognizing academic freedom issues at stake, and more importantly, often by, in effect, denying academic freedom through the application of employee speech jurisprudence. For example, as Mary Rose said, to be covered by the First Amendment, speech by a public employee must be about a matter of quote-unquote public concern. Decisions have rejected claims by professors that their speech has been protected by the First Amendment because courts have said the speech by a professor is only quote-unquote abstract theorizing or quote-unquote designed to make the university better or quote-unquote complaining about the denial of tenure based on a violation of academic freedom. Courts have held that this speech is not about a matter of public concern, it's only about a matter of private concern, and therefore is not protected by the First Amendment, even though clearly, don't you think, academic freedom issues are raised. Other courts have found this kind of speech to be about matters of public concern, so the decisions are divided. On the pursuant to official duties test, also mentioned earlier, I was general counsel of the AAP when this case was litigated, and we opposed the test in general, but particularly we were worried that the application of official duties test to professors would undermine the protection of First Amendment academic freedom that had been developed over decades. What are the official duties of professors? At their core, scholarship and teaching. And lower courts, as you heard this morning, have been divided about whether there is an academic freedom exception to this official duties test. So I want to close by just giving my own view of what academic freedom should mean as a First Amendment right. In my view, one has to differentiate academic freedom from free speech. If you can, there's no reason to have a distinctive First Amendment right of academic freedom. But then if you do differentiate academic freedom from free speech, you have to explain why academic freedom as a distinctive right fits within the First Amendment. And in my view, the function of professors and universities in the production and dissemination of knowledge provides the basis both for differentiating academic freedom from free speech and for connecting academic freedom to the First Amendment. The value of the production and dissemination of knowledge has been recognized as a First Amendment right in many contexts, and professors cannot do their job in producing and disseminating expert knowledge if they can be punished for doing so when others disagree or are offended by or hurt by the academic conclusions they reach. As long as professors meet academic standards, they should be protected distinctively, but only to the extent that they are dealing with academic issues. So in my view, academic freedom as a First Amendment right does not apply to the general political expression of professors. The general First Amendment right of academic freedom that covers all citizens applies to political speech by professors too. So I'll stop there and look forward to hearing your questions later, and also my fellow panelists' questions.
Hi everyone, I'm delighted to be here because I too wrote a book on academic freedom, and it was 15 years ago. It's a book called The Trials of Academe, the New Era of Campus Litigation. And it looked at academic freedom cases, and I made the argument that courts were responding negatively to colleges and universities, and I joined others in suggesting that there had been this movement, this shift toward the legalization of higher education, and that actually was a bad thing. I was pretty shocked when I did the research for the book 15 years ago. I looked at cases and students were upset, faculty members were upset, and the university was using lofty academic freedom language in unusual or tangential ways. They would argue, for example, using Supreme Court language that academic freedom is of transcendent value to us all. And the response, at least as time went by to 2009, was that courts seemed downright hostile to this. So they didn't like this use of language by universities very much. And my theory was simple, that colleges and universities were acting increasingly like businesses. And they were acting like businesses in hiring adjuncts and not tenure-track faculty in order to save money. They were hiring an extraordinary number of administrators, and they were also treating students like consumers. And so there's some pushback to that. And courts, meantime, were responding to this businessy trend by treating universities like McDonald's and shifting away from this deference, this deferential language that had existed previously. And I'm going to give you one of the examples from the book that I wrote 15 years ago. There was a medical student from Florida in the early 2000s who failed his final rotation. His assessors took a look at how he treated patients and others. He hadn't reviewed patients' charts. He hadn't treated all patients with respect, and he missed a very easy, simple case of diabetes. The medical school decided that he did not have the requisite skill to be a physician, and they dismissed him. So the student sued. He argued, in effect, a breach of contract claim. The school, in its materials, had promised that students would spend 4 years and the 4-year curriculum would lead to a diploma. The university, of course, argued in part that it had the academic freedom to decide who should be a student there and who's worthy of calling themselves then a graduate. Now, maybe you know from what I just said where this is going. The judges sided with the expelled student. Here's what one wrote in condemning the behavior of the medical school. Judicial deference to universities is now disfavored because deference no longer represents community values. So ultimately, a jury ordered that the medical school pay its expelled student $4.3 million. And that amount of money was for his lost tuition and lost time, but also for his lost earning potential. So there are similar cases involving faculty where the university made an academic freedom argument and the court didn't like it very much. including a professor who won more than $200,000 after his university suspended him for using graphic sexual depictions to teach freshmen how to write a technical report. That was 15 years ago. So zoom ahead to today. For this talk, I decided that what I would do is take a look at what has happened since those sorts of decisions and back from previous times. I expected to find two things in my review of case law that mentioned both academic freedom and colleges and universities. First, an increase in the number of such cases. Second, all the more increasing rejection by courts of the university as a hallowed, hands-off place. I was correct about the increase. The number of such court decisions has skyrocketed, up from an average of 24 cases per year to 72 cases per year over the past 4 years. That spike since the year 2020, it includes nearly 15% of all such cases ever decided, and it could well relate to COVID and the many direct and indirect ways that COVID affected campuses and concepts of academic freedom. But my second theory, my expectation that courts would continue and even beef up their anti-university sentiment, I don't seem to be correct there. And I'm basing what I'm going to say now on the approximately 300 cases that I reviewed for today. First, there could be, and I'm saying could be here, the beginning of what I might call a return to judicial deference to colleges and universities, but without the poetic language of the past. In other words, it seems that as colleges and universities have shifted toward that more business model, at least some courts have come to side then with that idea. It's true that not all cases go this way, and there are some recent ones, of course, that you've heard about already and will hear later today that don't. But I was quite surprised at the number that did, with 3 main takeaways. First, by my read, faculty are not winning cases against universities in the ways that they once did. Take the example of cases involving collegiality. In the past, in language and in holdings, courts seem to be willing to investigate the possibility of sexism or racism or some sort of retaliation when a university refused to tenure someone or fire them for their lack of collegiality. Now, in the past 4 years, courts seem much more willing to accept an argument that a school benefits from getting rid of someone, even someone who publishes a lot, even a tenured professor, if they can't get along with others or a rabble-rouser in some way. Second, colleges and universities seem to be winning even when faculty members argue that they have academic freedom more explicitly. Those faculty members might say, for example, that they have the constitutional right to teach in a certain way, or use a certain book, or to research what they'd like. But those arguments fell flat over the past 4 years, at least in certain cases. One court, for example, pointedly criticized a professor's ramblings, used that word, while rejecting his academic freedom argument based in part on his teaching style. Third, one sort of case that colleges and universities seem to lose at times is when COVID-related matters involving students were at issue, even when they tried to argue that the plaintiff's claim is ultimately one of educational malpractice and therefore barred by academic freedom principles. So if my sense, after reading admittedly qualitatively these cases from 2000 to today, if I'm right that the reason that courts are accepting university arguments and in effect are rejecting faculty members' academic freedom claims, why they're doing so is an intriguing question too. What I think, at first I think it's possible that as university teaching positions become increasingly scarce, people will sue no matter what to get them, even if their lawsuits have little basis. And here some of the plaintiffs were indeed pro se, so they moved forward and made the arguments themselves, and others didn't seem to appeal their losing claim. It's also likely that colleges and universities today settle many more of the viable claims before we ever hear about them too, so I'm reading those cases that they chose to defend. Or maybe that it's that colleges and universities have simply become more honest in defending their business model and recognizing the pushback from academic freedom skeptical courts are less likely to cloak themselves in that way. In 2002, 2 years ago, Barbara Lee found that some federal appellate courts had moved away from deference to the university, and she warned university counsel that academic freedom as a simple defense wouldn't work anymore. Instead, she advised that universities ensure that individuals participating in employment decisions, including faculty, justify their recommendations with solid evidence and careful adherence to policies and procedures. That could well be happening, and courts could well be responding positively to that. Or maybe it's just that courts are thinking less highly of faculty members these days as their squabbles or social media posts make headlines. So where is all this headed? I'm not sure, but these business sensibilities seem likely to continue and remain on campuses for the foreseeable future. First, today, only about 50% of college presidents come from an academic background, meaning that on half of the nation's campuses, someone steeped in perhaps the business world is making the calls. That those calls include the increasing use of AI, and this is a quote, to enable the delivery of lessons and materials conducive to individual learning styles, catering to each student's unique needs and preferences, could mean the end of certain in-person faculty summit in some places, especially as outsourcing continues. Second, academic accrediting bodies are said to be pushing all the more for institutions to prove student outcomes and learning. That can be good for students, but it could be bad for institutions because those numbers can act as provable metrics to support some sort of claim, contractual or otherwise. And third, in the past 10 years, people have started to value higher education less, with those expressing high confidence in it falling from nearly 60% to 36%. Had I been writing about those three things 15 years ago, I would have warned that it meant lessened judicial deference was all the more likely. As one court wrote back then, judicial deference to university conduct becomes increasingly less defensible as bottom line commercial concerns motivate university actions. So I suggested in my book that universities work to educate judges about the university's importance and what it stands for, to prove that universities are deserving of special judicial solicitude. Today, maybe that's working, just not in the lofty academic freedom-focused way I imagined it would, and ultimately I think that's pretty troubling for academic freedom more generally. Thanks.
Good morning. I'm so glad to be here talking about this important topic. I think I'm unique among all the panelists. I have not written a book, and I'm not in the academy, but I'm a practicing attorney doing First Amendment work with the licensing freedom. And my practice consists of defending First Amendment rights of students and faculty at public universities and public K-12 schools. And one of the most contentious and recurring questions over the last 5 to 7 years in my practice, and I think throughout the country, has been whether public universities and K-12 students can force professors, teachers, and students to use the pronouns of students that are inconsistent with the student's sex. And my talk today is going to focus solely on whether public universities can force professors to use preferred pronouns of students. Now, I'm focusing on that issue because, as you've already heard from Professor Papandreou and others, the First Amendment analysis is a lot more complex and nuanced when the government's regulating the speech of its employees rather than the speech of ordinary citizens. So before I get into the specific issue, and I'll try not to repeat too much of what Professor Papandreou said, but I want to lay the foundation by talking about two important foundational First Amendment principles which can underlie this issue. First, the First Amendment only applies to stop the government from taking action against a private citizen who wants to speak a message. It doesn't restrict the government from speaking its own message. The government has the right to choose the messages it speaks, which would include public universities. So how does the government communicate its messages? Well, through its employees. Now, second, when we think about the First Amendment, most of the time we think about it in the context of the government censoring speech. For example, in Cohen v. California, the government punished a Vietnam veteran for wearing a jacket that said after draft. The Supreme Court held that the government violated his rights for punishing his speech. But the First Amendment not only prohibits the government from censoring speech, it also prohibits the government from compelling speech. And the Supreme Court has made it clear for more than 70 years that government-compelled speech is even more damaging than government censorship of speech. So one of the seminal cases on compelled speech is West Virginia versus Barnett, which also deals with compelled speech in the public education setting. So I'll just give you a brief background if you're not familiar. This case was decided in 1943 in the heart of World War II. And obviously many governments, state governments and otherwise, were very worried about patriotism and loyalty to government and things like that. And so West Virginia enacted a law which mandated that every school had a pledge of allegiance that every teacher and student must participate in. As the Jehovah's Witnesses, they believe that they cannot pledge their allegiance to anything other than God, as mandated by the Bible. So Jehovah's Witnesses said, we can't do that. And there were students that were expelled for not doing that, and they appealed it to the Supreme Court. And the Supreme Court, in one of the most eloquent defenses of the First Amendment, said this, that if there was any fixed star in our constitutional constellation, it's that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion. And here's what's important: or force citizens to confess by word or act their faith therein. And they said if there are any circumstances which permit exception, they do not now occur to us. Now, the Supreme Court has reaffirmed that compelled speech doctrine numerous times, including in 2018 in Janus, when they said when speech is compelled, additional damage is done. And then they reaffirmed it just last term, the 303 creative case, which my colleague argued. And so they reinforced that this notion of compelled speech is even more damaging than censorship. So when you take these two principles, they pose an obvious problem. So how does the First Amendment apply when the government's interest in speaking a message collides with an employee's right to speak or not speak a message? That's where the rub lies in this particular issue. And so as Professor Papandreou has indicated, you have initially the two-part balancing test, which Pickering established in 1968. So normally what the courts would do would say, well, is the employee speaking as a citizen on a matter of public concern? If so, then the speech is protected, and I'm going to move on to the second part, where they say, is the speech on a matter of public concern? Or is it a private matter, like just an employment matter? So when the speech relates to any matter of political, social, or other concern to the community, then it addresses a matter of public concern. And that would be protected, so you move on to the second part of the test. And then they're going to balance it, just a facts test. The court's going to look at it and say, is the employee's interest in speaking greater than the government's interest in promoting the efficiency of the public services it performs? In the notion of education, that's delivering an education to the students that are there for an education. So this is how the law stood until 2006, and the Supreme Court decided Garcetti. And in Garcetti, the court added an additional step to the analysis where it said the first step in evaluating the government employee's free speech is to determine whether the speech at issue was pursuant to the employee's official duties. If an employee is speaking pursuant to official duties, there are no free speech rights. If an employee is not speaking pursuant to official duties, then you're going to move on to the Pickering test. Obviously, in response to the concern raised by the dissent, as noted earlier, Garcetti added an important carve-out. The court held that they were not ruling on whether the official duties test should apply to public university professors when the speech at issue was related to teaching or scholarship. So the Supreme Court essentially left it up to the circuits to work out whether Garcetti applies. And to date, I think 4 circuits have looked at this issue, and the 4 have ruled that Garcetti does not apply. So the 4th Circuit looked at it in Adams, a case my colleagues litigated back in 2011, the Deemers case in the 9th Circuit, 2014, the 5th Circuit in Buchanan in 2019, and then the Merriweather case is the latest one in the 6th Circuit in 2021, which is the case I want to talk about because this is one I litigated. So this is, I'll give you the brief facts of the Merriweather case. So Merriweather, Professor Nick Merriweather was a professor of religion and philosophy for more than 20 years at Shawnee State University in Southern Ohio. Until the time that this issue arose, he had had a great tenure there. He was a full professor, had never been punished, and had a great reputation in the community. In 2018, he addressed a male student in class as yes sir on the first day of class, and the student came up to him afterwards and said, I want you to address me using female pronouns. Dr. Merriweather said, well, I'm not sure that I can do that. I'll use whatever name you want, but I don't know that I can do that. The student got angry and told her he was going to get him fired, and eventually filed a Title IX complaint. Now, Dr. Merriweather, the student remained in class the entire time. He got a good grade. There was no disruptions. And Dr. Merriweather tried to work with the Title IX office to work out an accommodation. And Dr. Merriweather said, look, I won't use any pronouns. I'll avoid pronouns. I'll use whatever name the student wants. I just don't want to be forced to say something that I think is untrue or maybe harmful to somebody else. And so the university denied those accommodations. One of the accommodations he asked for, which was mentioned in the opinion, was he said, well, what if I use those, but I put in my syllabus what my views are on sex and gender, and as a statement. They said, no, you can't do that. You wouldn't be allowed to do that either. So he was denied, and they found that he violated Title IX, and it wasn't because of any differential treatment other than declining to use a female pronoun referring to the student. We filed a lawsuit challenging that. The lost in the district court was dismissed on all the claims. We appealed to the 6th Circuit, and the 6th Circuit ruled in our favor. And first it looked at, because it hadn't yet applied, whether Garcetti applies. And the court found that it did. And here's what it said, and some of the key points. It says, when the state stifles a professor's viewpoint on a matter of public import, much more than the professor's rights are at stake. Our nation's future depends on leaders trained through wide exposure to a robust exchange of ideas, not through the authoritative compulsion of orthodox speech. Then it gave a few examples which I think are applicable to think about when we think about what principles are involved here. It said this: if professors lack free speech protections when teaching, a university would wield alarming power to compel ideological conformity. A university president could require a pacifist to declare that war is just. A civil rights icon to condemn the freedom riders, a believer to deny the existence of God, or Soviet immigrant to address his students as comrades. That cannot be. And then it cites Barnett. So then the court moved on to the Pickering balancing test and held that Dr. Merriweather was speaking as a citizen on a matter of public concern. And they ruled that because of this. They said that pronouns can and do convey a powerful message, implicating a sensitive topic of public concern. And in fact, in the Janix case, the Supreme Court ruled previously back in 2018 that gender identity was a topic of public concern. There's lots of debate going on around those issues. So then, it's determined that Dr. Merriweather spoke as a citizen on a matter of public concern. Now it has to balance those interests. And the court really ruled that there was really 3 interests at stake. The interest of students in receiving an informed opinion, professors' rights to disseminate his own opinion, and the public interest in exposing our future leaders to different viewpoints. On that issue, the court looked at it and said the compromise proposed by Dr. Merriweather seemed like a, quote, win-win. Merriweather would not have to violate his religious beliefs by speaking something he disagreed with, and the student wouldn't be referred to using pronouns that the student finds offensive. And so, on that basis, they ruled that the Pickering balancing test favored Dr. Merriweather. And this was on a motion to dismiss, so they didn't rule in his favor, but they ruled that they overruled the dismissal, sent it back down, and eventually we reached an agreement with the university to give them an accommodation and modify the policy to grant the accommodation. So I want to just end with addressing a few arguments that are typically on the other side, to kind of address what the other side would say. Now, one of the primary objections is that misgendering or using a different gender different than what a student prefers is not the type of important speech that we need to protect, such as revealing government misspending or corruption. And I would argue the opposite. I think the notion of who we are as humans, what does it mean to be human? What is sex? What is gender? That is a topic of utmost concern that should absolutely be protected and should be discussed on our college campuses, much more so than even government spending. That's clearly something that should be discussed. But I think we need to be able to have these discussions. In another case that we won in the Virginia Supreme Court on this issue, the court said it this way. It said this is from the Merriweather case. They said that the point in his speech, taken in context, concerns a struggle over the social control of language in a crucial debate about the nature and foundation, or indeed real existence, of the sexes. That is his motive address was the message. And it reflected his conviction that one sex could not be changed, a topic which has been in the news on many occasions. So it is a topic that I think is worthy of protection. Secondly, as the allegation of misgendering. None of my clients that we've ever represented is asking to be able to affirmatively use any pronoun. They're asking simply to avoid the use and use a name, first name or last name, that the student doesn't object to. They're just simply saying, I want to just remain silent on this. I don't want to express an opinion that I think is incorrect. And so there isn't an allegation in cases involved of an actual, using a term that's offensive. They're just wanting to avoid the use of that. And then the third thing is they're saying, well, you're engaging in discrimination. So my clients, they all desire to address their students equally. They desire to address their students based upon sex. Some students object to that. And they say, if you object to that, I'll modify my language to avoid any sex-based language. I just don't want to use something that I think is incorrect. So they're not discriminating. They're not trying to treat any student differently. They're simply trying to treat them all the same. But if a student objects, they'll even modify their language to accommodate. They just don't want to do something that would violate their conscience. And finally, the issue of you can't create a welcoming environment if you don't do this. And I just think, my experience, I've represented teachers that have been litigating this case for a very long time. It's not true. The teachers I represent are beloved by their students. They can create that. I think we can create an environment where even we talk about really tough topics, but we do it in a way that's respectful, that recognizes the dignity of every person, even if you disagree on things that are really at the core of who we are. And that's the type of protection we're looking for. And finally, I'll just add that we need to be very careful about this topic, because our position is that no professor, regardless of what their views are on sex or gender, should be forced to say something they disagree with. So as we've seen in Florida has some laws where it's trying to compel teachers and professors to speak certain messages on certain things, and some teachers that believe in the use of preferred pronouns and so forth, they're being compelled to speak messages they disagree with. And it's our belief that government shouldn't be able to compel any message on that topic. It should apply across the board. And so I think we need to have a policy, a principle that does apply across the board, regardless of our views on this difficult topic. So I welcome the discussion as we proceed. Thank you.
All right, let me make sure. Okay, so all right, so I haven't written a book either, but I am in academia, and I was actually asked to address this question of whether professors have a free speech right to misgender the students. So I will. So in a nutshell, I argue that professors do not have a free speech right to deliberately misgender students in class. They don't have it as a matter of current doctrine, and nor should they have it as a normative matter. So a little back. In the United States, sex is assigned at birth, and it's based on external genitalia. Sex is actually a lot more complicated than that, but this method works for most people. But not everyone. For many, the sex assigned to them at birth does not match their gender identity, what they feel, what they know their gender to be. And for example, among the students using the Common App for college, 2.2% of them identify as either transgender or non-binary. And transgender kids have a really rough time of it. They have, for example, distressingly high levels of depression and suicide. Studies, however, show that gender affirmation alleviates some of the mental health risks of transgender children. So, for example, one study found that for each additional environment that affirmed a student's gender identity, and in this case, by using correct names and pronouns, their depression and attempted suicides fell rather significantly. And gender affirmation in the classroom presumably also improves educational outcomes, right? Obviously, you can focus better if your mental health is strong, and if you're not anxious or humiliated in class, you're more likely to participate and you're less likely to cut. So the first point I want to make is that gender affirmation at school and in the classroom is really crucial to the well-being and education of transgender students, right? You're like, oh, what about the free speech rights of the professors in the classroom? Generally, government attempts to control the content of someone's speech are presumptively unconstitutional. They are content-based regulations of private speech that trigger strict scrutiny, rarely pass this. After all, the whole point of the free speech clause is to prevent the government from controlling what we say and what we hear. In contrast, content-based regulations of government speech, as opposed to private speech, trigger no free speech scrutiny whatsoever. So under the government speech doctrine, which several people have mentioned, government speech is outside the ambit of the free speech clause. Right? So the free speech clause protects private speakers from the government, not the government from itself. Why am I talking about government speech? Because under existing doctrines, how teachers address their students is probably government speech. And I'm talking about professors at public universities. So when a government employee brings a free speech challenge about speech at work, the first question is whether the speech was spoken pursuant to official duties. That is it speech uttered in the course of fulfilling your ordinary job responsibilities? So it's not speech at work or speech about work, it's speech that is the work itself. And if it is speech pursuant to official duties, it is considered government speech and outside free speech protection. And professors teaching is pursuant to their ordinary job responsibilities. In fact, that lies at the core of their responsibilities. And how they address their students is part and parcel of teaching. So under the existing Garcetti rule that speech pursuant to official duties is government speech, teachers should lose. They are teaching essentially the government's own speech, and therefore the government has complete control over it. But wait, right? What about academic freedom? This is an academic freedom panel. And the Sixth Circuit did in fact hold that academic freedom protected a professor's right to misgender his students. So here's the thing. It is true that Garcetti acknowledged that there may be an academic freedom exceptions, but it has not yet told that there is an exception. So again, I'm only talking about current doctrine. current doctrine now is it's an open question whether there is an academic exception to the consecutive rule. And furthermore, to the extent that there is such an exception, most courts have found that the protection attaches to the institution rather than to the professor. At least when the two clash, usually the institution triumphs. Again, I'm only talking about the doctrine as it exists. And in any event, right, even if their speech is not, even if their claim is not automatically used because it is speech pursuant to official duties, it still has to satisfy the other two requirements, which is that it's on a matter of public concern and that it doesn't unduly disrupt the workplace. And really, there's no question that the topic of gender identity is a matter of public concern. However, using the wrong pronoun is not a discussion of gender identity. It's not even an invitation to discuss it. Rather, it is a professor imposing a view they believe is not subject to debate. So I think there's a real question whether a professor misgendering a student in class satisfies the matter of public concern requirement. Finally, does misgendering unduly disrupt the workplace? Well, here the workplace is the classroom. And so the question is, does this undermine the goals of the classroom? And obviously, the primary goal of the classroom is to teach the students in it. And misgendering undoubtedly creates an unwelcome environment for the students in the classroom. And so yes, right, it does disrupt the smooth functioning of the workplace, especially because the students are target audience. Indeed, it may not only undermine the role of teaching, it might also undermine the legal requirements not to discriminate by creating a hostile school environment. All right, that's describing the application of the law as it exists. But for that, I want to talk a little bit more about academic freedom. I also say that as a normative matter, academic freedom is not designed to protect something like deliberately misgendering the students in your class. The American Association of University Professors, their view of academic freedom is the one most widely adopted. It's the one that your law school has adopted, it's the one that's mine. And they absolutely support academic freedom for individual professors in their scholarship and teaching. As do I. So again, I think absolutely professors should have academic freedom in the classroom. But even the AAUP does not view academic freedom as carte blanche for professors to say whatever they like in class. There are limits to it. Academic freedom is not coextensive with the free speech clause. And I want to just repeat it because I think this is a really crucial point. Academic freedom is not the same thing as free speech rights. It has a very particular purpose, which is to protect the search for knowledge, and I'm thinking for teachings, protect the search for knowledge from professors and students. Right? And it's going to protect speech that advances that purpose. And so, for teaching, academic freedom as envisioned by the AAUP, which is again an organization that has really worked hard to establish it as a norm, it protects teaching on the professor's area of expertise, right? Not any random topic that they feel like opining on. And for most professors, you're a math professor or a history professor, science, right? No, that's not right? The topic of gender identity is not their area of expertise. And so just like academic freedom would not protect a French teacher's right to talk about how the earth is flat, right? I don't think academic freedom protects a math teacher's right to say that there are two genders that are established at the moment of conception. And the second point about academic freedom is that it's always been understood to come not only with certain privileges, but also with certain responsibilities. And one of those responsibilities is towards one's students. And I think at the bare minimum, that includes creating an unwelcome classroom environment for your students, which deliberate misgendering absolutely does. And indeed, it might even contribute to an illegal hostile classroom environment. In fact, it's really contrary to every educator's ethical obligations that at the minimum, you treat your students with respect. And even if you want to put this more in academic freedom, it's the freedom to protect the generation understanding the growth of knowledge. It protects not just professors, but also the students in the class. And so I think academic freedom, it puts limits on what the professors may do in the classroom, and it also provides some protection for students and their ability to learn in the classroom. And that's why I'm taking the very odd position as a free person to say, I think in this situation, in terms of deliberately misgendering the students in your class, I don't think their free speech recognizes such a right, and I don't think the free speech clause or academic freedom should recognize such a right. Thank you.
Well, at least there's no controversy on the panel. I sort of want to start off by asking a couple of broad questions and then getting to the more specific issues that were raised by Tyson and Caroline. First of all, David, did you buy Amy's thesis that the more universities adopt a business model, the less they are entitled, or the less they might be perceived to be entitled to have any aspects of academic freedom, or that they are undercutting the claim to academic freedom by looking more to the bottom line than they are by looking to what you call the value of producing and disseminating knowledge?
Well, I'm not sure fully what the business model entails, but to the extent that the business model is inconsistent with the search for knowledge and the dissemination of knowledge, to that extent, universities are not protected by academic freedom, because academic freedom is designed to protect that. I could imagine some business models that do not jeopardize the production and dissemination of knowledge. I can imagine others that do. So it's not the business model per se, it's the potential deviation from the purpose of the university that justifies academic freedom, which is the production and dissemination of knowledge.
I think that's right. But just the problem is that judges are seeing, or we're seeing, especially universities, as being more business-like as they attempted to cloak themselves in this lofty language about First Amendment freedom, academic freedom, and they were responding negatively to it. And so it is intriguing that now we have litigators defending colleges and universities, top litigators, suggesting that universities move away from academic freedom arguments because they weren't working, and just to focus in on the reasons why the person was fired, as opposed to attempting to argue that they have the First Amendment right or an academic freedom reason for, or supported reason for doing so.
Tyson, let me get to a more specific question for you. If a biology teacher said that they didn't want to teach evolution, And their school said, that's part of the basic biology curriculum, you have to teach evolution. Do you think the teachers should be protected if they disobey the command of the school to teach evolution?
Absolutely not.
Why is that?
Well, because clearly the schools, both K through 12, both universities, do have the ability. They do, as Professor Porter talked about, there is an academic freedom component to universities being able to determine their curriculum, this course of study, and they clearly have that, and they can say, you're going to teach this as a professor, this general course of study, and you're going to teach it kind of from this perspective. Here's the textbook we want you to use. What they don't do, and we know this, they don't tell the professors or the teachers, here's the script you're going to read from. They don't do that. They don't dictate every word. Clearly, one of the reasons we like some professors and teachers other than others is how they teach it. They teach it in a different way. They communicate in a different way. They relate with their students in a different way. That's all individual speech, and everybody knows that. Even young students know that certain portions of that speech in class, even though the teacher's in class and being paid to be in class, that's the teacher's personal speech. They say, hey, did you see the Chiefs game this weekend? Yeah, I'm glad they beat the Bills, which is going to happen this weekend. So, but that's their personal speech. So I absolutely agree that universities have the ability to determine the course of study. What I don't believe, though, is that they have the ability to dictate exactly what every professor says in class. And I'd be surprised to learn that any professor here would think that they do have that right, in this context.
Well, why isn't a school just saying you should address a student by whatever gender that student wants to identify as a kind of direction that's the same thing as you have to teach biology? You have to teach evolution, you're going to have a religious objection to that particular.
Well, as Professor Porter pointed out, a math teacher is hired to teach math, not gender. So that's contradictory if you're saying that they're saying now that's part of the curriculum because we say we believe this about gender. So and again, what we're talking about here is not that every one of my clients they're not asking to say anything. They're asking to remain silent on a topic that they were not hired to teach on. If they were hired to teach gender studies and they had a different view than the textbook and that they were hired to teach, they wouldn't have the right to do that. But they do have the right, and again, I think you see this when you look at the professors' different views on the Florida laws. People, I see academics with different views on Florida's laws than they do on my clients, primarily because they're taking a different position. And I think that we should be taking a consistent position that the government can't compel anyone, regardless of their views on sex and gender, to state positions about sex and gender. And let me say one other thing about the topic of compelled speech that we haven't, and I didn't really get a chance to talk about it. There are, even under our study, there are exceptions where the government cannot compel speech. And I'll give you an example. Jack v. Burns, the case out of the Second Circuit. In that case, a police officer was out at a stop. He saw one of his officers beat somebody that he was arresting, and he wrote his report about it. His boss came and told him, change this report. He said, no, I'm not changing it. That's what I saw. That's part of his official duties. He was fired for that because he wouldn't do it. Jack v. Burns, Second Circuit, said, no, it's his official duties, but you can't be forced to lie. The government even has limits on what it can do from an official duty standpoint. And so from that standpoint, there are limits to what the government can and can't do, even in the official duties context.
Let me ask you a different kind of hypothetical. Let's assume that a school board says, look, teaching evolution is, a lot of our students really find it offensive to hear about the theory of evolution. They feel alienated from the classroom when they hear that. So therefore, we are going to prohibit all of our biology teachers from teaching the theory of evolution. And a teacher, we'll call it Stokes, wants to teach evolution anyway. Would you say that person can be sanctioned for teaching evolution?
There's this sort of what's the answer under existing law and what I think the answer should be, right? So again, under existing law, they probably could not prevail because it would be speech pursuant to official duties and they would lose. The teachers. On the other hand, the free speech clause is not just, the free speech clause, just like academia is about the production and dissemination of knowledge, both the creators and the recipients. Free speech is not just about the speaker, it's also about the recipients of the knowledge. It's about the free flow of information. And so while the teachers and government employees may have their lawsuits stopped in the tracks by the very unfortunate Garcetti decision, which I totally don't agree with, I'm just speaking as a matter of existing law. Students might have a free speech challenge. There are some limits to what kind of restrictions the government may place on what has previously been taught. And so there is the one case that the Supreme Court decided involved the school board removing books from the library. And the court was like, the students had the right to challenge it. So the school board does not have absolute carte blanche to censor as far as the students go. But as far as the teachers go, under existing law, I think they have a harder challenge, although they could certainly write op-eds and do things outside the classroom, but they wouldn't have a free speech claim. Should they have a free speech claim? Absolutely. As I said, I think that professors should have some academic freedom protection. And so the question then is teaching evolution in a biology class the kind of thing that academic freedom should protect? And if you're a biology teacher, and that is in your area of expertise, then I would say the answer has to be yes.
Well, I just feel what you're saying is contradicted by hundreds of lower court decisions that recognize academic freedom as a First Amendment right. That's the positive law. That law is challenged by Garcetti, but as has been pointed out, even in Garcetti, there's this reservation of the issue of whether the official duties test should apply to the teaching and scholarship of professors. So I think it's how should I put it, overreading, speaking euphemistically, of Garcetti, to say that it prohibits teachers from expressing their own views about teaching and scholarship because that's their official duties. Garcetti leaves that open. Lower court decisions are divided. Ever since the 1950s, hundreds of courts have protected the First Amendment rights of professors as an academic freedom right.
Yeah, I totally would not mind being wrong about that, because I think it should be. My sense, though, in the cases that I saw, was that it was not. So,
please read my book and the hundreds of cases, and really, the hundreds of cases cited in the pen.
I guess my sense is I think Garcetti overruled this. So that may be how we may be reading the effect of Garcetti. Yeah.
I want to add one other wrinkle to this to dive down and show how important this issue is. It's not limited to pronouns. When we start censoring views about sex and gender, it impacts scholarship. And let me tell you how. We currently represent Dr. Alan Josephson. He was the leader, the division leader of child and adolescent psychiatry and psychology at University of Louisville for 16 years. He'd been in academia for 40 years. He went and spoke in 2017 at a panel on Heritage Foundation about the treatment of children with gender dysphoria. He essentially, you can go look at it online, it's still online. He essentially said, look, when children are struggling with gender dysphoria, we need to first learn what's causing this, what's going on in there. Are they depressed, are they anxious? We can help them before we move to medical procedures. That's what he said. Within 7 weeks, before that, he had perfect marks on his reviews for the 3 previous years. Within 7 weeks, they demoted him as the director. Why? Because they said several colleagues disagree with your views on the treatment of children with gender dysphoria.
and within a year and a half, he was fired. All right, so we're not just talking about the issue of, it's not limited to pronouns, it begins to seep into academic scholarship, and we're dealing with what is the best way to treat children with gender dysphoria. And I think that is an important topic that can't be censored, and so when we start censoring that type of stuff, it will impact scholarship and teaching. It's not just limited to address.
I'm interested in how many cases you are handling, and also how you decide which cases move forward. How many do you decide not to stick on because you think they're losing?
Oh, I just want to be clear. I'm talking about how the professors talk to their students. I'm not talking about their own research. And just to be clear about what was going on in the classroom, is the professor was addressing all the other students with an honorific of Ms. or Mr., except for the one transgender student who did not receive that, who only got called by their last name. And I guess, you know, I'm a professor, I'll try to come up with an analogy. Imagine that the professor addressed every student in the classroom with an honorific except the one Asian student or the one Black student. That was actually what was going on in the classroom. And I guess I would also say that I don't think calling someone by their name is necessarily, I'll make it that as
You're asking specifically about how many cases we're handling on the pronoun litigation?
Or just generally, I'm very curious about how many professors have come to you and what percentage of cases you end up taking and why you take those cases. Just out of curiosity and my own interest in campus litigation.
Sure, I don't know the numbers on that. I mean, obviously, there are a number of factors that will go into, one, whether we take a case, two, whether it goes to litigation. After Dr. Merriweather, we worked for over a year to try to actually work through the Title IX office and get it right. We didn't want us to, like, it wasn't in his interest. He had no desire to sue. Within 20-some years, we tried to get them to work in accommodation. So our goal in general, because professors aren't there to sue their universities, they're there to do their work. Dr. Josephson didn't want to get fired, he just wanted to do his work. So, how many you go to litigation, what are the factors? I mean, obviously it depends on the context of the situation. We've got limited resources, so we look at where are the pressure points in academia. And then we try to look at that. And I think here, clearly, one of the pressure points in academia right now is gender identity and how to deal with that in every sphere. And so a lot of our litigation is around that. But again, we stand for the proposition that would support professors on both sides of this issue. This isn't a partisan issue in our mind. Our mind is that we need to be able to speak freely about this issue overall. And obviously, and I'm talking about personal rights, but we absolutely believe in treating everybody with dignity and respect and not disrespecting anybody, but sometimes when we have difficult topics on difficult issues, people are not going to be happy about that. They're not going to feel the same way, but I think we can do it in a way that's still respectful, and that's the goal that we're trying to put forward is a principle that protects everyone.
Okay, let's move to the broader question. One of the questions from the audience is, I think it's a great question, who holds the right of academic freedom? Is it the individual or is it the institution? And does this answer change in the context of public universities?
Great question. The answer, as a matter of positive law, is that both individual professors and universities as institutions have academic freedom, according to judicial decisions. The initial recognition of academic freedom as a First Amendment right was in the context of litigation by professors. But later decisions, starting with Justice Cowell's pivotal opinion in the Bakke case, identified academic freedom as a First Amendment right of institutions. And that First Amendment right of academic freedom by institutions has been recognized in many contexts. Dismissing a student for poor academic performance, academic freedom of the institution in making decisions about appointment and tenure. So both have academic freedom. In some cases, those rights conflict. What if a professor denied tenure said, "University, you've denied me tenure in violation of my expression of academic freedom upon a legitimate issue within my field." And the university responds by saying, "Judge, one of the four elements of academic freedom recognized by the Supreme Court, derived from a statement in South Africa, is that the academic freedom of the university includes the freedom to select its faculty." There's a conflict. There are ways for courts to resolve those conflicts by looking at the evidence. In one case, the complainant was able to prove she had written 2 books that she was denied tenure. This was over sex discrimination, but the same thing could happen with respect to academic freedom. She had written 2 books. Male professors awarded tenure in the last year or 2 of her denial had written no books. Is that evidence of sex discrimination? The court said yes. Similarly, a professor could indicate evidence of violations of academic freedom. The university would have to disprove them. So it's complicated, it's hard to do. There are these conflicts and they need to be resolved.
And I'll add that students also have some aspect of academic freedom too, so the freedom to learn and the freedom to listen. So there's a third player on the academic freedom scene.
Let me just say, just this a survey of a case law, which I've done, the student right of academic freedom, alleged student right of academic freedom is a First Amendment right. So it has been based on student freedom to learn, but it's been much less recognized, much less developed. I think it would be hard to assert firmly that even it exists, unlike, I would say, the First Amendment academic freedom rights of professors and universities, which are clearly there. I believe there's strong arguments to be made for student rights of academic freedom, but they haven't been recognized by the courts, at least not nearly to the extent as First Amendment academic freedom rights of professors and institutions have been.
Do you want to weigh in on that? Well, let me get to another one of the questions here. Does the free exercise clause complicate these questions in any way if what the teacher is doing is compelled by their religious belief? And following up on that, does Kennedy versus Bremerton influence your thinking on how courts might resolve this? Kennedy versus Bremerton is a case from 1.5 years ago in which the court held that a football coach had a free speech, not free exercise right, but a free speech right to go to the 50-yard line at the end of a football game and have a very publicly visible prayer. So, Carol, let me ask you if you also weigh in religion clause.
Right. So, so the challenge in that case was that there was a football coach who, while he was at work, would pray in the middle of the football field immediately after games. And there was a long history of many of the students joining him as well. And so there was an establishment clause question of whether he, in his role as a public school teacher, as the state, was somehow subtly coercing his students into a religious exercise against their will, which would violate the establishment clause. And one of the ways the court resolved it is, well, first, it didn't look at the whole history of this prayer practice. It just looked at the last 3 instances. And then it said, in these last 3 instances, he's on a break, basically. It was the friend's excuse, but an establishment. He was on a break. And the reason why that matters is because they said at that time, he was speaking not in his role as the coach, as a public school teacher. He He was not speaking pursuant to his official duties, but he was speaking at a private individual. And once he's speaking with his private person hat on, as opposed to his public employee hat on, then the doctrine is quite different. And so they were focused more on his rights as a private person to have the right to exercise his religion and the right to speak. And so therefore, you didn't have the same problem, the same issue as you do with a teacher who's clearly in a classroom speaking pursuant to their official duties.
So it definitely does add another layer. I didn't bring up those. Every one of our cases, well, not everyone, I think there might be one that doesn't. Most of our cases do involve a free exercise claim as well. And it complicates it in two ways. One is Title VII, as you all may know, the Supreme Court just changed the standard for accommodation for Title VII claims, and religious claims, last term, from a de minimis standard, so that the employer has to provide an accommodation for an employee. It used to be, unless it imposes a de minimis cost. Now, the new standard is, unless it imposes a substantial increase in cost relative to the size of the business. That's a very different change. We've got a case in the Seventh Circuit, will be argued in 2 weeks, for a teacher who was an orchestra teacher named John Klug. He'd been there 4 years, had no problems. They adopted a pronoun policy. He asked for an accommodation. And they actually said, okay, you can do it. You can use last names for all students. You treat every student the same, last names only for all students. And you can't tell anybody why you're doing it. If they ask you, just say, well, it's like a coach, we're a team, it's like a coach. Lots of them use last names. That's what he did. There were no problems the first semester. They had no disruptions. Everybody was fine. This principal came down a little later and said, hey, we've heard some students are complaining. They know why you're doing this. All right, he never told anybody. They know why you're doing this. Because of that, they said, we're revoking your accommodation, adopt a new policy, and they said either you agree to the policy or you'll be fired. So even under a same treatment, it's no differential treatment, they fired him because everybody knew why he was doing it, his religious beliefs. Obviously, if you know anything about the free exercise clause, when you do something, one, because of someone's religious beliefs, you can't do that. Two, you're treating people differently based on different reasons. They allow a coach to do it because he just does it. That's what he does. You don't allow an orchestra teacher because he's doing it because of his religious beliefs. That's a differential treatment standard. You'll lose under the free exercise clause every time for that reason. And it's another reason why, one thing I've talked about here in the K-12 context, what you don't understand about these policies is that these policies mandate the use of names immediately upon a student asking for the request, no matter what. Like first grade, they ask for it, they have to do it. But yet, there's no legal name change, so that their name is the same in the system. Many times these high schoolers have to sign in using their email, which is their legal name. They get an email every day, or they sign in using their legal name every day. And yet they're going to fire a teacher for declining to use a pronoun when they're not even, the system's not even using those same things. So they're a differential treatment. That's a different standard, and under the equal free exercise clause, that would be a violation, and they would lose over that.
We're coming to an end, so there are a few more questions we're not going to be able to get to, but I want to do a couple real quickly. One is with the Supreme Court that is increasingly originalist and textualist. Does separating academic freedom from free speech put the legal protection of academic freedom at risk? Quick answer, I think, on that one, and I'll avoid disagreement, is yeah, the court's going to get more originalist academic freedom. It's going to be on different grounds.
You know, the concept of academic freedom was not around in the late 18th century. So if you're a total originalist, the meaning of the Constitution is determined by its meaning in 1790. No, academic freedom is going to lose. Makes one wonder about that theory in the first place.
just want to say, if we're going to go all originalist, I think it would also mean that you would ban free speech.
Final question, I'd like a response from all the panelists on this one, because it really brings together this whole question of where we are on academic freedom in a very personal way. Question is, if academic freedom and First Amendment principles primarily find their footing in the search for truth, would enforcing professors who take a side on an issue like gender also force them to give up the search for truth? Even if it may be hostile to misgender, would the search for truth demand professors to invite debate on the issues? And what I think this question really suggests is, in the fight between academic freedom and the creation of hostile workplaces or hostile educational places, which side should win?
I don't think this is that hard. I don't actually think it's that complicated, right? I think, again, if that's not your area of expertise, then there is no loss to this search for knowledge by addressing your students with pronouns. Actually, even if it is your area of expertise, you can still explore the question and address your student with the bare minimum of respect and use the names and pronouns that they have asked you to use while you have this discussion.
In my mind, I don't think there's any conflict between academic freedom and the harassment clauses. I mean, the Supreme Court's been very clear in the Davis standard that, it's harassment if the conduct or speech is severe, pervasive, objectively offensive, and deprives of an educational benefit. And I think under those standards, if a professor's, engaging in conduct, which, does those things to the students from the standpoint of not in a teaching context, and a harassment context, obviously that's not academic freedom. And so that's how I think the Supreme Court's balanced it. I think that's how we would balance it when, addressing those types of situations.
And I'll just respond personally. In my classroom, my academic freedom takes a back seat to my concern about student learning.
To me, this is an extremely difficult issue. There are times when professors speaking within their academic expertise, meeting the standards of their discipline, say things that students find hurtful, even harmful. A university is fundamentally committed to the search for and dissemination of knowledge. And I put a very heavy thumb on that value, sometimes even at the expense of, I would even say, the harm the expression of an academic idea could cause. There's one famous incident, I think it's, or example, in the first major speech code case, Doe versus Michigan, in 1989, 1990. Doe, who proceeded anonymously, was a graduate student who taught a course in behavioral psychology. If there's anybody here who's an expert in that area, let us know. Here's my understanding of what was going on. And so I'm going to say something that some might find offensive, but it's in the case. And I would say academic freedom defends my right to give this example in an academic setting.
But you gave a warning first.
But I didn't have to. But I did. Okay. And some would say even with a warning, the following would be improper because of the harm it causes. So the issue was, as I understand it, in behavioral psychology, there is a theory. It might be a minority theory within the profession, but one taken seriously. It's not like the earth is flat. It's like an idea some people have. That males of various species, including Homo sapiens, are better than females of various species, including Homo sapien, at mental tasks dealing with spatial relationships. And the argument is there's kind of the males have been the hunters. Being good at spatial relationships makes you a better hunter. There's natural selection of that ability through evolution. So the argument is men are better than women at these particular types of mental tasks. And to be more offensive, as I understand the argument, some people who hold this view further say, if you want to know why there are fewer women in STEM fields, this is in large part the reason. And Doe said he was concerned that the University of Michigan's new speech code, passed after horrible racist incidents, let's be clear, the new speech code prohibited, quote unquote, victimizing or stigmatizing people on the basis of, including sex. And Doe was concerned that presenting this theory in class would be considered to violate the speech code and subject him to discipline. And the judge agreed and declared the Michigan speech code unconstitutional in a very influential decision.
Give a really good round of applause.
All right, well, now that we have our blood pumping, it's time for lunch. We have some Carolina whiskey chicken, a vegetarian lasagna, and a few sides. Lunch is set up in the back. It's a buffet style, so we're welcoming y'all now to get up and grab some lunch, and we'll start our third panel at 1:45. Thanks.
Yes, I was like, where did I recognize you as where?
I'm manning the live stream. I'm a production assistant.
What I do, you know, I kind of like college. I did.
No, this is really interesting. Hold on. During lunch. It's available. I think they should do it.
Wait. Oh, dude. Oh, yeah. Dude,
Someone has been sitting here, but I can speak over it. You sure? You don't need that one? Oh, okay. I don't know if that one knows no there. Yeah, I'm a journalism student, and so I'm a production assistant at the Husky School, and this is a more tame day. I basically just make sure that the live stream keeps going, but sometimes we actually shoot you. Working for podcasting and I'm a senior. I don't know. I'm primarily do sports broadcasting, but I'm also doing some other like marketing. So you know William Gates? Okay, I just did a story on him. I don't know if you remember him. He's a great railroad in Little Washington. He basically just had no information on William. He's the first and did some research with some of the librarians at Davis Library and found out some of the insights information. And then related to the local library in Washington. Called him and was like, so you donated a 5%. It's really great. Like 18 and all types of animation. Yes. In New York. Yeah. I know, it's crazy. And then his friends from the kindergarten were saying Maria was there.
Oh, so you guys don't tell. Yes, maybe we're pretty good students. You have lovely access to all the funding, so you don't tell. The train station and the bus station, I just want to go to the bus station. I am often at the bus station with the students. Sometimes at the train station. And DC, more familiar with that than I necessarily want to be.
Yeah, my sister was in London. What is she doing?
I was really
Yeah. I mean, I went to some Shakespeare's everything's just
So
it's just like it's not like business where you start
somebody from the
there's a couple different routes you can do about
that reminds me of somewhere 4 years ago, sister office, right? Yeah.
But I also
you remember.
Whatever. It's a good location. Yeah, my son. Or just going on.
I didn't realize she also spent time in this house.
Where you?
I had like 7. Is that in Durham? How often you go to the depot? I was sitting in the store. Okay. That would be I've never seen it. Someone loves theater, so I need to pick something that they would enjoy. I went to a play at North Carolina School of the Arts. It was called The Wild Party. And not appropriate for my kids. The actors as well. I've got a dance program and acting program. It was one of my music theater. And it was kind of a thing that got used to music program. So it was all or like straight away. Well, they mentioned several, but that was the best one ever. They won't come up here unless I can't help them. And they have nice to meet you. Have a great day. Just certain Sorry, I'm here working on I'm a journalism student. So what is your area of interest? Broadcast. Is that really broadcast? I'd rather not do traditional hard news. I'd rather do political reporting. Yeah, but obviously a little bit hard and it's great interest. Yeah, I can imagine. Rebecca Hall, the director of Global International Okay, cool. My dad is really? What's your dad's name? Chris Humphrey. Yeah.
But he was chemical engineering at state. Yeah. Yeah. So still a big state, but I always mind him.
I lived here for 4 years.
Oh, yeah.
So fun. My favorite. And we all marched together. And we were such
But it's like virtual.
So I used to walk when I first started at work. I happened to get going to Joshua Johnson, his last
Oh, you got to be there. Oh, cool.
I got to see their.
I remember that broadcast.
Yeah, I remember. I was starstruck for years.
Oh, yeah.
But yeah, it was like that in my apartment. And it was just like, wow. I'm coming out of Northwest Mississippi.
Life is weird. Middle school.
It's a brand new law school.
Oh, did
Double the size of it. And very different kind of vibe in terms of global type things.
Oh, I wish I could remember that one. Yeah, that's awesome. Yeah, travel reports called. Yeah, so I have people put on that. Then I went there. I'm very excited. Well, that was my. I'm not going to argue. Time slept. It's good to see you too.
Big conferences and big meetings. So you never know secretary teachers, report over, talking about some kind of infrastructure stuff. But I was taken aback because I don't know and
Totally different experience.
Yeah.
And then now I'm going to do one. Yeah. She loves it. I love it. I know a lot of students end up working
Oh, I bet.
So I'm like, oh, I'm going to kids everywhere.
Yeah.
not necessarily excuses, but do you, with the sports, I mean, I would love to
Washington Commanders.
some sports teams, I might try to look at MMA. I've actually looked at Charleston, and it's like market number 8. It's like not for sports, just for regular yeah, that's like real fun. But I feel like working with production. So my daughter is communications major.
I love it.
She worked on the late shows. Now, in part, it's kind of interesting. That might help. So right now, she loves it. She lives in Brooklyn. She's actually got the issue, which is one of the second and the production. She loves it.
Oh, that's right.
She's trying to piece together part-time stuff, and she's practicing. Like I remember when she was so early, she said, I could call her and say, yeah, I go into the office. I just like so often when it's like to get something, because we're getting ready for Salmon Rush. I'm like, you know, we get it. Look down. I don't. So yeah, that's the kind of stuff. I know she's always excited. Yeah, I mean, she's had, while she's struggling to find now, she's had some amazing my other son is he is working not too far
It was wonderful.
She really loves what she's doing. And she's great at getting into that side gigs. She did a bunch of, she helped Steve know like and so she was doing a lot of those. What the club and tours like press, yeah. So she did that. She's done a lot of that way. But yeah, and that's the thing about very moved, but The journalism school is partnering with on location. So we took a trip to the Olympics. You lucky duck. Yeah, it was really cool. I got to like send content back to North Carolina station. I was so happy. But while they were there, we connected with on location, which basically just plan your trip for you and then offer all of these like rounds of things. But they do it for every major sporting event. So if you just like on location obviously making money, then you do right. And so they're partnering with school now for next semester to go to Super Bowl and March Madness and have us like work with them. So it wouldn't really be journalism, but right. Like hospitality side. Even shoot. Yeah, you're going and you get a team. Yeah, oh my God. So I'm like, I'm hiring all your I know. Wait, so where did you guys go?
I graduated in 2020. This was supposed to be a career shift for me from higher ed to law. I'm still in higher ed.
Yeah.
I love working with students, so here I am.
Where were you before?
I worked at Ashland Technical Community College for 14 years, and for 5 years at International prior to that. So I've been in higher ed. Most of them are okay. My in-laws were out of power for 4 weeks, out of internet for 5. Actually, almost 6. Only one of my friends was us. But she's over it. So it was a rental home, but it means she lost her income and the renters lost everything. So that's messy, but it's a mess. Because that really is it's in town and it's for most purposes that's mine out of there. You still don't have potable water. Mid-December from this place. Well, I mean, 30 feet of water. I mean, I was in the, and I was in the Asheville area. I lived in Asheville, in 2004 when Hurricane Ivan tore through and then came to us. Western North Carolina, and down in the basement for a long time. And she lost power for quite a while, and it flooded my commute to work. And flooded the whole village and made a mess of things. But the scale of this is so different. The road that I used to commute, the water was like 3 feet above my car for Ivan, but it didn't destroy any buildings. It was 9 feet higher than that. For this just, I mean, it's hard for me sometimes to watch the videos and go, wait, I know where that is. I used to go through that drive-through. Why do you need this 4 feet of water in there? Or just to look at the river art center that I drove for 14 years and see it just smashed to pieces after having been through multiple floods in that area. So it's been really strange to see your hometown just troubled. My parents lived in eastern Tennessee, so they got really hard to where they evacuated and go south of the hospital. That's where down the upriver, downriver, where my brother worked in the campground for years and just wiped that campground off the face of the planet. The river, it was just a tiny little Nolichucky gorge campground, just a tiny little campground, but the river, which is usually 300 feet wide, was half a mile wide. It was insane. I can finally get to my parents' house via Asheville. But yeah, it's been weird to watch. And it's one of those things, here at the beach, you bulldoze stuff and you build back up. And if the road's out, you can kind of drive over on the sand or whatever. When you're in the mountains, I mean, the road that I take to my parents' house is literally not just the road is what was under the road was cut out by the river and is now a new part of the road. And it's on a mountain that there's two walls where it just cut out and you can't go. It's like 6 miles of my drive. I have to go all the way to Johnson and back. It's insane that the river came so hard that it just cut over the banks. You would never know that it was a river. Yeah. Yeah. My parents have had some stuff in their house that, I mean, it's just looked rattled and we're pretty sure that these are pets that just got somehow stranded or lost, survived somehow. But were clearly malnourished by the time they got to found their way to my parents. Right there all the time. Black Mountain Guy. They kind of turned into like there were some of my friends that it took almost 3 weeks for me to be able to get to. It was tough. And one of them sent me a text, like, I'm sorry I didn't respond. I literally just got your message that you sent me 3 weeks ago. Because there was no communication. So it's going to take very long. Very long. Thank you. Some friends of mine have a house share in the community. They've been going back up since their house is a lot of activity. And you know, these are people that have been through multiple records over the course of the last 30 years. There's absolutely nothing they could have done. They could not have been situated. Absolutely not. The billboards are exposed. I mean, I didn't think they just went with that entrance, and you could still go to the properties. But they lost livestock, they lost roads. It was the highest cost of living, some of the lowest income, and some of those businesses paid 80 to 90% of their income. There's New Belgium. There's also Nevada and South River. That's the one out towards out near there. It's beautiful. The one with like the copper. Yeah, that's New Belgium's in downtown Nashville, right off the river. But yeah, they're gorgeous. They had some damage. I'm not sure how much, but yeah. Yeah, they did a beautiful job. Does anyone want to University of South Carolina. So we practice. Actually, military is open. Sierra Nevada is open, but New Belgium is closed.
We would like to. He's like, I gotta get this out of the way. I think about it. It's so different. It's I can actually get in. My girlfriend's sister.
All right, everyone. Looks like everyone's already taken their seats, so we'll get right into our third and final panel on institutional speech and administrative challenges. This panel will be moderated by our keynote speaker, Professor Mary Rose Papandreou, who is the Samuel Ash Distinguished Professor of Constitutional Law, and she will go ahead and introduce our panelists. Thanks so much.
All right, last but not least, I'm very excited that I will be moderating this panel on institutional speech and administrative challenges. Just a logistical note, I have prepared a series of questions for our panelists. Professor Whittington will be giving an opening statement about his paper, but the other panelists have not written papers. That is not why they're here. They're not here to offer scholarship, but to discuss the very real challenges that they face as academic leaders. Although I do have a full list of questions, I do welcome questions from the audience, and we'll be following the same procedures from the prior panels where you should write your questions down and put them in a basket, and I will do my best to work them in throughout the conversation. Okay, so with that, let me introduce our panelists. For sake of time, I'm not going to read through the biographies which you have available in your program, but we are just delighted. This is an all-star panel. At the end of the table, we have President Peter Hans. He's the president of the University of North Carolina System. Next to him, we have Keith Whittington, who's the David Boyce Professor of Law at Yale University. Then we have Christopher Bracey, the Provost and Executive Vice President for Academic Affairs and Professor of Law at George Washington University. And finally, Liz McGill, Professor of Law at the University of Pennsylvania, former emeritus President of University of Pennsylvania. So once again, let me just thank all of you so much for coming and taking the time to share your insights on some of the most challenging times I imagine as you have faced as leaders. So we are going to start with Professor Whittington. I have a series of topics we'll be talking about today. Topic 1 is institutional neutrality. Topic 2 is the role of public and political input and dealing with competing constituencies. And topic 3 is free speech in university students and faculty. And finally, I put this in for myself. I really am eager to hear some leadership advice for those of us who might be interested in pursuing careers in academic leadership. What would you tell us to do aside from run away, don't do it? Okay, so we'll start with institutional neutrality, just by way of background. In 1967, a faculty committee at the University of Chicago, under the leadership of First Amendment expert Harry Cowden Jr., issued a statement on the university's role in political and social action. This report urged the university not to take a position on political and social issues in order to protect an environment of free inquiry. In the last year, universities have increasingly adopted institutional neutrality policies or similar policies with slightly different names. Professor Whittington has authored a piece for this symposium on the topic of institutional neutrality. So I turn it over to you, Professor Whittington.
Thanks, I appreciate it. I have a good friend who is a university president, and he has frequently reminded me over the last few years that it's easy for me from the cheap seats to cast aspersions on university presidents and offer good advice that they find difficult to follow through on. I appreciate the opportunity to be on the panel, and I recognize that my situation is somewhat different than those who actually have to exercise responsibility and authority within these institutions. But we each have our role to play, and my role is to throw stuff in the gap. I should also note, for purposes of symposium, that this really is not, at least my paper is not about First Amendment issues as such, but instead about questions of speech in the university context that I don't think really implicate the First Amendment in a very direct way, but do raise a series of issues about prudential questions about how universities ought to speak in their own institutional voice and what the implications are for engaging in various forms of institutional speech. I have a separate paper that sort of is presented elsewhere, which you can actually find on SSR, and if you're interested, that is more focused on the problem of institutional risk that is associated with institutional speech. That I think we're in very difficult political environment in which the more times universities speak in their own voice on controversial political issues, I think the more the risk of backlash against universities is likely to be. Universities will be safer in the long run if they mostly refrain from speaking out on controversial political issues and stick to their core concerns of education and scholarship. But this paper focuses on a second kind of concern that I think is real in this context, which is the relationship between university and other kinds of institutional actors speaking in institutional voice and the core scholarly mission of these scholarly institutions. And I say scholarly institutions because I think there are issues here not only for thinking about universities, not only for leaders of universities and central components of universities, but also things like departmental and academic subunits of universities. And there's quite a bit of controversy these days about whether or not, for example, university departments want to be issuing collective political statements, as well as whether or not universities ought to, as well as faculty senates, for example. But there are also questions about scholarly associations and whether or not they should be issuing political statements, should scholarly journals be issuing political statements, or have political commitments of various sorts. And I think all of these entities engaging in that kind of institutional speech tend to erode their core scholarly mission and do real damage to the goal of free inquiry they ought to be pursuing. And I just want to put on the table a couple of reasons why I think that's particularly true and why we ought to be concerned about that kind of speech. So one is that all these institutions, whether we're talking about scholarly associations or university departments or universities as a whole, are fundamentally about hosting the pursuit of knowledge. So they provide venues in which we can engage in scholarly inquiry and pursue a range of questions. What they're not supposed to be in the business of doing is entrenching conclusions that result from those scholarly inquiries. It may well be that we as scholars reach some consensus, at least in the near term, on a set of issues that we are testing. But even when that's true, it's not the job of universities or departments or scholarly journals or scholarly organizations to then say, okay, we're done now. We know what the answers are. Here's this list of acceptable conclusions we want to reach, and we're going to endorse those and cast into the outer darkness those who disagree with them. And so we should really try to stick to a core enterprise of being a place where we ask questions, rather than a place where we're trying to privilege certain kinds of answers. Secondly, I think there's a real risk of elevating non-expert opinion in all of these contexts. So to take a relatively straightforward example, if you imagine a faculty senate, for example, trying to decide whether or not to issue a statement about the wisdom of particular military action abroad. Now you're going to make a vote among all members of the faculty. You may well have a very small number of faculty in your university with genuine expert knowledge about military action, the consequences of military action, the particulars of those countries involved, etc. But what you're now doing is asking the English department about vote on those people and to give us their considered opinion about the wisdom of military action in those particular cases, or any other particular political issue you might want to address. But again, what universities have to offer and what they can bring to the table is trying to provide platforms for people with genuine expert knowledge, provide their expertise, and share their expertise. What we don't contribute in any kind of useful fashion, I think, is simply asking a bunch of people what their opinions are on contested political issues and then trying to count them up. And finally, I think there are real concerns about academic freedom that particularly play out in the context of things like departmental statements. So I'm less concerned on this one, I think, about presidents, for example, issuing statements on contested political issues than I am on departments issuing statements on contested political issues. Precisely because I think presidents are actually less likely to be able to put pressure on individual members of the faculty if they find themselves in disagreement with the president on some particular political issue on their very high profile. But I think departments, on the other hand, are in a posture where they can put significant pressure on colleagues and members of the department. So, for example, imagine a department wants to take an issue on whether or not adoption right is decided and whether or not there ought to be a right to abortion recognized in the Constitution. And you're a junior faculty member in that department who finds themselves on the opposite side, whatever side it happens to be. the opposite side of the majority of your colleagues, including most significantly your quite senior colleagues on that issue. You now are facing very significant professional pressure to either swallow your true views on this and simply be silent, or even worse, to go along with views you disagree with in order to curry favor with your more senior colleagues who have different views and more than one department now to be issuing statements on this particular issue. And there's some conflict between junior and senior faculty that are unavoidable, right? You're going to make disagreements about curriculum decisions, professional scholarly issues, questions about who admits to the department, who hired the department, et cetera. And those kind of professional considerations are fair play and unavoidable and more important. What we should not be doing, though, is also forcing people to be trying to navigate a professional world in which they have to think about to what degree do I have to hide my own personal political opinions in order to operate in this world. The core feature of academic freedom principles in general is we ought to protect the private political opinions of faculty, allow them to express themselves precisely because they don't have consequences for their professional activities. So those private personal opinions that are being expressed on social media or at political rallies, for example, are protectable precisely because they do not reflect the university's own positions and they do not reflect the professional activities of those particular faculty. But on the other hand, instead they're going to say those personal political opinions can be translated into institutional statements issued by departments. You've now broken down that firewall between private political views and professional activities, and generally now suddenly that private political views become professionally relevant in ways I think you're going to have real consequences for the ability of faculty to hold a diverse range of views about private political matters, as well as their own professional and scholarly matters. And so I think there's a range of reasons associated with core features of the university itself and its internal operations that all suggest we ought to refrain from trying to issue institutional statements on these kind of contested political issues.
Thank you so much for that overview of your paper and of institutional neutrality and the reasons motivating it. I think there are no empirical studies that show the effects of these statements, and so we could talk about that. But I would say one question I want to ask, we've seen a dramatic increase in the last year of universities embracing institutional neutrality or similar statements. Is this really just a little too convenient for these institutions, a way of avoiding having to take sides on contentious issues? Maybe, or is it they just don't feel like they have the expertise in this particular conflict, and that's motivating it, or there's all of these things? What is your view as an expert on, although of course I understand you're not involved and embedded in the decisions of all these universities.
I was going to say,
President Hunt's next.
Some people at this table probably have more insight than I do as to what exactly is motivating these universities, although I've certainly had conversations with folks involved in some of these decision making. I mean, my sense is I think that especially in the post-October 7th environment, which unlike a lot of other political issues in which universities have found themselves speaking out about, this is one that divided the campus community itself, right? And so it was easy to see that the campus was internally divided on these issues, as well as the kind of external controversies and divisions on these issues. And I think that helped contribute, although we already have been seeing this gradually over the last couple of years, of the universities really rethinking whether it was a good idea for them to be out there as much as they were on some of these political issues. And so I think a lot of university leaders have rethought what they ought to be doing in these contexts and try to reposition themselves and have taken this opportunities to recommit and reaffirm to some of those values in ways that maybe not always well thought out, and we sort of drifted into a world in which we were issuing lots of statements. I think lots of university leaders have realized maybe that wasn't a good world to be in.
President Hans, I think you know that university presidents are not united on their views of institutional neutrality, the wisdom of adopting institutional neutrality. One particularly outspoken critic is Michael Roth, the president of Wesleyan University, where he's been particularly critical of institutional neutrality policy, saying that staying neutral or silent is an abdication of educational leadership. How would you respond to that criticism?
Dr. Papandreou, I think
President Roth and I have a different definition of educational leadership, perhaps. Now, he is the president of a very small private school in Connecticut. We're a very large public university system with a quarter million students. I believe there's 3,000 students at Wesleyan, and perhaps that's an expectation of someone in that role. So I won't sit in judgment of him, although he has of me over the past 4 years. But I find this actually to be a little puzzling, the idea that university presidents are expected to make pronouncements about any range of foreign and domestic policy issues. Not that long ago, I had a conversation with a friend, a former faculty member here at Chapel Hill, who was challenging me to speak out on an issue of national import. It's certainly important here, but no more so than it is anywhere else in the country. And that he said, you need to lend your moral voice to this issue. And I asked him with as much sincerity as I possess that, what if I had a different thought about this issue than you? And his response was that I would be politicizing the issue. And I said, now hold on, let me get this straight. If I agree with you and I speak to it publicly, then I am lending the moral weight of my good office to the debate, yes. But if I take a position contrary to yours, I'm politicizing the issue, yes. Well, to me, that feels like a really big blind spot. I can't imagine how the university really would decide what issues it should weigh in on. Just given the volume of news events, the rapidity with which they occur, would the university's official position be my personal thoughts alone? Or perhaps I would put it to a vote of my board, or perhaps we would leave it up to the chancellors of the 16 individual universities within the UNC system, or their trustees. But perhaps we should turn to the faculty, particularly those who have knowledge of the subject, but we wouldn't want to neglect others who have strong feelings as well. And of course, the staff and the students themselves. Well, gosh, we're here in the Alumni Center. Why don't we survey the alumni as well? How do you determine what to weigh in on, and who is consulted about that? I mean, it's just a practical point, I think. I believe people respect institutions and institutional leaders more when they know their roles and stay focused on them. My best days come when nobody is thinking about the president or the chancellor at all, when they're paying attention to the work of our schools and our faculty members and our researchers, and most importantly, the accomplishments of our students. Those are my best days. And to the extent that anyone is thinking about me, they generally want to know how I'm focused on the mission of the university, which I believe is appropriate. That's accessible, affordable, high quality, higher education for as many North Carolinians as possible. And how do we advance the human condition here and beyond through teaching and research and public service? Last thing in the world that our society needs right now is more live action opinion about the news of the day. I don't think people are looking to university administrators for political commentary. And I don't sense the nation is suffering from a deficit of political commentary. Quite the opposite. Quite the opposite. I think it's taking a collective toll on the mental health of our nation, actually. So there are clearly times when the core interests of the university are directly affected. Something has occurred on a campus, something involves a specific event on campus. Then it may be useful, of course, or appropriate for a president or chancellor to weigh in, but those moments, in my opinion, are generally rare.
generally rare. Public universities belong to everyone, not just those with a particular point of view.
Professor McGill, I would love to get your thoughts on institutional neutrality, and in your answer perhaps address whether you think it should extend down, not just from the president's office, but to individual departments and meeting centers and that sort of thing. Oh, sorry, yes, you go.
Well, I want to join others in thanking you for inviting all of us and commend the wonderful students of the law review for putting this all together in such a beautiful way. You could probably go into the business of teaching others how to run conferences because you're very good at it. So I hope you're feeling good about it. I'm happy to talk about institutional neutrality. I mean, I think Professor Whittington made a very powerful case on the effects of stance that isn't institutionally neutral on various values of an academic institution, effects on the core mission of the university. Like the university is, I think it's the Calvin report that puts it, the home to the critics, not the critic itself. And that was quite powerful, worked out through a lot of different examples. The particular question, and I'll make a couple comments on neutrality generally, whether it should apply to departments, I think is interesting. I think, again, Professor Whittington made a powerful case both in the paper and here today in emphasizing if the department or other organization that isn't the entire university, a limited society, a professional organization, takes a position qua department or as the organization, they are taking it on behalf of an institutional body. And so you want to ask, as Professor Whittington does, who has consented to this, who agrees to this? This is representative of the whole group of people that are part of whatever the organization is. And I mean, the same is true when the president speaks or provost speaks, but a department, sometimes I think when they're making statements aren't necessarily thinking about it, might be thinking about the faculty, but they aren't thinking about the students who are in that department, or the future faculty who will join that department, and perhaps be affected by the institutional position of the department chair. So I think, to me, the important conceptual point is that when you make a statement as a department, you are making an institutional statement on behalf of the people affiliated with that department, and that should be the occasion to think about, do they all agree and consent to this? And I think it's unlikely, especially if they're weighing in on contested issues of the day, that everyone in the department, including people who aren't faculty, but people who are students, people who are staff, agree with it. This is, I think, importantly different from a group of 4 faculty in their individual capacity saying we have a very strong position on X, Y, or Z, we have academic expertise in this area. Even if we don't have academic expertise, we think as a moral matter, I want to state that I have the following position. That's not, typically speaking, in an institutional capacity unless they hold a position and they're invoking that institutional capacity. So I would distinguish that. I mean, more broadly about institutional neutrality, I think, I hope someone goes back and studies the adoption of institutional neutrality and the rise in the embrace of institutional neutrality in the last year. My own hypothesis is that it relates quite heavily to the experience in the post-October 7th period after the Hamas terrorist attacks and the ensuing war in Gaza, that universities were quite heavily pressured to make statements. There were institutions that had institutional neutrality positions and actually took positions despite those institutional neutrality positions, and the divisions that have already been discussed within the campus community, between and among faculty, between and among students, between and among staff, as well as in the alumni, parent community. The divisions were so deep that I think very few of those statements served a purpose that the institution hoped it would serve in speaking in a way that spoke to all parts of the community in a way that was satisfactory or soothing or took a position of moral clarity. I think they were pretty roundly criticized. So we had a kind of intense experiment of many statements
which I think by the lights of most of the people who issued them and other observers really were not serving a good purpose, and in fact caused a lot of conflict and a lot of disagreement. And yet there was unrelenting pressure to issue statements. So in some ways, that trial by fire of lots of statements in a deeply divisive issue, politically, globally, but also on campuses, taught a particular lesson that led many institutions to adopt many more institutions that have before an institutional neutrality position. I would say that, and I'm curious whether the academic leaders here agree with me, there are, in addition to the principled reasons to adopt neutrality, there are a lot of pragmatic reasons to adopt neutrality. In other times that university leaders of all levels spend on statements and trying to get them right, and everyone does the best they can with as much input as they can, and they pretty reliably disappoint. And or worse, inflame and anger people. They quite rarely, certainly I guess in the fall, made members of the community who were seeking a particular kind of statement, had a statement on the position they wanted, made them feel better about the values of the institution, maybe occasionally, but they certainly produced a lot of negative feedback. And academic leaders, like the rest of us, have only so many hours in every day. And so there's a set of pragmatic reasons that are on top of the principled reasons. I guess I raised two questions that maybe we can keep talking about, maybe not. We'll see what Provost Gracie has to say. I think the exceptions to institutional neutrality are not exactly easy to apply. It would be interesting to see over the years how they do apply. I think what President Hans identified an incident on campus where the community really needs to hear from a leader about what happened, what the institution is doing is quite easy. I think in most institutional neutrality positions, direct attacks on the mission of the university are generally exceptions. When I think about, because I experienced it when I was out in California, as a dean, but the immigration restrictions that dramatically and sort of immediately affected students who are at U.S. universities, kind of evulsive change at one moment, and that very directly affected students, but of course it's a contested national political issue. That's an interesting one to think about, whether that's what side of the line that would be on, and maybe it's how the statement is made as compared to whether a statement is made. So I think that's an interesting question, and there are lots of people think about that. I guess the last thing I think is interesting to explore, and maybe not for today, but another day, is just thinking through why there is so much pressure for leaders to issue statements. I think most of the statements actually tend to be aimed at the community. There are members of the community who want to hear from a leader about a particular issue, and often, even the post-October 7th statements, they were about the community that the president or dean was speaking to, because there were members of the community directly affected by that conflict. And this is not just pressure on university leaders to issue statements. And if you go back in the last 10 years of statements, CEOs of companies were making statements about contested political issues, I think partly because they had employees and that the community of the company really wanted to hear the leader share their values. And we've already explored how difficult it is to share the values when people disagree on the values and the consequences of potentially sharing values. But it would be interesting to know how we got to the point where the community wanted to hear from their leader on so many issues. And there was, again, I do not think this was just educational institutions. I know it wasn't. And how will that community expectation and hope change over time, and sort of where that come from? I'll end that point by thinking about, if you compare very broadly described conflicts on campuses in the 1960s to conflicts on campuses today, I don't think a lot of people on campuses in the 1960s, especially those who were protesting university policy, wanted to hear the leader express their values. I think their view of the leader was the leader is sort of the enemy, and I'm not interested in their view at all. It will not affect my view. And I think in the last 10 years or more, there is more of a desire to have the leader express the values that you have. Even if you disagree with the policy, you want to hear the leader say, I'm with you on one particular value or another. And that I think is a pretty significant change in the way people think about their affiliation as a student or faculty or staff member or alum of the university.
I want Professor Whittington and Provost Gracie, whatever you want to talk about your position, your institution's position so far. But first, Professor Whittington, we heard Professor McGill reference the exception in the Calvin report for statements about core academic matters or institutional operations. Have you seen universities using this, and how broad is it? I think one criticism that is hard to deny that you could drive a truck through this, perhaps, depending on how you interpret this. I've heard many students argue that it shouldn't be so hard for schools to condemn racist or say anti-Semitic speech on campus. So, to even just use the campus idea, that does weigh into the core academic matters and it's the ability of students to learn. So that would be great if you could tell us what you've seen.
Yeah, no, certainly I think that kind of exception is built in the Calvin report and gets repeated in lots of other university policy, lots of university statements and policies regarding institutional statements tries to carve out some kind of exception for, at the very least, things that affect the university operations itself. I think in the case of Calvin, a report being drafted in the early 70s in Chicago with lots of faculty who had either direct or indirect experience with the Nazi example in Germany. Their concern is very much looking at the European situation during those years and thinking, if you have something like that, the university, of course, has to defend itself and critical features of an institution for inquiry against those kinds of authoritarian pressures. And so we can't kind of manage such. We can't speak out of a state or try to restrict that. And so, and I think that's right, at the very least, right? And so, but then, I told Troy and suggested, right, you did sort of gradation of sort of, okay, well, what about immigration policies that are going to affect student visas, for example? So it's one thing about saying, okay, a bunch of students are upset and it has consequences for them personally. But furthermore, it has consequences for the university operations, right? And sort of who's actually going to admit students where you're doing those student visas, for example, they're going to be restricted as immediate policy consequences for the university. I don't think the university is going to avoid saying it. Yale just adopted a kind of thing that the writers of the particular policy denied it was institutional neutrality, but basically institutional neutrality. But it has a little carve out as well for the exact language they use, but expressions of concern for members of the campus community, for example. And so one of the kinds of concerns people have about institutional neutrality is, well, does that mean we can't say anything in sympathy with students who are being affected by something? And those are relatively easy, what we're talking about natural disasters, for example, and students on campus are being affected by it. Much trickier is what we're talking about in war zone situations, where you may have students on both sides of the war on your campus, for example, and what you say under those circumstances. And then also there are questions about silence versus when they're speaking out. So if you said something about that hurricane that affected that community, you didn't say anything about the hurricane that came through my community, and so why are we missing out? So again, I think those kind of exceptions in themselves create real dilemmas for university leaders, and they trying to err on the side of just not saying anything most of the time is probably in this interest.
Provost Gracie, I don't think, I could be wrong, but I don't think GW has issued or adopted institutional neutrality. I'm curious if you have been hearing conversations and how you've been thinking about this issue.
Yeah, so first, thank you for inviting me down. It's great to be here back in Tar Heel country. I am Tar Heel, born Tar Heel bred when I died, Tar Heel dead. So what I would say is that, George Washington University, we most recently answered a question from around the media in Washington Post and the local student paper, where we have said publicly that we have not embraced institutional neutrality, at least not yet. You know, for us, being the largest private university in the District of Columbia, having a global reach with students from all 50 states and 130 plus countries, whenever there are these issues of significance out there in the world, having one of the most engaged student populations in terms of political activism and, you know, engaged alumni base in terms of political activism, as much as I would love to embrace those principled justifications for institutional neutrality and revel in pragmatic sort of things that will make life so much simpler for us as administrators, the reality is that historically the George Washington University has spoken publicly on matters of consequence whenever they've occurred. This goes back many centuries. The George Washington University is 200 years old, we're in our third century, and we've always been an active voice in whatever prevailing issues were impacting the world or domestically today. So, you know, for better or for worse, we have a tradition of institutional statements around these sorts of things. Doesn't mean we necessarily have to assert an opinion, one side or the other. I would want to distinguish between a sort of reactive statement where you choose sides or choose a perspective and advance that as the institutional perspective, or simply commenting that an event has occurred and recognizing that it has impacted members of your community. And we tend to err on the side of the latter because, again, with the broad reach of our university, we know that these things are likely to have impacted someone connected to our extended family. And I like Liz's question about values alignment. This is something that we're seeing not just in higher ed, but also in corporate employment context, where younger generations are looking to test the values alignment that the organizations they affiliate and work for, how do they align with their own personal values, and they want to test that proposition. And so we're seeing that on many occasions. I mean, I can tell you, Peter, I wish I had those good days like you in North Carolina where no one's concerned about what the administration's position is on an issue, but I can tell you, there's an op-ed that runs. We had one that ran recently in a student newspaper. It announced the formation of an organization called Faculty and Staff for Justice in Palestine. Sort of like the faculty and staff equivalent of the Students for Justice in Palestine, which has caused a lot of controversy across campuses in the country. Well, that op-ed ran on Friday. I think people saw it on Saturday. By Sunday morning, I had 892 emails in my inbox as part of a petition to have the administration condemn this new organization that had just been created. Now, we did not make a statement on that because we didn't feel as though that was significant enough to sort of have a reassurance message to our community, but I do think there's a difference between issuing reactive statements and offering sort of, instead of being on defense, being on offense. One of the things that I talked to my president about, because she had come from a university where the provost and the president didn't offer political statements or statements about anything. They were able to revel in the work of the faculty and the experience of the students and didn't have to comment on things publicly. But when she came to GW, I said, you know, we're going to have to figure out a protocol for when you issue statements and how you issue them. And I encouraged her to think about making statements that describe what our institution is going to do. So we comment on the event, then we describe what it is we are going to do to try to either improve the lives of our students, our faculty, our alumni, our people who are impacted, or how we can double down on strengthening community, reinforce the unique environment that we have as a university, where we know it's a place where ideas come to collide, and we expect people to be able to have civil discourse and conversation around contentious issues of the day. The only other thing that I would say about institutional neutrality is that there are instances where you can't afford to be neutral. And we've experienced this at the George Washington University in the context of this Israeli-Palestinian conflict that has occurred since last October 7th. and that is regarding the Office of Civil Rights investigation into activities that occur on campus. And the OCR has offered an interpretation that also suggests that there are moments in which the institution has to speak affirmatively. You can't be neutral. You actually have to say something positive in support or against a particular position. And if you don't, then that may cause some legal problems for you down the road. And so that's another aspect for us that we wrestle with within the District of Columbia. The other point that I would just want to close on, when you think about all of the constituencies that are putting pressure on universities, it's not pressure in the abstract. Liz can speak to this, and I'm sure Peter can speak to this, but we're talking about direct, intense pressure to articulate a position on behalf of the university where you know it will get you in trouble. I think sometimes they know it will get us in trouble, but they want us to do it nonetheless. For us, we have congressmen and senators coming to our campus, doing press conferences outside of the campus, and then asking the university what its position is. I mean, intense pressure. So I don't want to sort of suggest that, we can resolve this in a theoretical frame or in a conceptual frame. When the rubber meets the road, it's people like me and presidents like Peter that have to ultimately make the hard decision about what an institution is going to represent and the values that it purports to reflect, knowing that those decisions always have some cost associated. And then you go back to work, and you hope you don't have to make another one like that again, and then something else happens in the world, and there you are right back at the table trying to figure it out.
I just thank you for that, Chris. I think your point that each institution has its own norms and history and expectations and environment, within the district, lots of universities have that, your version, that is a really important feature. It's quite hard to just decide I'm going to change the culture of this place because I believe in principle this is the right thing to do. You just have to have respect for the culture of each place, I think. It may change over time, but immediate alteration would have all sorts of reverberating effects that would be damaging to the institution, I think. So it's a great reminder.
You can keep that one there. So we're going to move on to our next topic, even though we clearly could spend the entire panel on institutional neutrality, if not an entire conference. I did receive an interesting comment about how Professor Robert Post at Yale has suggested that we think of this topic in terms of institutional restraint instead of neutrality. I'm sorry, we won't, I think we're going to move along, but that is an interesting way to rethink perhaps or just reframe what we're saying. Many schools are using that type of language to get away from this idea that they're neutral. All right, so we heard some comments here about the pressures that universities are facing from multiple competing constituencies. So I want to turn back to you, Professor McGill. From state legislatures to Congress, we've seen political forces attempting to bring pressure on universities. Do you think it is possible in the future that we'll see more political attempts to assert control or otherwise dictate the operations of universities? What do you think is driving these political efforts to, and in some cases, a hostility to universities? And what do you think universities can do to counteract these attacks on universities?
Well, that's a big question. There are books that are yet to be written on this topic, I think, and there have been books in the past. I think the first thing I'd say is attacks on universities or their predecessors are really, they're hundreds of years old. Henry VIII dissolved the monasteries because he was unhappy with the independent source of knowledge and ideas that were coming from them. I'm summarizing a complicated history there. So I think political dissatisfaction with universities and what comes out of universities is not a new phenomenon. So that's worth knowing. I think Universities are among the many institutions in the United States and across the world that have declining respect and trust. So I guess another way of saying is universities are not immune to this particular moment where the decline in trust of all institutions, everything from the military to the government to churches, nonprofit organizations. We are in a populist moment. I don't know if that's the proper term for it, but a real decline in trust in institutions, and universities are not alone. So I think that is part of the reason there's increased political concern, political hostility to universities. I think universities have big challenges in access and affordability across the country. If you look at the whole sector, the focus of a lot of the political attention is on the most elite universities that are, relatively speaking, well-resourced. And I think that's kind of part of the decline in trust in elites, as well as in institutions. And they're increasingly, I think, viewed to be partisan and also expensive and well-resourced at the elite level. And then the concern that people have about the return on investment, I believe, what is the usefulness of these degrees that not enough people have access to and are too expensive. And so I think there's a whole range of reasons especially reputation. I think you can sophisticated people about the whole sector of higher education would say, well, that's a fair critique here, but it's not a fair critique there. But the broad brush decline in trust, I think, is connected with all of these. And of course, if there's a decline in trust, elected representatives exhibit that. I would say, I'm not certain exactly what universities can do. You started out this morning saying that universities need to be better at explaining our, I think, noble missions of knowledge generation and dissemination and what it does for individuals and the collective society. And I certainly think that's one thing that universities can do much better. Universities can be difficult to defend from attack because they're very large. They're really unlike any other organization I can think of. They're certainly not like a corporation. They're not like the government. They're not like a large nonprofit. They are very bottom up. And the faculty teach in their own classrooms the way they want to teach. The faculty pursue research that they're passionate about. And the decentralization of most universities, I think, is essential for the pursuit of those missions, especially the research mission. But that means that on any given day, there might be something you see at the university that you really don't like so much. And in an era of social media, it's easy to make it seem like that's the only thing that's happening at university. So I think the new media environment has contributed to, as certainly the case to be made last year, as we discussed, as I think Professor Rubington discussed and others discussed. It actually wasn't me, it was someone in an earlier panel, taking 2 or 3 minutes of what happened at the university and making it seem like it happened at the university time. So I think it's an important question to be asking: how can universities better promote the missions of the university and what knowledge production and knowledge dissemination to the next generation does for individuals in the broader society. I think that's a real need, and it sometimes is hard for universities to have allies because of what I just discussed. So building more allies, there's an odd juxtaposition. I'll end on this. We have declining trust in universities for the reasons I mentioned, and I'm sure others. Remember what Provost Gracie just said about his affiliation with Trump. So a lot of us feel that way about our alma maters, and you go on any university campus, and there are university students walking around that campus really hoping to be admitted to that school. So it remains the envy of the world, our higher education system broadly described. And at the same time, it's facing these really, I think, significant headwinds, which I think will increase. So we need to be better about it.
I welcome other comments from the panels on this topic. In the meantime, I wanted to turn to you, President Hans, with a specific question dealing with political pressure. In prior interviews, you've spoken about drawing a line between appropriate public input and political interference. How do you regard the efforts of the General Assembly here in North Carolina regarding the university? And can you give us any examples where you've worked with them to address their concerns while protecting academic freedom?
Certainly, I do believe institutional restraint has served us well in that regard, actually, because as I mentioned before, I think the university taking official positions actually crowds out academic freedom and freedom of speech. Actually, our faculty are more than capable of having thoughts of their own, and we're preparing our students to be independent thinkers to do exactly the same. I find my observation is that few people actually like the sharing part of shared governance. So finding the autonomy and the oversight, that right balance, is always a negotiation. And my job as an administrator is to conduct that negotiation as well as I can and make some judgment calls about how to protect the institution and maintain public confidence as a public institution. As I mentioned before, we are a very large public institution, and I do not presume to advise smaller institutions, much less private institutions or public institutions for that matter. I just know what's right for North Carolina, where I believe the strong public interest in our universities is a strength. It's not a liability. As the phrase goes, the opposite of love is indifference. And by that standard, our universities are very well loved. People care deeply, and they share their thoughts frequently. Sometimes I appreciate it more than others, but when I'm in a clear state of mind, I do appreciate it. We've enjoyed tremendous bipartisan support of the university system over its entire history. I have lots of quiet conversations with political leaders in both parties, much more constructive to do so on a quiet basis as opposed to public pronouncements. And I think it's, again, a fair point. The overall direction and the strategic mission of our universities is clearly a matter of public interest, and it's subject to public input. Every one of our institutions was founded with a particular state need in mind, and they evolved in response to emerging needs in our society. So we're a vital public resource. That's good for us, but we have to stay in constant conversation with the public and their elected representatives in both parties. We're a purple state. Now, there are obvious lines to be drawn around how scholars teach in the classroom, how they research in the lab, how different disciplines define their curriculum. I've defended the faculty prerogatives there, and I'll continue to do so. I also think it shouldn't be in tension that we earn trust for our exercise of academic freedom when we engage in that good faith conversation with policymakers on the things that they also care about, the people they represent care about. Whether that's teaching civics or improving early childhood literacy or researching flood risk, you name it, a million topics. And a big part of my role is brokering those productive relationships between our universities, our faculty, and policymakers.
Provost Gracie, could you speak to the competing demands you have dealt with at GW? And in your answer, I'd love to hear about donors, and not just donors, but you can address donor pressure. That would be great.
Sure. So we're a private university. We don't receive any state funding or anything like that. So we're largely tuition driven, and we rely on a healthy endowment to provide this to get us over the line. And so we are, deeply engaged with donors all around the world who make commitments to the university, and they've been good friends of the universities, and we've been good stewards. But they have political opinions, and they have perspectives on things, and they have strong feelings sometimes about what the university should or should not be doing on campus in response to activities. And, we lost donors, frankly, since October 7th, because they were not satisfied with the university's response to the full range of activities through the encampments and beyond. We've had others who have withheld payment on existing commitments and are making future payments contingent upon the university shaping up and doing what they perceive the university ought to be doing. It's not easy, because ultimately we are a mission-based organization, just like every other college and university in the country, and we have institutional values that we take seriously. And because we're in Washington, D.C., we like to think that we are ecumenical and open to both parties and everybody from around the world and every place in between. But that's hard to balance when you have such a fractured population in politics. So, what the president and I have really tried to message out to anyone who's in earshot is that aside from focusing on the mission of research and teaching, we really are trying to do a couple of things as a university. We're trying to maintain a high-quality environment that has a robust commitment to freedom of expression and freedom of inquiry. That's something that is historically very important to GW, and it's something that we want our alumni and donors to fully appreciate. At the same time, we're an urban campus, and that presents a unique set of challenges for us. When we talk about encampments and protests at the George Washington University, we're not necessarily talking about our students. We're talking about being a sort of mobilizing point for advocates from around Maryland and Virginia, who may be students, may not be students, may be just agitators, as someone had said earlier today, some people just want to see the world burn. There are some of those folks too, and they come into our orbit to produce whatever mischief is there. We have to manage and maintain an environment that is safe for our students. And so we're thinking about that as well. And then, of course, there is the continuity of operations. We're a university, and we need to make sure that we're continuing to move forward with continuity of operations. And we recognize that those things are in tension with one another. If you really feel strongly about that robust free speech environment, it may be that you're compromising potentially the safety of your students by allowing others to come in who you don't necessarily know who they are and what they bring, or it may interfere with classrooms or exam schedules or things of that nature. So it's a constant balance, and we try to remind our donors and our supporters that that's the university that we aspire to maintain. And we hope that they will remain committed to us. But the reality is that the last year has been incredibly divisive across a number of college campuses, including ours. And there have been some folks who joined us and doubled down as we try to strengthen our community and commit to creating spaces where people can have conversations around those difficult issues. And there are other people, frankly, who have said, you know what, we want more, and you're not able to deliver it, and we're going to take our contributions elsewhere. But in the final analysis, I think we'll be okay as a university, because, as I like to tell the president, if both sides are complaining about what you're doing, you're probably doing something right. And I think we feel pretty good about where our students feel about coming to the university. We have the highest first and second year retention rate in the last 5 years. We're over 92%, which is great because many of our students and their parents in particular were suggesting that maybe GW wasn't the right place for their freshmen to return for the sophomore year. But I think because we demonstrated a resilience and we've signaled a commitment to core values that I think people believe in, that the students overwhelmingly voted with their dollars and their feet in coming back to the George Washington University. So, but you know, these external pressures, as I suggested, were real. It's not just donors for us. Frankly, it's the parents that are getting increasingly well organized. Believe it or not, and I'm soon to become one of these parents. My son is a senior this year. So I look forward to joining the parental listservs and getting other provost help. But there is this group of parents who I think demonstrate, and it may be a function of value proposition, as Liz was suggesting earlier, that as the cost of tuition goes up and cost of attendance go up, there is this desire to have almost a concierge-like higher education experience for your child. And so if there's an issue that you read about in the paper, or someone sends you a text or a link or a tweet that says something is amiss at your kid's college campus, the parents are the ones who are quick to respond. I don't hear from the students first. I hear from mom and dad. And they'll say, Junior or my daughter, you know, saw the following thing on campus, it's a sign, here's the photo, take it down. This is offensive, it's making her feel unsafe. Now, you know, I go talk to the kid hasn't even seen the sign. Kid doesn't know anything about the sign. Kid's having a good time. But it's the parents sometimes that I think, you know, are sort of living vicariously through their student and are wanting to shape what's happening in that learning environment because, again, you know, the cost of things has gotten to the point where they begin to expect a higher level of service.
Professor McGill, I was wondering if you could add any thoughts you have on dealing with donors who are reacting to student speech or maybe faculty expression. We've been hearing throughout the day that social media has made everything much more visible. So we frequently do see controversial statements that go viral and lead to a lot of concern. What are your thoughts on dealing with donors? Thanks for the question, and I endorse everything I think President Hahn said about legislative and public interest in the university, what Provost Gracie said about donors in particular who decided to support the university because they want to advance a particular cause or mission and then can be dissatisfied, just like legislators can be dissatisfied. I mean, I'm not sure that being an academic leader means that there are multiple constituencies. That's one way of putting it. It can be impossible to do the job. There are so many people who have an interest in the institution and so many people whose opinions and ideas matter to the institution rightly, and they are all relevant to the university thriving and being the best university it can be. So what I heard in Provost Gracie's description of the donor issues that he's dealt with is that my opinion as well. I certainly listened to donors and their concerns, and in the Penn case, we had a campaign, an effort to say stop donating to the University of Pennsylvania until change happens in the leadership of the university. So it's quite public effort by a group of donors who are concerned and alums. And I feel like my job was to listen, just as I would listen to anybody else who has a strong view about how the university is handling something, and take in all of that and do what I thought was the best for the long-term interest of the university. So sometimes that means saying, as I think Provost Gracie suggested, here's how we're handling this, we've heard you, and we're sorry if that makes you stop supporting us or be angry at us or be unhappy with how your student experience is having, to think about the parents or the legislators. And in the end, you need to follow what you think is in the long-term interest of the university, and that means abiding by its processes and the shared governance that is, I think, a mystery to most people outside of higher education, and do, in the old language of the old commercial, do what you think is the right thing given the things you have to think about as a leader. So I guess I'm not sure I think of donors as distinctly different than the many other constituencies of a university that care deeply about it and have opinions to share, often in conflict, about what the university should do. Along the lines of dealing with people or entities that control money, money's important to universities. Professor Whittington, I wanted to talk to you about Congress, and specifically the conditions that Congress can and perhaps will put on federal funds, upon which most federal, private and public universities depend. How do you view these kinds of conditions? Is there any sort of limits? Can Congress do whatever it wants? How do you think about that?
Well, I think you're certainly right that there's going to be creative efforts to impose new restrictions and use whatever tools federal policymaking are available to try to influence universities going forward. And we'll have to see what those wind up looking like in detail. And one thing that was true about the first Trump administration was it often was trying to impose conditions on government entities, including, for example, municipalities that were sanctuary cities, for example, aggressive efforts on the part of the Trump administration at the time to try to tie strings to various federal grants to those entities, strings that were hard to justify in statute. And so you can imagine the executive tries to go on its own, they can easily overshoot what statutes can allow. Courts may wind up reining them in on that. On the other hand, we also now have the possibility of maybe getting some new congressional statutory language that is more supportive of imposing some restraints on universities. And I think it will force courts to think new and fresh about some of those issues that we don't really have very well developed doctrines about a lot of those issues. I think there's been some First Amendment questions about how much of string can attach some of this federal funding that might impact university operations in their scholarly activities and missions. There's also going to be interesting questions about the scope of the conditions you can attach that are relatively unrelated to the core purpose of the grant, sort of consistent with what the court has thought about spending laws, limitations more generally, highly undeveloped in all kinds of contexts, but maybe become relevant here as well. So I suspect Congress and the executive branch are about to get creative in how they approach universities, and it's going to wind up generating new doctrine potentially on the part of the courts and how we respond to that. And I suspect from the academic side of things, we're probably not going to be happy with whatever winds up playing.
Yeah, I think we'll be seeing this play out. We'll, I guess, see what happens. We are going to continue talking about dealing with competing constituencies, but I'm going to move to some questions I grouped under topic 3, which is the free speech in universities. You've already touched on it quite a bit, but Provost Gracie, I wanted to hear more about what happened at GW. You already alluded a bit to the unique position GW was in given its location. And I wanted to hear from you, get us started, perhaps among the panelists, in talking about how those encampments pose unique challenges or different challenges for university administrators. We heard on the prior panel some debate about administrators should act immediately and not wait, and that was part of the problem. It wasn't aimed specifically at GW, just in general, that was one of the issues. Another criticism we heard in among various commentators is the use of city police or state police. How should universities be thinking about the use of their own campus police versus the city police, the town police, the state police, the National Guard, and any other complications that you encountered?
Sure. For better or for worse, it's all been in the Washington Post and it's in the congressional record. So I'm not speaking out of school, but we had an interesting situation on our campus. We were one of the last schools to get an encampment. So we saw the encampments popping up on other college campuses. And so we were, quote unquote, prepared in the event that we had an encampment. And so late in the spring, this was right before the undergraduate exam period, but during our law school exams. I got a call around 6 a.m. in the morning. There are 15 tents on University Yard, Provost. What do you want us to do? So this was from the Dean of Students and the Chief of Police. GW has its own police force. They have arresting power. But there were 15 tents and maybe 15 people. I get there around 7 a.m. and, students are quiet. They're studying in the tents. Seemed pretty peaceful. But the Chief of Police had called the Metropolitan Police Department, just as a courtesy matter. And so when I arrived at 7 a.m., the chief of the Metropolitan Police was standing next to my GW Police chief, saying, "What do you guys want to do?" So I went over and I talked to the students. They were all undergraduate students. And I explained to them what the university policy was on protest encampments, and that they were supposed to be located in one of these sort of free speech zones on campus that was designated as such, and that they were not in the appropriate place, and that they could relocate there. That would be great. And I walked away from the students, and I went back and talked to the police department. Metropolitan Police Department said, "Look, if this thing starts getting out of control, just let me know. 90 minutes, I can have enough officers here to clear whatever you need cleared." Great. Went back, met with the president at 8 o'clock. Explained to the president what was going on. We got a camp with about 15 people. And they're in violation of university policy. They're supposed to be in a designated free speech zone, but that's not where they are. They're quiet, but they're right outside the law school where those exams are going on. So the president said, "We'll keep an eye on it, and we might want to ask them to leave. Maybe we ask them to leave by sundown or something like that." So I walk out to University Yard, and I go to the putative leader of this group, a young man who's identified himself as such, and I said, "Okay, so the president says that you're supposed to be in the other location. You're not there. You're in violation of university policy. She's giving you until sundown. You guys should feel free to just take the tents down, put them up on the other location. No problem with the tents. Just you need to clear this particular area." Well, the student then gets on social media and sends out an all points bulletin to other students, colleges, and universities in the District of Columbia. Next thing I know, I hear that there are buses soon to arrive and a delegation marching from Georgetown to GW, which is about a couple miles apart. And what started as 15 kids quietly studying in tents soon became about 350 people. Some of them were our students, but many of them were not, with megaphones and drums and all sorts of things. Our GW police force was overwhelmed by the numbers. The Metropolitan Police Department was told to marshal their resources just in case. We don't know how big or bad this is going to get. We fenced in the yard so that we could maintain control of ingress and egress. And we began to, we requested that MPD mobilize. An hour and a half later, 90 minutes later, they had all of their cars lined up. They had all of the police officers ready to go. The president sent an announcement that we would be clearing the yard. And then the mayor of the District of Columbia said, "What are you talking about? No one talked to me about clearing the yard with Metropolitan police officers." So everybody's waiting for something to happen at sundown. The police officers are all there. You're all standing out there. The protesters have their megaphones and they're banging drums and they're disrupting the exams. Law students are coming out of the law school arguing with the protesters. "Why aren't you taking this elsewhere? You're ruining my college experience or my law school experience." And sundown comes and goes, and there's no police action. So now a second all points bulletin goes out. Send everybody. It's a party at GW. Another 350 people show up. They end up blocking the roads around the university yard. They take over the entirety of the university yard. Soon their Amazon deliveries coming with tents and food and blankets and bug spray and rat repellent. And the entire university yard is taken over within a couple of days. And I will say there were unique complexities in trying to negotiate de-escalation. What we found out was that the students that began the protest on our campus were not actually in control, and that there were professional organizers who were actually in control. Many of the students who were there early on had actually left, and at one point, I couldn't find a student among the protesters that were occupying university yard, which was private property. The police department had barricaded the public street that's adjacent and allowed the campus to spill over into that area. So this was really metastasized. And we began trying to negotiate with the mayor for some assistance. Eventually, we were contacted by the House Oversight Committee for the District of Columbia. This is the Republican House Oversight Committee. They wanted to know what we were doing with the encampment. We explained the situation to them. They subpoenaed the mayor to come testify in front of the House Oversight Committee. And on the evening before she was due to testify, the Metropolitan Police Department came and cleared the encampment.
Well, that's the end.
Wow. So there's a lot there I unpack, but I just sort of want to lay it out there because that's all a matter of public record.
Great, yes. So you did mention negotiating. I did get a question from the audience about, I think you're wondering whether universities should speak and engage. I think the question is if they should, I'm not sure, but sorry, it's hard to focus on lengthy questions while I'm up here. But I think that's the idea. We saw some discussion in the news about universities negotiating, not negotiating. What are your thoughts? And the whole panel, anyone jumping in on what is that a desirable thing?
I think different universities approach that differently. I was in conversation with the organizers initially. When it became something that had to be negotiated, my position was that I'm not negotiating. Ultimately, there's going to have to be someone else who negotiates. That's not the posture I wanted to adopt. That's not the posture that the president wanted to adopt. Again, it was complicated by the fact that while we were speaking to our students who were in university garden, trying to assist them in transitioning back into normal student life, the negotiations and the scripting for the negotiation was done by the professional organizers. So you were never having a direct conversation with whoever it is that was maintaining the campsite. Right? You were only having conversations I could have with students who were not actually making the decisions. So one of the things that happened that I thought was particularly interesting for us is that we got the campsite cleared. The Metropolitan Police came over and took over the situation. Subsequently, there was a question as to how do we deal with the academic disciplinary process. Those students who were arrested, was the university going to participate and support them in any way? And so there was a negotiation team that was created among that sort of student group, hoping to negotiate some sort of outcome that included fiscal transparency, all the other things, and amnesty, all the things that they wanted, but they didn't have the campus leverage. And so we had a conversation with some set of administrators that broke down, a subsequent conversation with another set of administrators that broke down, and that's sort of where we are now. We haven't actually negotiated, despite claims in the media that GW was negotiating. But I think the question of whether to negotiate is politically fraught. And there were some universities that were able to successfully negotiate and not take on a lot of political damage, particularly with trustees or donors. But we just weren't institutionally in a position to adopt a full negotiation posture.
Any thoughts from the other panelists about negotiations?
Christopher, my friend, Wow, that is a painful situation. I don't envy you at all. I think it's pretty simple, actually, and I believe most universities are adopting some posture along the lines of clear communication of the time, place, and manner, rules, consistent enforcement of those rules, no matter the cause or the people involved, not situational in nature, if at all possible. Allow plenty of room for free speech, support free speech, embrace free speech, absolutely essence of a higher education, to have those debates about controversial issues, but not disrupt the educational experience of all the other students on campus.
Professor Whittington, to follow up on the time, place, and manner regulation issue, we've seen a number of universities, it appears increasingly, passing, embracing more time, place, and manner restrictions. We had some discussion this morning's panel about them. Do you think that there's a risk that these time, place, and manner restrictions will unduly interfere with the free flow of ideas and expression on campus?
Oh, I think that's entirely possible. I think the flip side of thinking about the time, place, manner regulations. There you go. So the flip side of the time, place, manner regulations, I think, is on the one hand, you want to make sure that they are genuinely content and viewpoint neutral, that they are not being applied in ways, not designed to be applied in ways that are going to favor some kinds of expressive activities and some types of viewpoints and not others. On the other hand, a crucial feature of designing those things in the first place is you want to be providing ample opportunity for expressive activities on your campus. So you don't want to design them so they're so restricted people actually don't have good opportunities to express themselves. And you have to the justification for those things is that they are maintaining the educational functioning of the university, that they're avoiding disruptions. And you have to think carefully about whether or not the kinds of activities you're restricting really would have been disruptive. And so I think, and sometimes it's hard to capture, I think, in general rules. Certainly there's not going to be a one-size-fits-all across all kinds of campuses. But these kind of questions, for example, of are the protest activities immediately abutting the law school where they're doing exams, for example, is a very specific contextualized decision that I think is crucial in evaluating whether or not is this going to be a tolerable expressive activity or is this going to be a problem. And when it runs into that, then it highlights that we have to prevent the disruptions here. And so can you move this to a different part of the campus where you're not going to be so disruptive? And so in thinking about how you design these rules, you have to be extremely self-conscious about can we have rules that impose minimal restrictions that are necessary on these expressive activities consistent with maintaining everything else we need to do on campus. And I worry that some universities are going way beyond that. Instead, they are using this as an opportunity to become very restrictive of the express activities that occur on campus.
Another thing that came out of Provost Gracie's story about GW was congressional pressure. And I did receive a question about any reflections you might have on your experience before Congress.
Well, there's a lot to say. I mean, I think Congress has an interest in higher education for obvious reasons. The hearing itself that I experienced, along with others, was very long, and most people have seen 90 seconds of it, understandably, in the world we live in. We were all asked dozens of questions about donations to the university, transgender policies of the universities, centers that the universities had set up, specific questions about individual faculty members and their social media accounts and things like that, a really wide range of questions. And the question that the answers that became very well known were similar to the questions that were answered, questions that I was asked earlier, in which I did what I wish I had done in answering that question that became viral, which is to first show great empathy for how those calls on our campus would affect the community and individuals within the community. So several times early in the hearing, I expressed that in reaction to stories that people had told me about things that happened on college campuses, and it was a mistake not to do that. I don't think it reflects who I am. I am empathetic and could definitely understand and try to step in the shoes of someone who hears something like that on our campus, and that's what I wish I had done. So there's more to say, but that's a quick version of it.
I really, yes, we are, but I really do appreciate you answering that question. We have 3 minutes, I think. It's just a great segue to my final topic, which is what should academic leaders do for people who are or want to be provosts and presidents? I think this is a time when many people are saying they wouldn't go near those jobs with a 10-foot pole. Should they still consider these jobs? And if they do, what should they know in order to be successful? I'm going to go down the road here. I'll start with you, President Hans. Professor Whittington, you can offer whatever thoughts you have.
I would note I have a standing conflict with the congressional oversight panels, so I'll be unable to attend any. Please don't send me. In response to your question, Mary Rose, first of all, of course, if you always want to encourage good, smart people to go into higher education administrations. I think it's important. But be prepared if you take these jobs to lose them, and understand that you stand by your principles and your values, and I think always reflect that. And of course, we see that the lifespan of higher education leaders in the country is shortened considerably, generally 5 to 7 years, I think is presumed to be the current standard. Understand that your role is going to be small p, political and diplomatic. All these stakeholders, lots of cooks in the kitchen. That's the nature of leading any institution. People care strongly about it. I would like to think we could do a better job of making controversies more normal, if you will. We live in a noisy, fractious democratic republic. We're going to have controversial debates. If every public argument is addressed as a PR problem, that's going to be an issue. We've got to look at this as a more normal core part of what universities do, and hope that we can have a civil dialogue, and we can have informed debates, and they can be constructive, because there's a great deal of faculty expertise, there's a great deal of student passion to lend to those issues, and I hope they can become more normal, and as a result, more constructive.
I would say I have a great deal of appreciation and admiration for those when take on these positions, because it's critical that good people take these on. These are important positions of responsibility, and I'm just glad I'm not one of the people taking them on.
You know, when I first became an administrator, one of my colleagues told me, he says, you know, Chris, friends don't let friends become administrators. But I will say, I think higher education administration is an important role. I think that if you're serious about wanting to make a contribution, you're committed to the values inherent in education, higher education, and you're committed to the mission, the pursuit of truth and knowledge and the dissemination of knowledge, the development of future leaders to be able to take on the world's most important problems. If you're fundamentally committed to those things, you'll be okay in higher ed administration, because there are fellow travelers in higher education administration who believe the same thing, and they're working to do the same thing. And when you work together with folks like that, you can actually make a difference. So I think it's an exciting time. It's a challenging time to be a higher education administrator, but it's an exciting time because we need leadership like we've never needed it before. And this is the time for folks who are prepared to step up to really show that they have the ability to lead. But it's not for the faint of heart, I can tell you. It's not easy. And every day is not sunshine. But you do have your good days, and you get lots of great cocktail party stories.
I fundamentally agree with what President Hahn said and Provost Gracie, that if you believe in the missions of higher education, which are generating knowledge and transmitting that knowledge to students and the rest of the world, which I do, I think of as very noble missions. It's a very worthy endeavor to lead and advance those goals. I think they're essential in a very profound way. If you look at what knowledge production has done for the world in the last several hundred years, you could say case closed. This is a very worthy endeavor, and we need great leaders in higher education. So I encourage you to think about it. You make me almost want to become a university president. Well, we are out of time. Please join me in thanking this extraordinary panel.
So just quickly before we conclude, I just want to give some thank yous to those that helped support this. First and foremost, I want to thank our panelists for coming here. And I mean this as the editor-in-chief of the Law Review. Every time somebody said yes, like my day got brighter. And every time somebody said no or they had a conflict, my day just got a lot drearier. So thank you for all of the panelists who traveled far and wide to come support our symposium today. Also, I want to thank our sponsors, the Center for Media Law and Policy and the UNC Alumni Free Speech Alliance, as well as the UNC School of Law, Office of Advancement, IT assistants, those who helped us with the live stream, the Carolina Club who provided the catering for us, and also for all of my FALR executive board and staff. You all were key in making this a really wonderful event. I've been able to learn a lot. Just to briefly conclude, I want to just note that this event was a wonderful reminder of the innate human capacity that we have to discuss very, very difficult issues with challenging nuances that none of us are going to be able to solve individually on our own. But as scholars of the law, we do have this innate skill set and tool set to be able to dissect and dismantle an opposing side's argument. Now, while that does have some use in both a pedagogical sense and in a scholarship sense and then a professional sense, there, I think, is even greater utility in flipping those skills on their head and using those talents to understand, dismantle, and dissect an opposing argument to then figure out a way to internalize, to understand the viewpoints that we ourselves disagree with. Just as legal professionals are capable of tearing down others' beliefs, we are equally capable in understanding and lifting up another's beliefs and defending their First Amendment rights to speak and believe and protest or whatever way they seek to exercise those rights. So while there may not be a silver bullet today to fix all of these issues with academic freedom, with student speech and protest and institutional response, and as President McGill said, we're all going to be imperfect in the way that we respond to them. This event today has shown us all that we have that capability of listening to those whom we vehemently disagree with and finding ways to understand that they too have First Amendment rights and that we need to be capable of defending them. And just to conclude, I wanted to share a quote from Professor Collis's new book that he just released.
because I really think it sums up what we should take away from this event and given the difficult topics of student speech in the wake of Israel Palestine and plenty of other societal issues that will arise. As we get to know why people think the way that they do, we tend to feel less hate and more sympathy. We may not agree with what they say, but we will be slower to dismiss them, quicker to consider their words, and more forgiving of their behaviors that we may find distasteful. And I hope we take this theme with us as we strive to defend the First Amendment, not just for ourselves and the causes that we hold dear, but those who disagree with us, even if it may be to the detriment of our own internal morals and beliefs, in order to protect the delicate balance of the First Amendment. I'm going to turn the time over to Jack to just briefly conclude. Thank you all for your attendance today, and we hope to see you again next year.
First of all, thank you all for coming. If you are here for CLE credits, please make sure that you are signed in with the registration table before you leave. And with that, I'll close the symposium. Thanks so much for being here.
Yeah.